The defendants again present before the court with his counsel, Mr. Cochran, Mr. Blazier, Mr. Bailey, Mr. Ullman, people represented by Ms. Clark, Mr. Yokelson, Mr. Darden, Ms. Lewis. Also present is Mr. Haddon on behalf of Detective Purdy and Mr. Walsh regarding the city of Los Angeles. We'll take up the matter of the pitches motion first. I'll hear from the requesting party. Anybody wish to speak on behalf of discovery of the police records? I see we're wearing team ties these days.
Your Honor, we just received this, and I haven't had a chance to go through it, but in just skimming it, it's clear that the application here is that we should not be entitled to these materials because they are not within 5 years, which is the limitation of the Pitchess motion. And I would like to reiterate the position of the defense with respect to the materials. A, internal affairs investigations in this case involving Detective Purdy, Lucian Coleman, Detective Aronson, Detective Vitrano, any others that were involved in these incidents. We feel that based on the application, the showing we made, and the extended remarks that we made last Thursday, that we should be able to examine these materials and have access to them because we think they contain potential exculpatory evidence. And even if the statutory limitation on seeking these records, those are current records, internal affairs investigation that were within 5 years, even though they relate back to materials that are over 5 years old. So we think we're entitled to that. Number two, for those materials involving Detective Purdy and other law enforcement officials that relate to their contacts with Mark Furman, and what we have outlined as the exculpatory evidence that we're seeking in this case, even if these materials are over 5 years old, we believe under the United States Constitution and our right to exculpatory evidence, we are entitled to it, notwithstanding limitations set out in the statute. And I don't believe the statute was intended, passed, and explicitly does not purport to go beyond the defendant's constitutional rights to obtain exculpatory evidence. There is a long line of cases, as I indicated to the court before, starting with Davis versus Alaska and going all the way through where statutory privileges, in Davis versus Alaska was the right to obtain records that were sealed pursuant to a juvenile privilege statute, so to speak. Those give way when exculpatory materials are being sought. So we think we're entitled to that, notwithstanding this motion, and those are the grounds we're proceeding. Most particularly, and I don't know if the prosecution has obtained this information, we have particular interest in terms of Detective Purdy concerning that case where he apparently testified, according to what he told Prosecutor Coleman at a preliminary hearing, in one fashion, then was confronted with a police report that apparently was filled out by Mark Furman that was different than his recollections at the preliminary hearing, and then he subsequently testified in another fashion and was that conformed to the police report, and apparently there was discipline for it. And we're trying to track whether that case is also the same case that Detective Purdy told us about when we had a conversation with him last week, where he admitted that he had had a confrontation with Detective Furman around a particular case where the two of them had been paired as partners, and also that there were entries in the diary which he burned by his own admission, even after being informed that that diary was going to be sought and was being sought by law enforcement officials involved in this case and/or internal affairs officials, because it contained entries about his relationships with Detective Furman and misconduct by Detective Furman, that he intentionally destroyed that diary, he has admitted, after knowing that it was being sought. So that's the material we're interested in. We think we're entitled to it, notwithstanding the fact that at least one of these internal affairs investigations is over 5 years old and the information is over 5 years old. We also want to be clear that we're seeking not only the records that are stored downtown, but the ones that are stored at the division, because we think all those are related. And of course, we're seeking the information with respect to the swastika incident as well.
All right, I'll hear from the counsel for the detective, Mr. Haddon.
Your Honor, Davis versus Alaska does not stand for the proposition that the defense is entitled to the entirety of someone's file just because they claim there might be some exculpatory information in there. As this court noted last week, Brady is very much a consideration in the statutory scheme that's embodied in the PITCHA statutes. The PITCHA statutes have, as I noted in my brief, withstood constitutional scrutiny in this state. Particularly, I am amazed at the comment by Mr. Scheck regarding what exactly it is that he's seeking. He's saying he's asking for something relating to Ms. Coleman's declaration today, but their brief instead asks for citizen complaints against Detective Purdy from 1986, discussing bias, prejudice, ethnicity, etc., and falsification of records, neither of which have anything to do with the matter for which Mr. Simpson is on trial here. Mr. Scheck noted that there is a statute that precludes discovery of matters that are over 5 years old. He ignored the fact that 1047 of the Evidence Code says that the records of an officer who is not involved in the arrest are per se not discoverable. It's as simple as that. The legislature was very clear on it. And the court, California Supreme Court, in the Santa Cruz case, which I cited in my brief, described this statutory scheme as a model of clarity, that the legislature said what it meant when it wrote it, and the courts should apply it accordingly. The defense has first of all, provided no reasonable cause for the court to even look at at Detective Purdy's personnel file. Even if the court were to do so, it would be excluded. What the defense is, I think, seeking is excluded under 1045 of the Evidence Code under the protective provisions there. And 1047 is an absolute bar in this case for the defense to get any materials from Detective Purdy's file. Thank you.
I'll hear from this representative from the City of Los Angeles.
Good morning, Your Honor. David Hotchkiss, Assistant City Attorney on behalf of the Custodian of Records of the LAPD. I would only add, Your Honor, a couple of points to underscore the legislative scheme that we're dealing with here, and that is that the legislature, on behalf of the people, has made certain legal conclusions that are binding upon this court, and one that is paramount is that the 5-year rule seems to control under these circumstances. They have ruled, they have determined as a matter of law that anything that is beyond 5 years from the date of the event or transaction which is at issue, which is the murders of June 1994. They're asking for events that preceded that by 7 years. And those are excluded by operation of law. Moreover, I wanted to underscore a point that Mr. Haddon made, and that is that there is absolutely nothing tying Detective Purdy to the investigation, the arrest, the booking, or anything involved in this particular case. However, if the court finds that there has been a prima facie showing under 1043, we are prepared this morning to deal with an in-camera at the court's discretion.
All right. Mr. Scheck, do you want to address the language in 1047, please?
This is the language indicating that since he's not involved in the case, there's a per se bar?
Yes.
All right. The response, well, he is involved in the case insofar he was interviewed by Internal Affairs with respect to his connection to Detective Furman in this case. And really everything that we're seeking here flows from the fact that we think that if we have these materials we have reason to believe were brought up in the internal affairs investigation in this case. The reason we have reason to believe it is that we were told this by Prosecutor Coleman. And we have to assume that Internal Affairs took note of that, and they should have questioned Detective Purdy on this. If they haven't, they should go back and question him now, because we can't be clearer. We believe that there's a basis for pursuing the fact that Detective Purdy has information showing that Mark Furman has falsified police reports, et cetera.
Why don't you address your remarks to 1047?
Well, I find these arguments completely non-responsive to the point we're making. The fact that he is not...
There's a discovery scheme
Yes.
for the specific records that you're seeking. There's a specific statutory provision that has puts certain limitations on this discovery procedure. Mr. Haddon raises 1047 as a complete and absolute bar to the information you're seeking. Do you want to address that, or do you want to just ignore it?
Oh, I'm not ignoring it. I think he misstates Davis versus Alaska and all the cases that flow from that, including recent cases concerning statutory protections in, I believe, the state of Pennsylvania. There's a whole series of cases. This is fundamental constitutional law. I thoroughly agree that if you read this statute literally and say we are not entitled to get evidence that Detective Purdy has apparently given before Internal Affairs and find out the results of this investigation, which could bring to light exculpatory evidence concerning Mark Furman's falsification of evidence, and get to the bottom of what Detective Purdy really knows about Mark Furman and his racial attitudes as well, but most particularly the falsification of evidence issue. If this statute is read as an absolute bar to getting this information, it's unconstitutional as applied. We have a constitutional right to exculpatory evidence. If they want to say that these materials can't be reviewed by this court for purposes of seeing whether or not it provides exculpatory evidence based on an internal affairs investigation that apparently has been ongoing with respect to this case within the 5-year limit, and concerning officers involved in this case, if that's the way the statute is being read to bar this court from exploring the exculpatory evidence, it's unconstitutional as applied. It violates due process and the rights to confrontation. Those statutory privileges are not absolute. It is not a per se rule in light of the constitutional protections we have. It is qualified.
Right. Do you have any case authority dealing with any similar statute, this statute or any similar statute that supports that position?
There are, if the court wants more, I thought this was a black letter proposition. Davis versus Alaska is a case that I think is close to 30 years old, but it is the first in a long line of cases which establishes a fundamental constitutional principle. Do I have a case right now dealing with pitches?
No.
That's directly on point?
Any case where the theory of Davis versus Alaska is applied to a discovery statute that is anywhere similar to this, anywhere in the United States. Do you have anything you can analogize from? Because there's no case in California that says this.
Well, the court is familiar with Davis, the Davis case? I do not have at my fingertips right now those cases. I can represent to the court, I can recall off the top of my head many. I didn't even believe that this point would be in controversy. I can recall, I know a Supreme Court precedent that I can give to you.
You've got a statutory scheme that says you can't do it. You need to have some authority to ask me to completely ignore a statutory scheme, wouldn't you say?
Well, Davis versus Alaska is the first in a long line of cases. That case and all the other cases that I will bring to the court's attention tomorrow all start from this proposition. In Davis versus Alaska, there was an effort to confront a witness on the stand,
I recollect.
and there was a statutory scheme that created a privilege that those records could not be discovered.
I recollect.
There's a long line of cases in this regard. This is a very simple issue. This is a due process Brady issue. If you're asking me for a case directly on point, no, that is not correct. The answer is, I was given this brief this morning. If you want more authority for what I consider an absolutely fundamental constitutional proposition that has not been addressed by these others, all they're getting up and saying to you is something that you already knew, which is, on the face of it,
All right, well, let's
these
not,
are statutory
let's not
bars.
waste any more time.
I won't waste any more of your time, Your Honor. If you want
No,
more cases,
counsel.
I will submit them.
Counsel, you requested the order shortening time for the hearing on this, and if you're not prepared, I'll give you till tomorrow morning to file.
Thank you, Your Honor.
I'll place Mr. Hotchkiss, the custodian of records, is placed on call for tomorrow within 1 hour.
One
All
further
right, file
application,
it, close of business today.
just so the court should note. If it is to be the ruling that these statutory bars prevent us from getting the records that are over 5 years old and prevent them from getting other records, we would want to call the detective to the stand to establish at a hearing outside the presence of the jury the underlying facts.
Thank you.
In giving counsel until tomorrow to file, Your Honor, the court is indicating then that the people will not be able to present any witnesses before the jury today.
Nope. That's not what I'm indicating. All right, other matter we have is the scope of the scope of people's rebuttal case. That was the issue we had set today. Also, counsel, I have conducted the 1054.7 as to Dr. DeForest notes, Mr. Neufeld. And the issue that I raised with Mr. Hodgman, he did not understand what Dr. DeForest, I asked him a question about the notation in Dr. DeForest's notes. He was not able to interpret that for me. So I directed him to immediately call Dr. DeForest to get an explanation of what this note means, or what he is addressing. So as soon as I get that information, I'll conclude the 1054.7 as to Dr. DeForest's notes. All right. Scope of prosecution rebuttal case.
Sorry, just before we get to that, the court, I think it would be more logical if the court pleases for the court to entertain Dean Ullman and the defense's motion to strike and request remedies for denial of constitutional rights of confrontation and cross-examination. I'd ask the court to consider hearing that first. Dean Ullman will helm that, and then Mr. Blazer will helm the other motion with regard to scope of the rebuttal.
All right.
You just got this brief, what, 15 minutes ago? No advance notice. We had no advance notice that we were going to file it. We've just seen it. We have at least a chance to read it. Perhaps you'd like to file a responsive brief. Ms. Lewis just had the cases brought down. They're on her lap right now.
Mm-hmm. And what is the practical import of your request?
Proceed with other motions first.
All right, you're prepared on the scope issue?
Yes, and we filed briefs on that.
All right.
I should mention, we filed this morning an additional brief. We filed a brief last Friday with regard to admitting glove evidence. This morning, I filed an additional brief on our behalf with regard to admitting the rarity of the Bronco fiber carpeting that the court had excluded from our case in chief.
All right. Mr. Blazer. Scope regarding the gloves.
Good morning, Your Honor.
Good morning, counsel.
It was my understanding that the prosecution was supposed to also file some document stating when they received various pictures, and I haven't seen anything that has that information. I did prepare a chart for my own use, but I'd be happy to provide it to the court and to counsel.
Thank you.
And in that chart, I attempted to list all of the various pictures and videos and correlate them to the games that were involved. And as you can see, there are 9 different football games where they have stills or videos. And I've indicated for those reports which state when they got the pictures, I put those dates on there, or when they did their first interview. And as you can see, many of them are before they rested. Now, the ones that don't have any date, I don't know what the date of receipt is because they didn't put that in their reports. But as you can see, for most of the games, they had pictures long before, or well before they rested in time to put those on. And I would also point out, this is an additional argument that should this evidence be allowed, we would argue that much of it is cumulative and irrelevant, particularly since most of these games, or most of these individual photographers, involve pictures where Mr. Simpson is wearing black gloves, not brown gloves. But I don't want to jump ahead. In response to the people's brief, as I understand their argument, they're saying that because we have put on a defense that evidence may have been fabricated or there may be some sort of skullduggery involved with the evidence, that therefore opens up the glove question when we didn't put on any evidence about the glove question. And I think that argument is very easy to destroy. What that in essence would mean is that any time you put on a defense, well, that opens up the prosecution. They can put on anything that they held back on just because we put on a defense. I would cite one of their cases that they have in their brief. That they cited for a different proposition. This is the Carter case and the Contreras case, which says that restrictions on the introduction of rebuttal evidence were created to prevent the tactic of withholding crucial evidence from presentation during the case in chief in order to take advantage of the drama and surprise inherent in confronting the defendant for the first time at the end of the trial. Now, this evidence was readily available to them. I believe they even took a day at the end of their case because they were considering whether to put it on or not. I've been told just this morning that they've subpoenaed, what Mr. Yokelson told me was a ton of videotapes, additional videotapes that they presumably intend to use. I don't know how much a ton is, but I suspect it's probably a lot. And I don't know whether there's any new games involved, anything other than what they've already listed. And I would argue that they knew about these pictures before. They knew about each of these games. If they wanted to subpoena the videotapes from those games, they could have done it then. They've got still photos from then. Mr. Rubin was here, I think, 2 or 3 times. It's my understanding that he is their expert, and he's going to testify that he's looked at these pictures and he sees some similar characteristics. All of that was available before. They could have put that on in their case in chief. They chose not to. We maintain that the reason they chose not to is because they were sandbagging and holding back information that they thought they would put on at the end for dramatic effect. We have opened up nothing that allows this kind of evidence. We specifically did not put on some of our evidence because of that. That was stated to the court. And as the court might recall, at one point when we were talking about our glove experiment, you made the comment that that may open the door to these pictures. Partially because of that comment, we did not put that evidence on. If they put, and they have, I think, 14 or 15 witnesses that they intend to call on this, if they put these people on, then we will be compelled to call back Mr. McDonald and perhaps some other evidence that we have of another experiment that we've turned over to the prosecution, and perhaps other evidence from other glove experts. It's going to prolong the trial substantially. They could have done this before. We submit that they should not be permitted at this point to sandbag and introduce this evidence now when they had it perfectly available to them before they closed.
Mrs. Robertson, what is the defendant's next exhibit? All right, Mr. Blazer, I'm going to mark your chart as defense 1370 for the purpose
Thank you,
of
Your
this
Honor.
motion.
And I might indicate also that I've indicated black or brown where you can determine what color the gloves are in the photographs or videos. And you can also see that many of these people are multiple witnesses on the same set of photographs.
All right, I'll hear from the people.
First, Your Honor, I urge the court not to rely on this chronology provided by Mr. Blazer. I know for a fact, just looking at it right now, that one is absolutely wrong. Ms. Guidera has the date of July 7th on her letter. but the actual thing did not arrive to us until a month later. I know because I saw when it arrived, and when the envelope was opened. It wasn't until early August that we saw that. So, and she may indicate to you why it took so long to get to us, but she may have indicated on her letter she
Yeah.
intended to.
Just out of curiosity, why would that be?
Why she delayed? I don't know.
In other words, she's going to say that it...
I don't know what she's going to say, Your Honor. I know when we got it. That's all I can tell the court. I know that there was a date. I saw her letter. The letter had her handwritten date of July 7th on it. The postmark was not until, I think, July 30th or something like that, and we got it in the first week of August. So we didn't get it till a month after she had the letter dated. So this is not accurate. That's number one. Number two, there was no effort to sandbag. Obviously, the defense knew about these photographs. That's why they chose not to have McDonald testify to the glove drying evidence. Now, the fact that they indicate that they're withdrawing that glove drying experiment in order to avoid cross-examination with the use of these glove photographs does not mean that we don't get to use them in any case in rebuttal. That has nothing to do with anything. It's apples and oranges. That just means we couldn't use them on cross-examination. At this point, Your Honor, there is no sandbagging. That's clear. The defense knew that these photographs were in existence. We also did not, we cannot be in a position to present such evidence until we have verified its authenticity. That means we've got to get the negatives, we have to interview the photographer, we have to examine the photographs and compare them to the negatives and the prints that we prepare to make sure that there's nothing wrong with them, that they are as represented, as they've been represented to be. Authentic photographs of the defendant in these gloves. After that, we have to be able to show them to the expert who will tell us whether or not it indicates what we think it does. I mean, this is not something where you get a photograph and slap, put the witness on the witness stand. That would be very cavalier, and it would not be an appropriate practice for the prosecution to do. We have to check this evidence out. We have to make sure it's proper before it comes before the court and before the jury. So the fact that they come into our hands at a given point means nothing in and of itself. If the court can tell, even looking at the dates and they're not correct, it was very late in the case that we got these things, because we put on the glove evidence that we had late in the Peoples case. By the time we rested, and I think it was in the first week of July, many of these photographs had not yet been received. Of those that had been received, they had not been checked out. The negatives had not been received. The fact that people sent us photographs didn't end the inquiry. We then had to recontact these people, get the negatives in, examine the negatives, have our own prints made, and interview these people. And then have everything examined by an expert, by which time the people had to rest. Yes, we could have done as the defense does and asked for a week to go and prepare and get things together and have the jury cool their heels outside, but we elected not to do that for the obvious reason, believing that if it was necessary, if the defense went a certain way, as it did, it would be a proper rebuttal. As a matter of fact, our predictions proved to be true, more true than we could have imagined, because it was after we rested that we all found out about the McKinney tapes. Now, as the court knows, the defense has shifted its primary focus of its defense, based on those tapes, to Mark Fuhrman. This has now become a full-out attack on the credibility of Mark Fuhrman to prove that he did what we know the evidence has proven he could not do. Reality is not important to the defense. They're going to go ahead and try and prove it anyway, get the jury to ignore the evidence, and let them think that Mark Fuhrman could have planted evidence that wasn't there.
All right, Ms.
Nevertheless,
Clark, what the court is most interested in this situation, however, is the chronology of the people becoming aware of the existence of the information, the subsequent contacting of the individuals volunteering this information, what interviewing was done, what corroboration was done, the nature of the investigation, production of the evidence, and the time frames during which all of this occurred. That's what I'm most interested in.
okay, I don't have that information, Your
The
Honor,
issue
because
being whether or not this information in the form it's to be presented at this point was available to the people prior to the people resting.
well, let me ask the court something then. Why is that even a relevant inquiry at this point? Because, and I'll ask leave of the court to allow Mr. Hodgman to address the issue because he was the one who received it. Assume for a moment that we got it all during our case in chief. Okay, first of all, the court knows that the defense knew about it. That's not sandbagging. Second of all, more importantly, this is appropriate, if this is appropriate rebuttal and the people submit it clearly is, based on the attack on credibility of Mark Furman and the allegations that the defense is making about planting of evidence, then what does it matter when we received it if it's proper rebuttal?
I stated my inquiry.
Okay, what the people are indicating to the court is this, that even should the court find that we received it soon enough to put on in the people's case in chief, which we didn't, but even should the court so find, the people submit that it is clearly a proper rebuttal based on the nature of the defense case and the change that it took after the McKinney tapes were discovered. And that was clearly after the people rested that was discovered. Let me also indicate something else to the court. I have at this point interviewed these witnesses. I can tell this court that it's very brief testimony, extremely brief, as will be Richard Rubin's. I don't think that the cumulative amount of testimony given all of these witnesses and Richard Rubin is going to exceed 3 hours, max. It's very brief, and I don't know how the defense can try and drag it out to be more than that. Did you take this picture? Where did you take it? What did you see? When was it? End. That's all we're talking about here. Okay, and Mr. Yockelson has a chronology, and he will present that to the court.
All right, thank you. Mr. Hodgman, you have Mr. Yockelson.
Ed, good morning, Your Honor. This will be sort of a bifurcated response to the court's inquiry about chronology. I have information with regard to the still photos. Mr. Yockelson has information with regard to video clips or videotapes that were obtained.
All right. Mr. Hodgman.
And, Your Honor, in response to the court's inquiry of last Friday, over the weekend, we tried to put together a chronology so that the court would have some understanding of when these photos were received. With regard to photographer James Chegia, Chegia, we received a photo on or about June 20th, 1995. On that date, one of our investigators obtained a negative, and some prints were made. Color copies were given to the defense on September 1st.
All right, negatives were obtained on June 20.
Yep, no photo, actually, just a negative. On June 22nd, 1995, a photographer named Bill Rankin, R-E-N-K-E-N, sent us a single enlarged photo.
That was on what date?
June 22nd, 1995. Subsequent to the receipt of that photo, there were a number of phone calls involving Mr. Yockelson and Mr. Rankin in an effort to attempt to obtain the negative, and in the course of those conversations and during, as I will relate in just a moment, into July and August, additional photographs were obtained from Mr. Rankin. On June the 22nd, or shortly thereafter, we had obtained a single 2 by 3 foot enlargement which was shown to the defense. And so the court is aware, we did not receive negatives from Mr. Rankin. The first time that people received negatives from Mr. Rankin was this morning. And to be even more specific about it, Mr. Rankin retains the negatives in his possession right now. The people do not have possession of them. a photographer named Rob Seib, S-E-I-B, sent us a photograph on June 27th, 1995. We received it sometime after that.
Excuse me just a second, Mrs. Robertson. Go ahead.
And with regard to that, Mr. Seib sent us the photograph from a location on the East Coast. On June 28, 1995, Mr. Rankin sent us some additional photographs. These photographs were of the same football game dated January the 6th, 1991. On June 29th, 1995, or thereabouts, we received a photograph, actually a number of photographs from a photographer named Kevin Schott, last name S-C-H-O-T-T. We received negatives from Mr. Schott on September 10th, 1995, yesterday. Previously, on September 1st of this year, color copies of what we had were turned over to the defense. On July 1st, 1995, we received a photograph from Michael Romano. A color copy of this photo was turned over to the defense on September 1st, 1995. On September 6th, negatives were made available to the defense so that they could obtain a print to whatever size, enlargement they wished. Then we have a photograph from Mark Kruger, K-R-U-E-G-E-R. This was received sometime prior to July the 3rd, 1995. Our records don't indicate a precise date that we received this photograph. We can infer, however, that it was received prior to July 3rd, 1995.
And we know that because Mr. Kruger was interviewed July 3rd, correct?
He was interviewed on September 1st, Your Honor, and on that date he stated that he still had the negative. A color copy of what we had was provided to the defense on September 1st, 1995. On July the 3rd, 1995, Deputy District Attorney Alan Yokelson sent a letter to Mr. Richard Rubin containing some copies or prints of what we had available regarding the photos to see whether Mr. Rubin could shed any light with regard to these gloves depicted in the photos. By letter on July 6, 1995, Mr. Rubin made some preliminary observations with regard to the gloves we had sent him, the glove photos. As far as our date of the receipt of the letter, it was sent regular mail. And Mr. Rubin's letter is dated July the 6th. The date we received it, we can only infer was after July 6th. photos continued to come in after the date of July the 6th. On July 27th, 1995, we received a photograph from Karen Brown. On September 1st, 1995, color copies were turned over to the defense, and that photo was reproduced from a negative on September 8th and turned over to the defense. On August 11th, 1995, Bill Rankin sent 2 more photos of the same game of which we had received photographs earlier. These were 2 8x12 photos. As of August the 11th, we still did not have negatives from Mr. Rankin. On August 17th, 1995, Mr. Rankin sent us an additional photo of the same game. We still did not have negatives of what Mr. Rankin had sent us. We did, in the latter part of August, make an effort to obtain a CD copy, that is to have the photos that he had sent us placed in a CD format so that that CD could be shared with the defense. On August 26th, 1995, Deborah Guidera, Guidera, provided us with a photograph. It had been mailed sometime prior to August 26, 1995. She indicated that she thought she had mailed it to us sometime in July. The people received the negatives regarding this photograph on September 1st, 1995. Color copies and copies made from the negative were available to the defense on September 6th. And lastly, Your Honor, we have a photographer named Stuart West, and he has a photograph of a December 25th, 1993 game. And we simply do not have a record of when we received that photo from Mr. West. We do know that on September 1st, 1995, color copies were turned over to the defense. On September 6th, negatives were made available to the defense for copying. And then as the court may not recall, on August the 29th, there was a telephonic interview with Mr. Rubin in Las Vegas. During this interview, Mr. Rubin made further conclusions regarding various photos and video clips. There became a need to have Mr. Rubin present in Los Angeles in order to get a more definitive opinion. And on or about August 31st, if I recall correctly, Mr. Rubin came to Los Angeles and viewed photographs as well as video clips. And notes of that meeting were provided to the defense.
All right, you've indicated to the court that Mr. Yokelson sent a letter to Mr. Rubin, who I take it is going to be your sole expert as to the identity of these gloves. Is that correct?
That's correct.
On July 3rd.
Correct.
That Mr. Rubin sent a response back dated July the 6th, however, sent United States Mail, U.S. Postal Service, and he is back east, if I recollect, so we can assume 2 or 3 days mail time.
Okay. And to be entirely accurate, Mr. Yokelson informs me the letter was FedExed, so I think we can presume that the letter was received July the 7th, or thereabouts.
And do you have a copy of that letter?
I don't have that with I don't have that letter with me, Your Honor, but we do have it.
All right, let's assume that this was a report from Mr. Rubin regarding his examination of these photos that Mr. Yokelson sent him.
Well, it was a preliminary report in the sense we wanted to get some idea of what we had. And Mr. Rubin responded that, this is with regard to certain style characteristics. And through the course of further investigation, we realized we had to refine even more what style characteristics we were looking for and we made investigative efforts to see if photographs could be enhanced to further indicate those style characteristics.
All right,
And
and
as
what
the
was
court
your-
is aware,
What was your next contact with Mr. Rubin after his letter of July 6th?
Your Honor, the next contact I'm aware of was on or about August 29th when Mr. Rubin was in Las Vegas. And we had an interview done by telephone in which Mr. Yokelson and an investigator participated. It was realized that we need to have Mr. Rubin here to be more definitive, and arrangements were made to fly him from Las Vegas to Los Angeles.
And did he then come and sit down and physically look at all these photographs and view the videotapes?
Yes.
Did he give a report, or was he interviewed at that time?
He was interviewed, a report was made, an investigator from our office was present, as well as various attorney personnel.
All right, and what's the conclusion that Mr. Rubin has come to that you wish to offer?
Well, Mr. Rubin is prepared to testify with regard to various still photographs and video clips, that there are style characteristics present in the gloves that he observes depicted in these various stills and video clips, which are identical to the Eris light style of glove, which comprise the crime scene gloves.
Consistent with, not definitive.
Well, his opinion is a little stronger than that, Your Honor. He is a better expert than I with regard to the gloves. However, there are a number of unique style characteristics which apply to this particular style of glove. These unique style characteristics are present in various of the still photos and video clips which we intend to present.
All right. Mr. Yokelson, tell me about the chronology of the video clips.
Before Mr. Yokelson addresses the court, may I interject this? I spoke to Mr. Rubin around 7:30 or 8 o'clock last night. We were looking at photographs and some of the videotape, and there appeared to be some type of defect in one of the gloves the defendant was wearing during one of the football games. So Mr. Rubin asked that he be allowed to look at the crime scene gloves again to see if that defect is also on the crime scene gloves. Just to keep you up to date.
All right, I'm sorry, let me just ask Mr. Hodgman one last question. The first photograph that you had available was from Miss Chagia, and that was on June 20th, correct?
Yes, Your Honor.
All right, Mr. Yokelson.
Yes, Your Honor.
Tell me the chronology of the videotapes.
Your Honor, following the arrival of some of these still photographs, we began investigating the possibility that there might be videotaped evidence of some of these games wherein the defendant was wearing these types of gloves.
When did you start this investigation?
This was approximately the 20th of June, 1995, when we received a telephone call from some personnel at a local network. They provided us with some videotape, which actually we do not intend to offer in this case. However, on June 23rd, 1995, we issued 6 subpoenas, 3 of which are relevant to this inquiry. These are for 3 games. One was dated January 6, 1991, between Cincinnati Bengals and the Houston Oilers. The second subpoena, issued June 23rd, 1995, was for videotape of a game between the Buffalo Bills and the Kansas City Chiefs, dated or played on January 5th, 1992. And the third is a game played on January 23rd, 1994, also between Buffalo and Kansas City. Those subpoenas were issued on the 23rd. Their return dates were for the 26th of June, 1995. And we received the actual videotape from NBC on or about the 28th of June, 1995. Based on the evidence of the still photograph, which Mr. Hodgman referred to from Ms. Guidera, Deborah Guidera, we have also issued a subpoena for a game played in 1993 between the Indianapolis Colts and the New York Giants. That subpoena is returnable today, and I have not yet heard from NBC. I would also add parenthetically that NBC wishes to be heard on some of these issues, and Ms. Edgerton from NBC will be here shortly.
All right, that's the record you wish to rest on.
I would also indicate that the copies of the videotape that we intend to offer into evidence was provided to the defense on or about September 1, 1995.
All right, and which of these videotapes do you intend on offering?
The 3 games that I've just referred to.
January 6, 91, January 5th, 92, January 23rd, 94.
Yes. And there is a possibility of some more videotape if it arrives. It has not yet arrived.
All right, so just so we're clear, you've had these videotapes since June 26th, correct?
June 28th. I
28th.
believe.
All right.
Very interesting, Your Honor. I mean,
Excuse me, Your Honor, and excuse me, Mr. Blazier. However, Richard Rubin did not get to see these videotapes until much later.
Why not?
Because we had to arrange to send this material to him after the 28th of June. And it's my recollection that he did not see these videotapes. It's my belief he did not see these videotapes until after the People's case ended.
When did he actually see these materials?
He saw the actual 3/4-inch videotape when we had him here in Los Angeles last week at the end of August, 1995, in the meeting that Mr. Hodgman referred to.
All right. Mr. Blazier.
it seems that everything on the list of things they got before they arrested, with the possible exception of Guidera, and their letter to the court says that the letter was dated July 7th. I don't know what day they got it, but I can tell you that the Guidera picture, Mr. Rubin has never said, at least not in the interviews that I've been provided, that he can identify the glove in that particular picture. The primary pictures that he has said in his interview that he thinks look like Eris lights are from the Renkin pictures, and that's the Bengals game from January 6th of 1991, which they received the first picture on June 22nd, 3 weeks before they arrested. Mr. Renkin is a professional photographer. He's got a big stamp on the back. They know exactly where he was. They knew about that. It's no secret that Mr. Simpson is a commentator on television. They know about that. They knew about these pictures. They could have gotten these videotapes. They did get the videotapes, but they chose not to present them then. And the reason they chose not to present them then is because they wanted to hold something back for a big dramatic finish. I think the dates that you've provided demonstrates exactly what I'm arguing. They've had this. They could have developed this. The fact that they waited to interview people is not our problem. It's not the court's problem. They should have done that. They have the people to do the investigation, and it's not fair for them to just get this stuff and say, well, we can't get to it now. We'll get to it later, and then we can put it on in rebuttal. I submit they should not be allowed to present any of this evidence at this time.
Now, let me indicate to the court that Mr. Google saw the Guidera photograph on August 28th.
Excuse me. And incidentally, I've never seen these Rubin letters. I didn't know that they sent stuff to him before they arrested and that they got a letter back. I've never seen those. Now, I'm not saying we didn't get them, but I've never seen them, and I'd like to see them.
I want to clarify that issue regarding Mr. Rubin's letters of dated June 6th. July 6th.
Mr. Yokelson was speaking to me, and I didn't hear what Mr. said.
I don't,
Has that letter from Mr. Rubin dated July 6th been turned over?
As I understand it, Your Honor, the letter that we're speaking of was not turned over to the defense because it was not a definitive letter. All that happened was preliminary finding was made. We saw a few photographs and he said, looks like there may be some style characteristics here. I've got to see more. I've got to see it more clearly. And so we endeavored at that point, and by this time it must have been at least July 7th, to start getting the things to him in his hand and get him out here and have further contact. There was no final report or finding made by him until...
Don't you think that's something the defense is entitled to know, that your expert witness looked at these items and wasn't able to give a definitive opinion?
If we decide, well, not, yes, at the point that we want to put them on, that's true. However, don't forget, Your Honor, that we already had the colloquy during McDonald's testimony about blood photographs, and we went to sidebar, and I informed counsel that we had a preliminary indication at that time that they may have been the same blood. That's what I believe I indicated to him the finding of Richard Rubin at that time. I don't know, that was in August, wasn't it?
My recollection is that your impression of Mr. Rubin's opinion was a little more definitive than that.
these are the gloves, that's what she said.
But that was much later. That was way after July 6th. And there was a lot...
All right, well, my question is, don't you think the defense was entitled to a report or a letter from Mr. Rubin indicating that based upon his analysis of the materials that were submitted to him, that he was not able to come up with a definitive answer? Don't you think they're entitled to that?
Yes, I certainly do. If we thought that we were going to present it in our case in chief, they were entitled to it. We didn't even get it until after we rested, so I don't understand.
Okay.
Well, the question is, now you propose to put on this evidence, yet you still haven't turned this over. Is that correct?
The preliminary letter, no, we have not. The actual report and findings of Richard Rubin, yes, we have. But we don't have an obligation to turn over that letter, which is a preliminary finding, until we know that we're going to put it on in our rebuttal case. Now, we didn't have the letter till after we rested, so we obviously couldn't put it in at the time in our case in chief. We didn't know where the defense case was going to go till after we got it. Then, when we did get it, Your Honor, and we started to indicate that we wanted to put this on in rebuttal, it was in response to, well, I've already indicated the legal argument in response to rebuttal and why it's relevant rebuttal. But we gave them the final report by Richard Rubin.
And when was that turned over?
I think September 1st.
August 31st, we had our final interview with Richard Rubin, in which he reviewed all the photographs, reviewed all the videos, and gave us his final opinion on the gloves. We turned it over on September 1st.
Now, as I understand it, I think we called our first witness on July 10th. Now, is Ms. Clark saying that on July 7th, the 20th, the 12th, that when she got this letter on the 7th, they're already planning their rebuttal case? I think that's very telling.
No, Your Honor.
That's what she said.
We didn't have it in time for our case in chief, and we had to consider whether it was something that we could put on in rebuttal. We didn't have it in time to put on. So how can we consider putting on in our case in chief? I don't get it. We don't know. How can we say we're going to map this out and put it in?
All right.
Incidentally, Mr. Rubin was out here testifying on the 25th. They had a number of these pictures then. We're not entitled to their attorney's notes. I don't know how many conversations they had that weren't in writing about these gloves and what he can tell and what he can't tell. But there's a lot more going on here before they arrested than we're being told, I believe. This is just unfair.
You know something, I'll tell you what's
All right.
unfair, Your Honor. It's unfair to be attacked unfairly with no indication that anything underhanded occurred. The court has been given a full chronology of what happened. We had the letter from Richard Rubin that has a date on it from the East Coast, and that's the date he rested. I mean, it should be very clear to everyone what happened here. And now we're supposed to be prescient. We're supposed to know what Richard Rubin's going to say when he gives his final opinion. When all we have in our hand at the time that we rested the preliminary finding, when he hadn't even seen all the photographs we got, he hadn't even seen the videotapes at all.
The point is they had them, and they had access to Mr. Rubin.
We cannot be everywhere at the same time, Your Honor. And Mr. Rubin doesn't live here. He's on the East Coast.
Refresh my recollection as to where he lives now.
I'm sorry.
New Jersey, I think.
All right. Well, another interesting issue.
You know, I believe this clerk just said that she didn't know until late in August of this final determination, but that was long after she made representations at sidebar that they could now prove these are the gloves.
All right. Thank you, counsel.
My representation is
Counsel,
apart.
counsel, I've heard the argument. I'm preparing to rule. Thank you. All right, the order in which evidence is presented at trial is governed by Penal Code Section 1093, and specifically that code section says that the district attorney shall offer evidence in support of the charge. In subsection D, 1093 reads that the parties may then respectively offer rebutting testimony only unless the court for good cause, for good reason, in furtherance of justice, permit them to offer evidence upon their original case. And I think that the case law in dealing with whether or not the court can allow the prosecution to reopen their case indicates that the court has wide discretion. However, there are several cases that deal with an abuse of that discretion. This is a situation where information regarding the defendant's possession and wearing of these gloves was available to the prosecution at a period in time prior to their arresting their case. The prosecution arrested their case on July the 6th, 1995, and the court believes from the chronology presented by the prosecution that the first photographs regarding Mr. Simpson wearing gloves that may or may not be these Aeroslite gloves were received by them on June the 20th. Court is also persuaded by the representations of counsel that the information from Mr. Rubin was reasonably not presented to them prior to the arresting on July the 6th. the photographs submitted to the prosecution by various persons prior to their resting their case are not usable or not meaningful without expert testimony and analysis. That expert testimony analysis coming from Mr. Rubin. Court therefore finds that since Mr. Rubin did not submit his findings in either preliminary or final form prior to the people's resting their case, that this information was not available to the prosecution during their case in chief. And I will exercise my discretion and allow a limited number of these photographs to be offered. I agree with Mr. Blazier's observations that it appears that some of these may be cumulative. I'm going to ask that the prosecution present their photos to the court and let's see what we have, because I'm not interested in listening to 20 people testify about taking photographs. All right, that's the ruling on that, preliminarily. All right, let's go to the other argument. I'm sorry.
We'd also like to see the letters.
Absolutely, forthwith. All right, let's go to the issue of, Ms. Clark, have you had the opportunity to peruse the motion filed by the defense or Ms. Lewis? Motion to strike the testimony of Detective Furman or alternative remedies?
I've been before the court, so obviously I read it. Ms. Lewis has been doing some reading. We need the cases have been pulled. And we're reviewing the case. Unless the court can give us a preliminary finding or narrow focus.
Well, this was just served upon me as well. All right, let's take a 15-minute recess. Why don't you look at it, confer amongst yourselves. I would like to pursue this motion today.
We also have other scope arguments.
Well, let's deal with the gloves first. I want all the glove material down here now. All right.
And, Your Honor, prepared to go forward with the Mr. DeForest inquiry at your pleasure.
Yes.
Your Honor, also, I want to bring to the court's attention that we have an extremely important 1054.7 that I think will affect scheduling that take 10 minutes, and we urge upon you an opportunity to present it.
All right, well, as I indicated to you previously, I was doing the 1054.7s this morning at 8:30.
Oh, that was for the prosecution.
Well, that's when I was set up and doing them.
Your Honor, I was here. Not 8:45. I went to get this.
All right, well, let's take these things one thing at a time, because I'm going to have to read this right now.
I understand. Well,
All right.
I'm just bringing it to your attention.
Record in the Simpson matter, all parties are again present. Mr. Blazier?
I'm sorry, but Mr. Darden and Ms. Clark aren't here. Mr. Darden is on his way back from the restroom, and Ms. Clark is on her way down. I would beg the court's indulgence, since I don't know what Mr. Blazer's about to say, and I probably don't have any knowledge with regard to the subject matter that he's going to address.
Well, I'm going to submit the letter that we were told about to the court. So you have a chance to look at it, and then when they come back, I'd like to.
All right, let me see the letter. Thank you. All right, we've been rejoined by Mr. Darden. And Mr. Darden, for your information, the defense has offer to the court the letter of July 6th from Mr. Rubin. Mr. Blazier?
Now, this is not what we were told it was. He says in this letter, which is in the form of a report, on all 8 photos, none of the detail that can be seen indicates that the gloves could be a style other than 70263, which is the Aris lights. We just confirmed that with Mr. Rubin, that it's his opinion, which he expressed back on July 6th, that these are the same kind of gloves. This is not a preliminary indication. This is not an indication that, well, I'm not so sure. He says it in here, that these are the gloves, and this is what they were told on July 6th. Now, I still haven't gotten the letter that they sent to him asking him for some findings, but I think that this has been totally misrepresented to the court. This is a final report, and they had it before they rested.
All right. Mr. Darden, you want to make any response to that?
Yes, Your Honor. This morning, of course, the court heard our offer of proof, and Mr. Hodgman's and Mr. Yochelsen's representations to the court. And after this morning's proceeding, I saw Mr. Rubin, and I discussed the details of that, of those representations by Mr. Hodgman and Mr. Yochelsen. And Mr. Rubin indicated that our representations to the court earlier were correct. Just now, I asked Mr. Rubin what he meant by that particular sentence and by this letter in general, and he indicated to me just now that he needed to see more information, that he was not stating conclusively that these were 70263s. He needed more information. He needed other photos. Anyway, and that this is in fact a preliminary on his part. And once again, I would point out that the date of the letter was July 6th. So our representations to the court this morning are consistent with what is contained in the letter, and Mr. Rubin confirms that. And I should indicate as well that after we received the letter, we went about blowing up photos, enhancing photos, attempting to identify those characteristics that are unique to this particular glove, so that Mr. Rubin could come to some conclusive opinion at some point.
He says in here, all other photos appear to be brown. Crime scene gloves color. Photo number 4 from Robert Lee is the glove. This is not equivocal, Your Honor. This is him saying, I saw the pictures, that's the glove.
We rested. He sent a letter from, was this New Jersey? Obviously, we didn't have this letter. The court will note that the letter is not faxed. The letter was mailed. So obviously, we rested with not having this particular information.
Mr. Rubin, what manner of communication did you use to send this letter to Mr. Yochelsen?
Federal Express,
All right. Was it on the day that the letter was written?
I believe it was.
Mr. Blazier?
I think that it's obvious from the letter what has happened here, and I think this evidence should be excluded based on this report.
All right. Court notes the first paragraph at page 2 of Mr. Rubin's letter, where the text is as follows: the key to an accurate identification of the glove would be fastest from number 3 John Cassidy photo, because the fine edge on the finger shows the brosser stitching and 3 points on the back are flat. Do you have a clear original question mark? Number 4 from Robert Lee is clear enough, but black, indicating a desire still to have further photographs. Although this does have a conclusion in it, it was sent after the prosecution rested, so the ruling stands. All right, let's go to the issue of defense motion to strike Detective Furman's testimony.
Could I say one thing before we go on? I notice Mr. Rubin is here. I am not prepared to cross-examine him. I can cross-examine the photographers. I have no problems with that, but I'm not ready for him.
I understand. Thank you. All right, Mr. Elman.
Well, Your Honor, as in so many other points in this trial, we're back to square one on an issue that we thought we had resolved. But we want to make it very clear that square one for us is the constitutional right to confront and cross-examine the witnesses against the defendant. And that right is so fundamental that no trial can be called a fair trial where that right has been denied. And the defendant will not waive that right by resting his case without some remedy that avoids an unfavorable inference from his unexplained failure to recall Detective Mark Furman in the presence of the jury. Saying nothing and doing nothing actually prejudices the defendant because the jury is aware that he was subject to recall in light of the evidence that has been presented. The failure to recall him or explain why we were not doing so can only result in an inference unfavorable to the defendant.
You recollect that my ruling indicated that I felt that it was not appropriate, that some instruction was appropriate because Mr. Furman had not been subjected to cross-examination with regards to Singer, Hodge, and McKinney.
Yes, Your Honor. We would add Rokar to that list. We believe that the contradiction between Mr. Rokar's testimony that that photograph was taken at night and the testimony of Detective Furman that the photograph was taken after he returned from the Rockingham premises at 7 in the morning is a very significant contradiction in terms of the access to the evidence that Detective Furman had before he went to the Rockingham premises. What we have proposed, Your Honor, are three alternatives that the court has not previously considered, and we have renewed our request for a fourth alternative, and we believe that any one of these four alternatives would be a satisfactory resolution of the problem, but no less than one of these is absolutely necessary. The first alternative we propose is moving to strike the portion of the testimony of Detective Furman that dealt with the discovery of the Rockingham glove and to strike the glove itself from evidence. As we noted in our moving papers, we have not previously moved to strike any of Detective Furman's testimony because we intend to rely on some of that testimony, and we have a right to rely on it to put in evidence some very important issues from the defense perspective. That is, we believe that as to some of the evidence provided by Detective Furman, it is favorable to the defense or it contradicts other witnesses for the prosecution and can be used to challenge their credibility. It's a question of either Furman is lying or one of these other witnesses are lying. And we believe we can argue based on Detective Furman's testimony that perhaps other witnesses have perjured themselves in this trial as well. I have delineated in the moving papers the areas in which we believe we are entitled to rely on testimony of Detective Furman. For example, he testified that he informed the other detectives, most notably Detective Phillips, that he had been to Rockingham on a family dispute on a prior occasion, and I believe that is inconsistent with Detective Phillips' testimony. He testified that when he went to the Bronco in the early morning hours of June 13th, not only did he see the speck above the door handle, but he saw the 3 to 4 small lines that he thought resembled blood on the door sill. And he also testified that he told criminalist Fung about that second stain. Both Fung and Larry Regal testified that those 3 or 4 lines were only visible when the door was open. So we believe, based on that testimony by Detective Furman, we can challenge the contention of the prosecution that no entry was made to the Bronco at the scene at Rockingham before it was hauled off to the print shed. And that, of course, is a vital point to the defense in terms of explaining the presence of blood in the Bronco. And also, Mr. Fung denied that Detective Furman had told him about that stain at the Rockingham scene. So there's a contradiction between what Furman said and what Fung said. Detective Furman is also the only source of evidence that Cato Kalin passed a nystagmus test in the early morning hours of June 13th. He is the only source of testimony that the plastic bag in the back of the Bronco is standard equipment in a Bronco, that it is a bag for the spare tire. He also testified to observing a partial fingerprint on the knob of the back gate at Bundy. He is the only source of testimony that the premises next door to Mr. Simpson's Rockingham residence were inspected by him that morning, and he found nothing out of place, which is important evidence in terms of any theory that the prosecution might offer that entry was made to those premises and somebody climbed over a fence and dropped a glove. We also want to rely on the preliminary hearing testimony of Detective Furman, which was elicited from him on his examination at trial, that he had referred to the gloves at Bundy as them, and that he had referred to seeing blood in the Bronco.
All right, Mr. Ullman, then have you, given the surgical manner in which you propose to strike Detective Furman's testimony, do you have a proposal concerning where in the transcript and what pages, what lines, from where to where?
Well, frankly, I
proposal?
think the jury would be very confused by a delineation of line by line in the transcript in terms of...
No, that's not what I'm asking for as far as the jury is concerned. I mean, you're asking me to strike specific testimony. You want some, but you want some left in and you want some taken out. So I need to know specifically what is it that you're asking me to strike.
What we are asking be stricken is the only portion of Detective Furman's testimony where the denial of cross-examination has seriously prejudiced us the most, and that is with respect to the discovery of the glove. We would like stricken all of his testimony with respect to his discovery of the glove behind the residence at Rockingham and the glove itself, that they be stricken from evidence and the jury just simply be told, disregard that. Don't rely on Detective Furman's testimony with respect to finding that glove, and ignore the glove in your deliberations. We have been prejudiced in terms of cross-examining on whatever motives he might have had to plant that evidence. We have been precluded from confronting him with the testimony of the witnesses McKinney, Hodge, Singer, and Rokar with respect to motives and opportunity in that respect, and we believe the appropriate remedy is simply tell the jury, disregard it, forget it happened. Our second alternative is closely related to the first because it really points out the unfairness and the injustice of the prosecution putting a witness on the stand and getting the benefit of his direct testimony and relying on that testimony to prove their case without taking the lumps that come along with cross-examination because of the invocation of the Fifth Amendment. And the prosecution really has it within their control to eliminate that obstacle to cross-examination by the grant of immunity to the witness. What we have proposed is that the court actually has judicial authority to grant use immunity to Detective Furman. Under these circumstances, to say to Detective Furman, none of the testimony you present on cross-examination by the defense at this point will be used against you in a future prosecution, and thereby make his testimony on cross-examination available to the defense. And we believe the prosecution should be stopped from objecting to that kind of a grant of use immunity because of their past reliance and their future intended reliance on Detective Furman's testimony. I think the strongest authority for that proposition comes from a case in which the Court of Appeals actually said that the prosecution could be compelled to grant statutory immunity under Section 1324 of the Penal Code under circumstances very similar to what we are presented with here. And that case has not previously been called to the Court's attention. It was not even called to the attention of the Court of Appeals in the petition for a writ that was filed by the people last week. And we've ended up with a very curious situation where we have a controlling precedent from the Second District Court of Appeals that apparently was not considered by the court in issuing its alternative writ last week, nor has it yet been considered by this court. And that is the case of People versus Garner, where a very analogous situation is presented of a witness who testified at a preliminary hearing and then came in at trial and said, I'm worried about prosecution for perjury for my preliminary hearing testimony, therefore I'm going to take the Fifth Amendment. And the prosecution then offered in evidence the preliminary hearing testimony on the theory that the witness was now unavailable so they could use the prior testimony at the preliminary hearing. And what the Court of Appeals said about that is highly analogous to the situation that this court faces. In fact, the situations are virtually identical. The court said, obviously, the people could not in good conscience have urged that the very testimony on which they asked to have the appellant imprisoned for the balance of his life was so untrustworthy that they wished to retain the right to prosecute their declarant for perjury. They already knew, of course, that Phillips claimed to have testified falsely. Under such circumstances, one might have hoped the prosecution would have been as desirous as the defense to see the truth prevail, whatever that might be. And that points out the irony of the prosecution's position if they are actually going to oppose the grant of use immunity to Detective Furman, because the use immunity issue only comes up in the context in which he can legitimately claim the Fifth Amendment, if at all. And that's because I face the risk of prosecution for perjury in the testimony I presented in this case to this jury. And for the prosecution to come into this court and say, we want to rely on that perjured testimony. We want to use it to convict this defendant and send him to prison for the rest of their life, and we don't want to immunize this witness from subsequently being prosecuted by us for perjury. Well, you can't have it both ways. And that's essentially the ruling that the court handed down in Garner. They said, lest there be any confusion concerning the extremely limited nature of the remedy we here recommend, we emphasize that a need therefore will arise if and only if the witness's invocation of the privilege is based upon a claimed fear of perjury prosecution. That's number one. And number two, it is the people who wish to use this witness's earlier and assertedly false testimony as evidence against the accused. While the district attorney may not be required to seek a grant of immunity, even in such an instance, his request to make affirmative use of that testimony may be conditioned upon his willingness to expose the witness to full and complete cross-examination. So what the court is saying is, okay, it's your choice. If you're not going to accept immunity, then you have to accept striking the testimony. You can't have it both ways. And that is precisely the situation we have here. Both of those conditions are met. The invocation of the privilege is apparently based on a fear of prosecution of perjury, and the people intend to continue to rely on this perjured testimony in making out their case in chief and arguing that the jury should consider the evidence of Detective Furman finding this glove and the evidence of the glove itself. The third alternative that we pose would involve the court making a much more specific determination of the availability of the privilege against self-incrimination by the witness, Mark Furman. What Detective Furman did in his brief appearance on the stand is to sweepingly invoke the privilege as to all future questions. And we believe that may be an inappropriate invocation of the Fifth if his only concern is potential prosecution for perjury. And in fact, even with respect to potential prosecution for perjury, if in fact he assumed the risk by getting on the witness stand and in direct testimony willfully and knowingly presented perjured testimony, we believe that itself may have been a waiver of the Fifth Amendment privilege. Now, we recognize Your Honor's prior determination that the invocation of the Fifth Amendment and the determination of the appropriateness of the invocation of the Fifth Amendment should be done out of the presence of the jury. But that can be accomplished in a 402 hearing at which Detective Furman is subjected to question-by-question cross-examination, and the court makes a ruling in the context of that examination whether he can appropriately invoke the Fifth Amendment privilege. But bear in mind that the burden is on him. Under Section 404 of the Evidence Code, it is the witness who invokes the Fifth Amendment privilege who bears the burden of showing that his invocation of that privilege is appropriate. Now, once the court has made such a determination, we can then proceed to cross-examination of Detective Furman in the presence of the jury with respect to the issues where the court has determined he has waived his Fifth Amendment privilege and he may not rely upon the privilege against self-incrimination in declining to testify. That, however, does not eliminate the need for some sort of instruction to the jury. Because if we cross-examine on very limited areas where he has not appropriately invoked his Fifth Amendment and are precluded from cross-examining in those areas where the court has determined his invocation of the privilege is appropriate, we're left with the same problem. The jury will infer from our failure to cross-examine in certain areas that we're conceding the credibility of his testimony, when in fact the reason we're precluded from asking in those areas is because of his facing a realistic risk of a perjury prosecution for that testimony. So just the opposite inference should be drawn. And the Garner Court addressed that problem. In fact, the Garner Court very specifically said, under these circumstances, the jury should know that he's invoked the Fifth, and they should invoke an adverse interest against him because the only basis for his invocation of the privilege is the risk of a perjury prosecution. Recognizing that the court has already ruled on that issue, we want to emphasize we're not waiving our objection to that ruling, but we're saying under those circumstances, the most appropriate instruction to give the jury now would be the 225 instruction of Calgic. And it's important to note that the Calgic use note itself indicates that this instruction, as slightly modified, can be given where the invocation of the Fifth Amendment is taken out of the presence of the jury. And what we have proposed is a slight modification of 225. So if we are permitted to cross-examine Detective Furman in the areas where the court has indicated he may not invoke the privilege, the court should instruct the jury that with respect to specific questions, his invocation of the privilege has been upheld, and they should not infer anything from that invocation of the privilege, one way or the other. The final alternative that we propose is one that we have proposed before, that in lieu of cross-examination, we be allowed to present additional excerpts from the McKinney tapes and transcripts as declarations against interest. But one of these four alternatives is going to be necessary in terms of the balance that the court must strike. And we would contend that when a conflict arises between the fundamental right of the defendant to confront and cross-examine the witnesses against him and the right of a witness to invoke the Fifth Amendment privilege, it is the Sixth Amendment right of confrontation that must prevail. And we have proposed four very reasonable alternatives that would accommodate Mr. Simpson's right to confront and cross-examine Detective Furman and still respect any valid assertion of a privilege against self-incrimination.
I'll hear from the people.
What you've just heard, Your Honor, is simply, in many respects, the repetition of arguments previously made to this court and rejected, and the expression of the defense frustration at not having obtained the ruling they sought to obtain. That does not mean that any of the proposed alternatives are in any way, shape, or form proper, legal, or required in this case. Let me remind the court of what occurred in this courtroom during the last week of the defense case, just so we're clear that the defense has not only not suffered any detriment, but they have received every possible windfall they could possibly ask for. In the form of the McKinney tapes, in the form of the testimony of Hodge, in the form of the testimony of Ms. Singer, the defense has trumped everything they previously planned to give to this jury in an incredibly overwhelming way. They have launched every inflammatory attack they could possibly launch. They were given wide latitude to do so. In doing so, they have been allowed to effectively impeach Detective Furman's testimony with respect to his assertion that he never used racial epithets in the past 10 years. They have done so conclusively. They have done so without any ability on the people's part to bring Detective Furman back to explain or mitigate the circumstances. We accept that deficit. The defense is refusing to accept their victory graciously. They want more. They want more. They've won, Your Honor. I mean, you know, they got that concession. They've won. They've proved to this jury he lied about that. They don't, but that's not enough. They want to go farther, and they want to rub the jury's noses in it and also seek to draw improper inferences from that aspect of the testimony. And that's what's not fair. And that's why they have been seeking things that are way beyond the law and way beyond the pale. With respect to, and let me indicate, People versus Garner is wholly inapposite. I don't know if the court had a chance to read that. But in the Garner case, what occurred was that the witness testified. It was the sole witness against the defendant. He testified at the preliminary hearing. After the preliminary hearing, he told the people, I lied and I'm not coming back to testify and I'm going to invoke because you could prosecute me for perjury. So all the jury had was the former testimony of that one prosecution witness who was their sole witness to prove all the relevant information against the defendant, read to them through the former testimony exception under Evidence Code Section 1291, so that the defense really had no opportunity to cross-examine him before the jury. And then the jury was not informed that he had told the prosecution that he lied. The only thing that the jury was informed in that case is that he invoked his Fifth Amendment right and they were not to speculate as to why. I don't consider that analogous to this situation at all, nor do I think anyone else would. When you look at the situation in this case, what you have is the fact that Detective Furman was extensively cross-examined as to all aspects of his testimony concerning this case, He is not the key prosecution witness. What he is the defendant's poster boy for the key prosecution witness. That's what they want. They want to make him as critical as possible because he was so easily and thoroughly impeached on his assertion that he had never used racial epithets in the past 10 years. It behooves them to make him supremely important. I understand. That doesn't mean it's true. It just means that's what they want. They're asserting him to be a key prosecution witness when, in fact, if you took hypothetically the situation where you eliminated the glove, you eliminated Mark Furman, we would still have overwhelming evidence of the defendant's guilt. So we do not have the sole critical witness involved in this case that they did in Garner. But more importantly, this witness...
Is that a concession that I should strike his testimony regarding the glove?
No, it's not, Your Honor. I'm talking hypothetically, and I will address that point. But in Garner, you had no ability for the jury to assess the witness's credibility, his demeanor, that is, as he was cross-examined concerning the facts of that case, and an admission that he lied in that case. All you had was former testimony. In this case, Mark Furman has completely and thoroughly been cross-examined as to all aspects of his testimony involving this case and Kathleen Bell. And the only thing that he was not cross-examined about was the windfall of McKinney, Hodge, and Singer that the defense came up with later. What you basically have here is that he was impeached, though. Even though they haven't cross-examined him about it, the truth of the matter is, all they want to do is parade him up again in front of this jury so that they can make the jury look at him when they ask him about the N-word. And they've already heard all the impeachment. He's been impeached with his own voice, saying racial epithets. They've got him, but they want more. They want to kick him around in front of the jury. They've got enough to get the instruction about a witness willfully false. They will argue it till the cows come home. I promise, Your Honor, they will. They will parade Mark Furman in front of the jury and talk about a witness willfully false, probably for half their case. And they've got that instruction. They've got the witnesses who directly impeach his assertion. They've got his voice on tape. And they want more. That's all they're saying here. They want more. But in saying that, Your Honor, they have not justified getting more. Now, I would indicate to the court with respect to Ralph Rokar's testimony, he's been impeached by already Robert Risky and Detective Phillips, both of whom testified that they saw that photograph being taken after the detectives got back from Rockingham. And the defense knows that. I mean, that's another game they're going to play with the credibility of Mark Furman. Now, talk about shifting sands. Mr. Yeoman gets up and tells the court that they think his credibility is intact as to various topics, and they intend to rely on his testimony about those topics. Now they want it both ways. If their indication is, and I'll move on, this is the striking issue, Your Honor, if it is their position that they have to strike the testimony concerning the finding of the glove, then they are doing so because they feel that his credibility has been unfairly left intact when, in fact, he was impeached. But he was not impeached as to whether or not he planted the glove, Your Honor, at all. In fact, as the court noted in its own ruling, all of the testimony in this case makes it very, very clear that no evidence was planted by Mark Furman. In fact, his credibility is intact on that issue. Yet they would have you strike just that portion of his testimony that everyone knows who reasonably and fairly looks at this evidence is true. Now, what is the point of that? What's the fairness of that? What's the legality of that? Nil. They just want to strike it because they don't like it. They want to be able to use the striking of that to turn to the jury and say, aha, you see, he did. I mean, it's ridiculous. The court's own ruling makes it clear that there was no evidence planted by Mark Furman, and they would ask you to strike that testimony. When they have failed to impeach it in any way, shape, or form, the only thing they've impeached is his assertion that he did not use racial epithets. Okay? If they feel that they have not had the opportunity to effectively cross-examine him on that point, strike that. I mean, that's where it goes. That's where the impeachment was, Your Honor. They were not able to cross-examine him on Hodge, Singer, or the McKinney tapes. So strike his testimony about racial epithets. That's what legally and logically follows, not the striking of the glove. They're going to pour through this transcript and say, as Mr. Yeoman just has, incredibly and inconsistently, he's going to go through the whole transcript and say, well, I like this, I like this, I like this, but I don't like that. Strike that. But that was never impeached. And that was not the subject of Hodge, Singer, and McKinney. So there's no logic to what they are requesting you to do. Moreover, and even more troubling, the court inquired directly of the defense as to whether or not they wanted to waive, or as to whether or not they wanted to strike Detective Furman's testimony. And they expressly and repeatedly said no. We're aware of that remedy. We choose not to. And they made that assertion at a point in time before they knew how the court would rule, at a point in time before they knew whether they would get that instruction. So they've waived their ability to move to strike at this point, Your Honor. And even if they haven't waived, there is absolutely no logic and no reasoning to support the ability to strike the testimony in any part at all. And I would also point out to the court that when they refused that option of striking, they did not do so conditionally. They didn't tell this court, well, we may move to strike if the court doesn't rule favorably on everything else. That was an unconditional waiver. No, we do not want to strike his testimony. And in point of fact, they're asserting to this court that as to large segments of his testimony, they're going to argue to the jury that Mark Furman was credible. I can't wait to hear that argument. That's going to be very entertaining. But nevertheless, I think it does tell the court something about the viability and the integrity of the motion to strike the portion concerning the glove. It's not right. It's not right in logic, and it's not right in law. Moreover, Your Honor, with respect to the glove testimony, full cross-examination was had on that subject matter. As you recall, Mr. Bailey went extensively into how Mark Furman found the glove and then proposed to go into, and did, I think, cross-examine about how Marines carry things in their socks and other interesting points like that. But Mr. Furman was fully cross-examined on that issue. So there's been no deprivation of the right to cross-examine and confront the witness against him on that topic. Again, then why strike it? Under the circumstances the court finds in this case, there is simply no authority to strike what the defense is asking the court to strike.
Excuse me just a second. Ms. Clark.
Let me cite to the court the case of People versus Daggett, D-A-G-G-E-T-T 225 Calap 3rd, 751 at page 760, that deals with this issue more directly. In that case, the court refused to strike the victim's testimony after the victim invoked. There had been a limited exercise regarding impeachment concerning his being charged with the molestation of children. In that case, he was the sole accusing witness against the defendant in a case of molestation. He admitted on cross-examination to having been charged with molesting other children, but exercised his right to, under the Fifth Amendment, to refuse to testify as to whether he had ever admitted having molested children himself. The court found there was no error in the denial of the motion to strike. Now, I would call that a pretty serious invocation and a very serious aspect of the witness's credibility when you're talking about a molestation case, and he invoked on a key issue concerning his own credibility. In that case, the motion to strike was denied. Now, interestingly, the defense belatedly contests Mark Furman's right to invoke.
I'm listening.
Okay. At the time that he did invoke, however, they not only conceded that he had the right to invoke, but were obviously not contesting any aspect of his right to invoke. And with respect to that, Your Honor, I would really like to hear an offer of proof as to what they think. They say that there are some areas in which he would not need to invoke and other areas in which he would. I'd really like to hear what they intend to cross-examine him about that doesn't require the invocation. Because as with respect to this case, all aspects of his involvement in this case have been fully and thoroughly cross-examined on. If they intend to go back into that testimony, it's cumulative, it's been asked and answered, and they're under 352 and undue consumption of time, and repetitively asking those questions should properly be granted. So if they want to go back into that, for which there is no Fifth Amendment, I believe, then there is no reason to recall him. If what they want to do is go into past acts of alleged misconduct on the tapes, there's obviously a valid Fifth Amendment right as to those issues. So I would really be curious to know what the defense thinks they can question him on, for which there is no valid Fifth Amendment right. And I think that that in itself really exposes the intent here. The intent is nothing more than a game to get him back in front of the jury and parade him around and ask some improper questions to which the court will sustain proper objections and infer things they should not be inferring from the manner in which the questions are asked in another effort to make a circus out of this trial involving Mark Furman. There is no valid reason to recall Mr. Furman, and the defense has failed to show this court in specific what reason there might be. And when I say that, question him about what? For what? He's already invoked with respect to those tapes. We know that when he said he didn't use racial epithets, he did not tell the truth. That's been done. Now, they have rebutted his testimony. They thoroughly impeached that assertion by him. And they have not offered this court any valid reason to go into that. Now, to recall him, excuse me. Now, based on what I've indicated to the court in the Garner case, we don't have the fundamental unfairness here that we do there. This witness has been thoroughly rebutted, thoroughly impeached in his assertion about racial epithets from his own mouth on the tape. The jury has a clear and complete picture of that. That's what,
that argument.
okay. Okay, so the defense really has all of the benefits that Garner would have urged it to have. Calgic 2.25, do I need to address that argument, Your Honor?
It's your record.
I don't want to waste the time of the court if it's not necessary. 2.25 is clearly inappropriate to be given. That instruction is included, obviously, in Calgic because there can occur a situation, as I previously argued to the court, where there would be an assertion, an invocation that was unexpected. And in that sense, I mean that someone comes into court and all of a sudden refuses to answer the questions posed to him in the jury's presence. Now, even though the invocation formally is taken outside their presence, when the witness all of a sudden stops answering and refuses to, some kind of prophylactic measure has to be taken. That is not the situation we have here, and the court is being invited to revisit an issue that's already been resolved on appeal. With respect to the last request, the court has already properly denied it. With respect to declarations against penal interest, the court gave a full recitation of reasons for its ruling. It was not an unconsidered, but it was a very carefully considered ruling in which the court appropriately found that the evidence code section requirements were not met. Now, for trustworthiness, I can't remember the rest of the ruling. In any case, I remember reading it and hearing it. Therefore, Your Honor, I don't think that there is any merit. No, I'll go farther than that. There is no merit to any of the requests posed by the defense, and these requests should properly be denied in toto as nothing more than a reassertion of their frustration at their inability to parade Mark Furman again before this jury. They have thoroughly discredited him, and they will have every opportunity to remind the jury of that fact in closing argument, as I'm sure they will do. They've been denied nothing in their ability to cross-examine him. They have gotten every benefit out of it they could possibly hope for, and much, much more.
Thank you. Mr. Allman?
Your Honor, I did not address the immunity issue.
I thought you did in terms of Garner.
No, not necessarily. Only I distinguished Garner. Let me indicate to the court, though, with respect to the immunity issue. We need to hear more about what the defense wants us to give immunity for. I would indicate to the court that under Hunter, although that court gave a proposal for how the court might grant immunity in the extraordinary case, I would remind the court that that theory was never implemented in any subsequent case by any court and never found to be appropriate. But moreover, I really think the immunity argument is addressed in this manner, Your Honor. They've had the ability to thoroughly rebut Mark Furman, and there is no reason to recall him for further testimony. And I think that really kind of answers it. There's just no need for immunity.
So I take it that's an indication that you, representing the prosecution, are not in a position to offer Detective Furman any immunity for testimony.
Well, I haven't even considered it. Let me indicate this to the court. With respect to his testimony and his actions in this case, he doesn't need immunity. He committed no misconduct. With respect to what's contained on the tape, no one knows. And of course, we could not grant immunity as to that. And that's clearly what the defense would like to get into in cross-examining Detective Furman. Furthermore, Your Honor, the defense has been clamoring for the prosecution of Mark Furman for perjury for the past 3 weeks. And now they want to grant immunity so he cannot be prosecuted? I find that position to be highly inconsistent. I don't think that properly anyone should want us to be precluded from prosecuting Mark Furman if there is an appropriate prosecution to be had. We don't know that. I can only say that with respect to the conduct of his investigation in this case, there was no misconduct. But with respect to what's contained on the tapes, we don't know.
All right. Thank you, counsel.
Your Honor, talk about inconsistencies and contradictions. Isn't it remarkable that the prosecutor is saying the defense has already thoroughly impeached and discredited Mark Furman and shown that he's a liar? And then to stand up and say, we're not going to grant immunity from perjury. It just represents the degree to which the prosecution wants to have it both ways in this case. They want to continue to embrace Mark Furman. They want to continue to rely upon his testimony with respect to the discovery of the glove, and yet they want the benefit of the defendant's denial of the opportunity to confront and cross-examine this witness. Confrontation and cross-examination of the witnesses against him is not a game, Your Honor. It is a right guaranteed by the Sixth Amendment, and the reason it's guaranteed in the Sixth Amendment is because it is the greatest engine for getting at the truth that we have been able to devise. And we have been deprived of that right. Your Honor has already ruled last week in noting that the record is clear that when cross-examination was adjourned, it was subject to recall for further cross-examination, and Your Honor indicated that further cross-examination about the testimony of these witnesses was likely and reasonably and appropriately the subject of further cross-examination. We've heard some really remarkable legal propositions in the course of the argument just presented, and they're propositions that I have never heard before. Number one, Ms. Clark is suggesting that impeachment is a substitute for cross-examination. I've never heard that before. I've never heard that regardless of what extent a court allows a witness to be impeached, that can be a substitute for cross-examination and be a justification to preclude a defendant from confronting and cross-examining the witness against him. Your Honor indicated in the cross-examination of Detective Furman being conducted by Mr. Bailey that certain areas should not be explored until we have come up with evidence to back up the assertions that were being made. Your Honor permitted the cross-examination with respect to Kathleen Bell, And we're prepared to accept Your Honor's determination that further cross-examination in that area is not necessary, because we had essentially what Ms. Bell had said at the time we got up to cross-examine. But now we have a lot of additional witnesses who were not even available to us at that time. With respect to whose testimony we have the right to challenge Detective Furman's credibility. There has not been any concession by the prosecution that Detective Mark Furman is a liar and that his testimony should be discredited. In fact, with respect to the impeaching witnesses that we called last week, the prosecution got up and impugned their integrity, suggested that they were here to make money, suggested that Ms. McKinney had some sort of ulterior motives, suggested that she had some sort of relationship with Mr. Furman. So there hasn't been any recognition by the prosecution that all of these witnesses should be believed in their entirety, and we can simply discredit and throw away the testimony of Detective Furman. They still want to embrace Detective Furman. They still want to use his testimony about the discovery of the glove. The second really remarkable legal proposition we heard in the course of that argument was that in view of what we've already presented with respect to Detective Furman's credibility, we cannot justify getting any more. That's pretty remarkable, that the defendant has to justify the right to confront and cross-examine a witness against him. I always thought that was a given. That was a right guaranteed by the Constitution of the United States. The final really remarkable proposition is that the prosecution can tell us which parts of this witness's testimony are true, that everyone knows, and which parts are false. I always thought that was the function of the jury, that we leave to the jury the question of sorting out what parts of a witness's testimony are true and what parts are false. And the most important tool we have to assist the jury in that process is the opportunity to confront and cross-examine the witness. We don't know what's in the minds of any of those jurors. There may still be people on that jury who were very impressed by how forthright and forthcoming Detective Furman was. That's the last time they saw Detective Furman, when he was on that stand, subjected to direct and cross-examination for 6 days. And remember, when he got off that stand, what the conventional wisdom was about the credibility of Detective Furman. There may still be jurors who believe that despite all of our efforts to impeach his credibility, he is still a believable witness, and who will assume that
You're not seriously suggesting that I should take the quote-unquote conventional wisdom into consideration, are you?
Well, apparently the prosecution is offering, Your Honor, the conventional wisdom and in suggesting, well, everybody knows that there's no planting of evidence in this case. Everybody doesn't know that. We certainly don't know it, and we don't believe the jury knows it yet either. And we're saying that the risk to us of not recalling that witness and confronting and cross-examining acceptable to allow the prosecution to say, we want to use this evidence to convict the defendant and send him to jail for the rest of his life, and we want to keep our options open to prosecute that same witness for perjury for the testimony that we're relying on. With respect to the suggestion of waiver, there hasn't been any waiver here, Your Honor. We are pursuing every potential remedy that the court has available. The fact that we were willing to accept an instruction last week in lieu of pursuing our right of cross-examination does not foreclose us from insisting on that right when the instruction has been denied. and we're left back with square one again, a witness that the prosecution wants to rely on, that we have not had the opportunity to fully confront and cross-examine as guaranteed to us by the Constitution of the United States and the state of California.
All right, thank you, counsel.
In light of the fact, I just want to cite cases to the court because we have not been allowed to. We got 15 minutes notice, we were not allowed to file moving papers in this. I just have some cases to cite to the court.
Cases.
People versus Cooper.
Is that the Kevin Cooper case?
Yes.
I'm familiar with
53
it.
Cal 3rd, 771 for the proposition that the Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish.
What other case?
People versus Superior Court, Piedrahita, Piedrahita, 34 Cal 4th, 508 for the same proposition. And Delaware versus Van Arsdal, ARSDALL, 475 US 673.
All right, thank you. I'm familiar with those cases. With respect to the first request to strike the testimony of Detective Furman as it relates to his discovery of the Rockingham glove, I find that prior to the arguments, the submission of the arguments concerning the request for a jury instruction, that request was waived. Assuming the waiver that, notwithstanding that waiver, assuming the defendant has the right to renew the request subsequent to the action by the Court of Appeal, I find that with regard to the issue presented and most forcefully argued, that is regarding the issue of the discovery of the glove, that Mr. Furman was in fact cross-examined with regard to that specific issue. There was a full opportunity to cross-examine him over 6 days. The motive to, the defense was aware of the comments of Ms. Bell. Detective Furman was cross-examined as to the allegations made by Ms. Bell, and there was in fact the full and complete opportunity at that time. As to the request that the court order the prosecution to grant use immunity, court finds that the facts and circumstances in Garner are very unlike the facts and circumstances in this case. In that case, the sole evidence that was presented of the defendant's guilt was the preliminary hearing testimony that was presented because the witness was no longer available, having claimed the Fifth Amendment privilege. Here, the situation is that Mr. Furman was subjected to cross-examination, direct and cross-examination over a 6-day period. His testimony encompasses 6 full volumes of this court's transcripts. He was ably examined and cross-examined. Garner is distinguishable. The court finds no other authority for the proposition that this court can either on its own grant immunity or direct the prosecuting agency to do so. With regards to the request to recall Detective Furman, the court has previously ruled on that issue. That ruling will stand. The court has previously ruled on giving a jury instruction. This court's ruling on that issue was overturned by the Court of Appeal. I have no authority to go beyond that. And with regards to the declarations against interest, that is a renewal of that request, and the court's previous ruling will stand for the reasons previously stated. All right, we'll stand in recess until 1 o'clock. All parties are again present. Jury is not present. All right, Mr. Cochran, what's your position on the defense ability to rest at this time?
Well, let me indicate the following to the court. Thank you, Your Honor. Good afternoon, Your Honor.
Good afternoon, sir.
As the court is aware, the defense really never rests. But more specifically, in this case, we cannot rest at this point for a number of reasons. First of all, if the court pleases, we would like an opportunity to take a writ regarding the ruling of the court this morning. The court will recall that I guess it was last Thursday, the prosecution indicated they wanted to take a writ, and the court was kind enough to give them, in fact, more time than Mr. Clark had asked for. We are very mindful of our jury back there, but we want to take a writ on this whole issue because we're in a situation, Your Honor, where we've talked a lot about a search for truth, where this jury will basically be lied to, that they will not understand what really happened in this courtroom. You're not permitted to give a jury instruction. So far, we can't call him back. This man has lied and perjured himself to the entire world.
Well, Mr. Cochran, the point being you want to take a writ.
Yes,
So
we want to
you're
take a
not-
writ. And we would like to take this writ, Your Honor, and I was just about to ask our court reporters how soon we can get the transcripts. And I would ask, I talked to Mr. Dennis Fisher, who will be handling the writ, and he needs basically until tomorrow afternoon because he's got to get the transcript and all the documents together to do that. That's the first thing I'd like to point out to the court. Secondly, so that we might have there's also another issue regarding our inability to rest. The court will recall that Mr. Sheck and I appeared in your chambers under 1054-7. There's a critical witness in this case who shall remain nameless at this point. And we think there will be startling evidence regarding before this week is out that we may want to impeach further, may want to call back for further cross-examination. We expect by Wednesday that information will be available. We think there are also Brady implications regarding this entire witness, so we can't rest regarding him. Finally, in addition to the writ, we would like to call Detective Furman back to the stand for a specific non-necessary testimonial circumstance, and it's as follows. You'll recall that during Mr. Darden's cross-examination of Ms. McKinney, it seems though he attacked her credibility. You remember the colloquy between the two of them. They can say all they want in argument, but we know what's happened before this particular jury. And so we would like to call Mark Furman to the stand, and I'd like specifically to have him utter those words that were played on that tape so that once and for all we can determine whether or not that's his voice, and this jury knows that's his voice. We have an absolute right to do that, and he's under no Fifth Amendment problems regarding that, and so we'd like to do that. Those are the various things that we would like to do at this point. If we can get Furman down here, we can do that and go on. But other than that, we need to stay for the writ. And then the other thing involving the witness will become obvious, I think, by Wednesday at the latest. As far as being able to do other things, Your Honor, my colleagues are very, very anxious to be able to argue to Your Honor the balance of the motion regarding scope. There's some issue regarding RFLP, the results. There's all kinds of things that we can do.
Well, that argument is scheduled for 5 o'clock this
Oh, is it?
afternoon.
Okay.
Yes.
Right, very well.
The Bronco, Gary Sims, et cetera, I think it's set for 5 o'clock this afternoon is my recollection.
I think the balance of the scope argument, so maybe we can hear that perhaps before that time. I think Mr. Blazer has more on the balance of the prosecution's idea of scope of the court, please.
All right, what's the people's position?
I believe that one of the orders issued by the Court of Appeals was that there would be no further stays. Secondly, when the people requested their stay, there was no minute of time lost. The court indicated we would begin rebuttal on Monday morning, and we then proceeded immediately during the time that the writ was being prepared to argue the admission of exhibits. There was not 1 minute of time lost in this trial. We did not start 1 minute later than we would have. So our writ took no time away from the jury or away from the court. With respect to Mr. Cochran's request to delay again until Wednesday, I think it is ridiculous. It is up to this court. This court's aware of what the information is, and I'm not. So, you know, we are operating at a real deficit here. I don't know what would qualify under 1054.7 at this late date. But Mr. Cochran, if he has no further witnesses to call before this jury, has to rest. That's all he has to do. And if he wants to take a writ, he may take the writ. He's always entitled to do that. That's fine. But not take any more time away from this jury. If he has no further witnesses for this jury to hear, he's through. And the court has the power and, in fact, the duty at this point to say, it's over. It's over. There's just so much that they can do to mess around with and fantasize about other people that have startling new evidence. Only the court is aware of how startling or new it might really be, or if it's even admissible before the jury. Who knows? I have no idea.
Nothing startles me anymore.
No, I can understand that, and I think I share that, Your Honor. But nevertheless, this is another filibuster proposed by the defense. It's the 11th hour. We have witnesses sitting upstairs that we have flown in, waiting to testify in front of this jury, but we will not begin, we can't begin our rebuttal case until they rest, and it's time that they do. I mean, that's enough monkeying around here.
All right.
I don't need counsel to tell us when to rest our case. I've indicated to the court where we are in this situation, and it's a flat-out untruth. What happened was that she'd asked for until Friday noon, she'd asked till Friday morning. Your Honor gave her till Friday noon, and then you said that we were going to start rebuttal Friday afternoon. Had nothing to do with her. The jurors had something planned on Friday afternoon. So, I mean, they can't ever get the record straight. There was a delay. There was no question there was a delay by virtue of them seeking a writ. Now, when we asked for a writ, and under circumstances, and it would seem to me they join in this, because the record, Your Honor's hands have been somewhat tied. We've talked all this time about truth to this jury. This jury's not getting the truth. And we cannot say we rest in good conscience. As officers of the court, we're not going to say those words. Further, you do know about the 1054-7. I think they should know, and that's why I said there's Brady implications about this. A lot of people know about this, and so certainly now that we've become aware of it, we brought it to Your Honor's attention, and we have a right to pursue that. It's a key witness in this case also. So that for those reasons, we're not wasting any time. We would ask leave of court to do these various things. They brought this writ. We have a right to do it. And the point I should point out, Your Honor, is this, how unfair it all is. What happened was, they bring their writ. The Court of Appeals issues some kind of preliminary stay. We never get a chance to file anything. Your Honor then withdraws the jury instruction. They then rule the issue mooted. Mr. Simpson hasn't been able to file one piece of paper at this point. What kind of fairness is that? He's talking about wasting time, and nobody's monkeying around. This is serious business, and we want our opportunity to have a chance to file some papers. And just before lunch, Dean Ullman and I spoke with Mr. Fisher. He's prepared to go forward at this point. So this is serious business. We want to make this thing as clear as possible. The court can see why we cannot rest at this point. And I think that, it's a little late for the people to be arguing this, Your Honor, because they're the ones who precipitated this problem. If you had gone ahead, as we'd ask you to give that jury instruction, we wouldn't have this problem. It would have been over at this point, but they saw fit to take their writ. We have a right to do the same thing. And the court gave them a stay. And as far as the Court of Appeals, I think they misconstrued. I cannot believe that a Court of Appeals in this state would tell you that you can't grant any further stays at all in this case, no matter what happens. They might as well come down and try the case if that's the case. Maybe they want to do that. But that sounds to me to be rather illogical. And you may take them up on it, perhaps, and that look on your face. But I can't believe that was the intent. I know Judge Turner, and I'm sure that wasn't his intent or his import. I think that he likes knowledge.
He might enjoy it.
Yeah. Well, Judge, he has a lot of reading to do. As you were aware earlier a couple of weeks ago, he'd have a lot of reading to do before he can catch up with this case. But I think we have a right to do this, Your Honor. This is not wasting any time, and there's other things that we can do. I am not, on behalf of my client, prepared to rest. You can imagine how Mr. Simpson felt on Friday. All these things went by through fax machines and telephones, and we're finding out on the news what's happening. What do we say to our client there who's asking for a fair trial? All he wants is a fair trial. And all these things are going on, and he never gets a chance to file one piece of paper. And then it's all of a sudden it's mooted out. And then you're told, well, look, you can't do this. We don't have to accept that. You may want to accept it. We don't accept it. We want to do something about it.
I'm just a poor trial court judge.
Well, no, you're too kind, Your Honor. You're much more than that. But I think we have a right to do that, Your Honor, because really, all of us have roles, transitory roles. But with regard to Mr. Simpson and seriousness, this has an effect upon him. It affects his life and the rest of his life, his ability to get a fair trial. And that's what we're trying to do, Your Honor. That's why it's so serious.
Thank you, counsel. All right, at this point, the court is mindful, first and foremost, of the burdens that we've placed on our jury and the fact that they've been seated in our lounge waiting for the presentation of additional evidence today. Likewise, on the basis of the request, these are extraordinary issues. I don't think anybody would agree that, I think everybody would agree that these are unusual and unique legal issues. And if the defense wishes to pursue their writ remedies, then they have every right to do so. And I am not going to require the defense at this time to rest. What I will do, though, is exercise my discretion under the penal code and direct that the prosecution, having indicated their ability to go forward with their rebuttal case, direct that they begin presenting their rebuttal witnesses at this time. Defense will have leave to present further witnesses in their case in chief on defense. All right, that'll be the ruling.
Court, listen to Mr. Glazer with regard to the rebuttal aspect.
Before you do that, what we're facing here then is for the ability for the people, the people have to go forward with their rebuttal evidence.
That's correct.
And the defense will then be allowed to resume its case in chief at some point during that rebuttal case, perhaps even including witnesses to rebut what we put on during our rebuttal case.
No, their case in chief, counsel, subject to the same scope issues. All right, let's proceed.
Will the court at least require that the defense put on the record outside the presence of the people exactly what witnesses they intend to present in their case in chief to conclusion, so that nothing is added as a result of the people's rebuttal evidence?
That's been done in the 1054.7 hearing this morning.
And at what point is the court going to determine that the people have the right to find out, to get disclosure of that secret information?
As soon as the investigation as to that issue has been concluded and the issue is available for public dissemination. That may happen sooner than you think.
Perhaps today?
I don't think today, but perhaps by the end of the week.
Perhaps by the end of the week. What if the people have to rest their rebuttal case without knowing about that?
Well, that's the nature of 1054.7, unfortunately.
Can the court take the waiver of the defendant?
They haven't rested their case yet, so I'm not inclined to take the waiver from the defendant at this point.
Is there any limitation that the court is going to place on the nature of the testimony they present in their case in chief?
They have made a proffer under 1054.7 as to what they might go into.
There are no other witnesses other than what's contained in the proffer of under 1054.7 that they can call in their case in chief at this time?
That's my inclination at this time.
Then perhaps we offer to the court the option of asking them to rest subject to the availability of the information under 1054.7.
I'm not going to require them to do so, and it's within my discretion not to require them to do so. I exercise my discretion in that manner. All right, Deputy Magnero, let's bring the jurors down, please.
Okay. One other question, Your Honor. Did Your Honor care to rule on the aspect we wanted to call Detective Furman for the purpose of having him state those words that were allowed on the one incident Your Honor allowed us to play? It was on tape. I don't think you can claim the Fifth Amendment for that.
All right, that request is denied. All right, thank you.
My understanding that you ordered that all the glove evidence be brought down so we could evaluate. That hasn't been done. I have not received the letter that they wrote to Rubin with the pictures that he was sent. I see some boards over here. I've never seen any boards. I thought that the pictures I got last week were the ones they're going to use. I'm not ready for Mr. Rubin. I heard a rumor that they're going to call him right now. I'm not ready for that. I'm not ready for the direct or the cross. Photographer's fine if we can sort out which pictures they can use and which ones they can't.
I already advised
Mr. Darden.
Blazier. Good afternoon, Your Honor. I advised Mr. Blazier earlier that there were two witnesses that we were certainly not going to call who were on the list, nor were we going to use their photographs. There was a third witness who I advised him was most likely not going to be called as well.
Which photographers are you going to call?
Are we going to or not?
Are you going to call?
Mark Berger, Bill Rankin, Kevin Schott, Karen Brown, Stuart West, Jim Chesca, Mike Romano, Robert Seed, and Deborah Derrick.
All right, while we're bringing the jurors down, I'm going to ask you to exhibit to council the photographs that you're going to use.
For the record, I've never received a print on shot. I like that as a color, a bad color Xerox that doesn't show you anything.
All right, who are your first two photographers? All right, do you have those photographs?
Yes.
All right, show them to council.
Good afternoon, Your Honor. Oh, wait.
I'm fine, how are you? Nice tie.
I'm glad to hear that.
Mr. Sheffield, let me resolve this issue first.
Renken, they have 10 pictures of the same game. I don't know why they really need 10. I was told that they were going to use 2. Kruger is not down here yet.
They're taken from different angles, Your Honor, and at different times during the day, which is important because at one point a flash was used, at another point a flash was not used. So all of these pictures are relevant.
All right, I just want to make sure that they've been shown to Mr. Blazier, that he's had copies of them, he's had the ability to look at them. And the second witness, you don't have the photographs down here yet?
Somebody else? I really.
Yeah, I had asked him to bring him down. He
Because
must-
this morning I ordered all of this stuff to be brought down, if you recollect. I hate all the
It was
time
down
we're
here
wasting.
this morning. It was down here this morning, and then we took it back up at lunch.
All right, is this the photograph?
Yeah, I've never seen this, Your Honor, this exhibit. I've seen the smaller ones.
Council has seen this photograph, not this big.
I thought that the court had ordered that I be provided with photographs the same size, the same quality as theirs, so I could show them to experts. Haven't seen this one.
Let me advise the court that photomicrographs introduced to Mr. McDonald were not shown to me
Wait.
until he was on the witness
Wait.
stand.
Apples and oranges, counsel. All right, you have a copy, however, of that photograph, correct, Mr. Blazier?
The smaller ones that they have, yeah, not this one.
He has a smaller version of this one, too.
All right,
Yeah, that's correct.
okay.
Not well.
All right, is this larger photograph with regards to the second witness?
Yes.
All right, how about the third witness?
No, that's Rankin.
Yeah, that's the second one.
Who's the Kruger? Oh, haven't seen Kruger.
Kruger's we haven't seen?
Yes. Council has seen it for this.
Yeah, I haven't
I'll
seen
bring
it
him back
now.
out. Yeah.
All right, bring them down here. Let's get the jury down here. All right, let's proceed.
Your Honor, I was just given 3 more pictures that have nothing to do with gloves, but are from one of the photographers that purport to have Mr. Simpson in what appears to be a kind of a team photo with no gloves on. But more importantly, I have a still photo of Mr. Simpson on a football field with, I guess, these old timers, I'm not sure, with 1 foot off the ground. And they want to introduce this to show that this proves that Mr. Simpson could run the 40-yard dash or something, I think is what I was told. This is the first we've heard of this. Completely different topic. We object to it. This is a still photo, doesn't show anything. We would object to these.
Ms. Clark?
Yes, we just got him last night. The witness came in, and we met for the first time. He had brought photographs in with him that we had never seen before. He showed me this one where he did the 40-yard commemorative run, and I'll just show the court as obviously direct impeachment and rebuttal of the defense case concerning Mr. Simpson's physical ability.
When was this?
End of November 93. November 21, 93.
Still photo.
Why doesn't the court look at it? Still photos capture people in movement all the time. And it will illustrate his testimony because this witness...
He's way behind and he's wearing wingtips.
Right, he's running in dress shoes. Right. But the witness saw him do the run.
I doubt that this witness has the expertise to testify about any infirmities Mr. Simpson might have.
He certainly testified to his observation that he saw him running.
What was his time?
I'm inclined to go forward with the testimony regarding photographs of the gloves. This is something completely new. It's going to delay our proceeding at this point. I'm not going to allow at this point. I'll think about it, but at this point, the answer is no. All right, let's proceed.
Yeah, we also have other scope arguments that we wanted
With regards to this witness,
No, with
I
regard...
want to get some witnesses in front of the jury now.
Judge, I have no problem with that. Can we just have your assurance then that we can deal with the other scope of rebuttal arguments?
Yes,
as soon as the jury
absolutely.
leaves this afternoon?
Absolutely. We're scheduled for 5 o'clock, starting with RFLP and the Bronco.
One thing, court indicates that we are not.
Yes, absolutely. I've told you I would do that. Yes, you may. Deputy Magnera?
Make sure they don't have any photographs lying on the table. They're not going to be... Perhaps turn those over and put them away. Just put the photographs.
The running photographs. Seated. You all look vaguely familiar. Good afternoon, ladies and gentlemen. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Ladies and gentlemen, my apologies to you for the delay in getting started today. As I mentioned to you, there were a number of significant legal issues that I had to resolve, and some of which are still unresolved. As a result, the defense has indicated to me that they have not finalized their decision whether to rest their case at this point in time. And I have allowed them to delay that decision for a brief period of time to give them the opportunity to contemplate the legal issues and the factual issues that are involved in making that decision. However, as the trial court judge, I have the discretion to adjust the order in which evidence is presented to you, and I have decided to exercise that discretion, and I am directing the prosecution to make use of this time by beginning the presentation of some of their rebuttal witnesses. So at this time, you should understand that the defense has not formally rested their case. However, the prosecution will take advantage of this time, since we have you here, to begin presenting rebuttal witnesses as to their rebuttal case. So you should underline that we're shifting focus at this point in time, but we have not concluded the defense case yet. All right, Ms. Clark, are you prepared to present a new witness on your rebuttal case?
Yes, I am.
All right, you may call your first rebuttal witness.
Thank you, Your Honor. People call me Mark Kruger.
All right, Mr. Kruger, would you stand right there, please, and face Mrs. Robertson, our clerk?
Raise your right hand, please. You do solemnly swear that the testimony you may give in class not to be before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please have a seat and witness stand and statements of the first and last names for the record.
Mark Kruger.
You have a seat,
Why don't you have a seat, please? And pull the microphone close to you, please. All right, would you state and spell your name, Mr. Kruger?
Mark Kruger, M-A-R-K-K-R-U-E-G-E-R.
Thank you, sir. Ms. Clark.
Thank you, Your Honor. Good afternoon, ladies and gentlemen.
Good afternoon.
Mr. Kruger, can you tell us, sir, are you a professional photographer?
No.
I'm directing your attention, sir, to the date of December 29th, 1990. On that date, can you tell us where you were?
Soldier Field in Chicago, Illinois.
And why were you in Soldier Field in Chicago?
I was shooting photos for my stepfather's newspaper. He's the editor of the newspaper, and I went in and would take shots for the paper.
And what kind of shots were you taking? What were you there for?
Chicago Bears shots, just anything I could get that's interesting.
And was that was a football game?
Yeah.
The Bears versus who?
Kansas City Chiefs.
And where exactly were you, sir?
All
Where on the
over.
field?
I was on the sidelines, in the end zone, probably every spot on the field.
So, but you were in the field, on the field, that
I
is
was-
not on the bleachers.
Right, I was.
Give me a second. Mr. Kruger, take your time, take a breath. Let Ms. Clark finish asking you the question before you begin to answer. The court reporter has difficulty taking down two people at the same time.
Okay.
Thank you. Ms. Clark.
At some point during this trial, sir, did you send to the prosecution a photograph that you took during that Bears versus Chiefs game on December 29th, 1990?
Yes, I did.
Mrs. Robert.
People's next in order, Your Honor.
605.
Thank you. Showing you People's 605, sir. Can you please tell me if you recognize the photograph I'm showing you?
Yes, I do.
And what is that?
It's a picture of OJ Simpson at a football game, at the game I was at.
And is that the photograph that you took, sir?
Yes, it is.
Now, does this photograph show him wearing any gloves?
Yes.
What does it show him wearing?
Does it show him wearing gloves?
Yes. Is he wearing gloves in this picture?
Yes, he is.
Can I show it to the jury, Your Honor, on the Elmo?
Yes.
After that, I'm going to ask leave of the court, if I may, to tape it up to the blank board that you see on the easel with a label for the date underneath. If I may, Your Honor.
All right. Mr. Fairlow, do you have your glare? Thank you.
Is it the photograph that you took, sir?
Did you want me to look at this or up there?
Yes, you can look at, do you have it on your monitor?
Yeah, it's on my monitor. Yeah, I can see it.
Is that the photograph you took on December 29th, 1990?
Yes.
I have two other enlargements, Your Honor. May I ask that they be marked 605A and B?
605A and B, have you shown those to Mr. Blazer?
Yes. Yes. For the record, 605A will be the smaller enlargement. 605B will be the enlargement that focuses on the glove.
All right. A and B as noted.
Thank you, Your Honor. Showing you 605A and B, sir, can you tell us if these are accurate enlargements of the photograph that we previously marked 605 that you took on December 29th, 1990?
Yeah, they look like the same ones to me.
If I may, Your Honor, I'm going to put these up on the blank board.
Yes.
Your Honor, it's water for me.
No, it's not. Is that Mrs. Robertson, the water is fresh? It's fresh.
Yeah, I thought, all right, thanks.
I'm going to let Mr. Ferkel do it, that's all right.
Sure.
Now, what color are these gloves, sir?
They appear to be black to me.
Do you recall what time it was that you took this photograph?
Not exactly. I knew it was at the end of the Bears game, and I would assume it was probably about 2 to 2:30 in the afternoon, Chicago time.
And do you recall where you were, how far away from him you were when you took this picture?
Probably 10 to 15 feet.
Can you describe the weather?
It was rainy. Just a dark, cloudy day. You know, it wasn't like pouring rain, but it was just constantly a drizzle all day.
Do you recall what kind of camera you used?
Canon AE1.
And do you recall the film speed?
It was 1600, I believe.
Can you tell us whether you used a zoom lens for this picture?
Yes.
What kind was that?
It was the model or the zoom?
Both.
Actually, it was a Sears 70 to 210 millimeter zoom lens.
All right, now, when you had these developed, did you develop them yourself or send them out to a lab?
I sent them to Photoshop, 1 hour Photoshop.
No, any special processing, sir?
No,
Did you use a flash for this?
no.
Were there any lights on in the area during when you took the photograph?
Actually, I don't think they did put the lights on that day.
And did you send the negatives to the prosecution for us to verify the authenticity of this photograph?
Yes.
Now, finally, I'd like to label these photographs with the date and the witness's name.
All right, why don't you show the label to Mr. Blazer?
December 29th, 1990, Mark Blazer.
All right.
Actually, Ms. Blazer, do you need this for the Elmo? Do you want to question him on it, or shall I put it on the board? Sorry. You don't need one? You want one for the Elmo? Okay, I'm going to ask leave of the court to place that with tape on the board when we've concluded all the testimonies, and Mr. Glazier can use it.
Certainly. Thank you. Ms. Clark, any further questions for Mr. Kruger? All right, Mr. Blazier, cross-examine.
Afternoon, ladies and gentlemen. Mr. Kruger, how are you?
Good, how you doing?
Good. Now, this picture was taken in December of 1990, correct?
Correct.
At some point, you sent the photograph to the prosecutors in this case, correct?
Yes.
When did you send it to them?
I believe it was just right before the end of their prosecution case. It was
And
probably about right around, I think it was like the 1st of July or somewhere maybe around between the 1st and the 4th of July.
now, I take it you had seen Mr. Rubin testify? Is that what prompted you to send the picture?
No.
What prompted you to send the picture?
Objection, Your Honor. Irrelevant.
Forward.
They said the gloves didn't fit and they were talking about the shrinkage and I just had this photo, so I just brought it into evidence. I figured it would.
Okay. And so you sent it to them before they rested their case.
Yes.
Did they follow up and call you and tell you anything or do anything at that point?
And they just said
Objection, it's irrelevant.
Forward.
they just said they'd be in touch with me if they needed anything further. They needed to verify if it was actually the same gloves. And if they found out it was, then there'd be a chance they might need me to testify.
And they told you that at some point?
Yes.
Now, how cold was it that day?
I would say anywhere from 30 to 35 degrees.
And were there a lot of people at this game?
It's packed.
A lot of people wearing gloves?
Yeah, I would assume. I don't know that. That was the last thing on my mind was gloves. I wasn't looking to see that.
But it was a real cold day?
Not real cold. For that time of the year, it wasn't really all that cold.
Did you have gloves on?
No.
Did you take note of any other people's gloves?
No.
Anything particularly unusual about these gloves that you saw?
Actually, I didn't see him that day.
Okay. When you looked at the picture, there's nothing particularly unusual that you can see in there, is there?
No.
Objection.
Forward.
Now, I want you to look at the blow up on the right on the board. Maybe you could step down just a second.
I think that's 605B.
605B. And can you see how it appears to be that there's some sort of a lump or bunching up in the palm area?
Yeah.
Let me put that on the elbow and see if it shows up. You can go ahead and take your seat and look in the monitor. Use the telestrator. Now, you see the area that I've circled, or that Mr. Harris has circled on the monitor?
Yes.
And that's the area that appears to be a bulge or bunched up in some fashion?
Yeah.
You know what a heat pack is?
No.
You know, have you ever seen the devices that you can break and generates heat? You can put them in your gloves?
It's not help speculation.
Have you ever seen such? Excuse me. Have you ever seen such a thing?
Yeah, I've seen him.
Now, did you at any time take notice of Mr. Simpson take anything out of those gloves or put anything in them, or did you even bother to notice anything like that?
Like I said, I never knew. I never saw the glove even. I was just getting a picture of OJ.
Okay. Now, there's no doubt in your mind that those gloves are black, is there?
From what I can see, I believe them to be black.
All right. Thank you. That's all I have.
Redirect, Ms. Clark.
Could we just take a picture up on the elbow?
Yes. All right, I take it, Mr. Blazier, you want that marked as an exhibit?
Please, Your
The printout? All right, I'll, just for simplicity's sake, I'm going to make that 605C. Ms. Clark?
Does that glove appear to be kind of short at the wrist, sir?
Objection, Your Honor. Photograph speaks for itself.
Sustained.
Why did you select this photograph to send to the prosecution, sir?
Objection, irrelevant.
Overruled.
Why did I select it? I mean, it wasn't like that was the only photo I had, and it was just seemed like it was evidence to me.
Did it seem like this glove fit very much the way the glove fit in court?
Objection.
Sustained. That's for the jury to decide.
Mr. Blazier asked you why you sent us the photograph. You recall that? And you told him because you'd heard some people say that the glove didn't fit?
Right.
And what was your opinion, sir?
Objection.
Sustained.
Why did you send us the photograph when you heard people say that?
Objection.
Because of the shrinkage test. I'm sorry. What was the question again?
Why, after you heard that remark, did you send us this photograph, sir?
Because I thought it didn't fit.
Because you thought what?
The glove did not fit.
Okay. And does it look like that glove? Did it look like that glove to you?
Objection.
Sustained.
Does this glove look small on him to you, sir?
Objection.
Sustained. Speaks for itself, counsel.
Does the glove appear to be up at the palm area, sir?
Objection. Picture
Overruled.
speaks for itself.
Overruled. You ask about bunching.
Actually, it appears to be above the palm. I assume it's above the palm.
Does it appear short to you?
From the gloves I've worn, I mean, I've never owned a pair of these gloves, so I couldn't say, but from gloves that I've owned, I mean, usually they cover your palm.
Then your answer is yes.
Yes. That they appear short, yes.
Mr. Blazier?
Never worn gloves with a heat pack in them or in the palm?
Objection irrelevant.
Overruled.
No facts and evidence, Your Honor.
Overruled.
No.
Now, was there something about, when you heard the testimony, did you hear any testimony to the effect that the evidence gloves in this case were black?
Could you rephrase that, please?
Yeah. When you were alerted and decided to send in this picture, had you heard any testimony about the evidence gloves being black?
No, I hadn't.
Thank you.
Yeah, I have nothing further on this witness. May I ask to pass around a small photograph to the jury?
Yes. All right, Mr. Kruger, thank you very much, sir. You're excused. Thank you for coming to LA. All right, Mr. Fairtlow, would you hand that, please, to juror number 1? Clark, would you summon your next witness, please?
Give calls for Bill Reckon.
All right, I need to allow the jurors to each examine, but I want you to make sure your witness is available. Stand by. We're having the jurors look at one of the photographs. Troutlow, would you retrieve the photograph, please? All right, let the record reflect that each of the jurors has had the opportunity to review and evaluate People's Exhibit 605. Ms. Clark, people may call the next witness.
Thank you. People call for Bill Rankin.
All right, Mr. Rankin, would you face Mrs. Robertson, the clerk?
Raise your right hand, please. Do solemnly swear that the testimony you may give in class now before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat. The witness stand and statements spell your first and last names for the record.
Name is Bill Renken, Billrenken.
Ms. Clark.
Good afternoon, Mr. Rankin.
Good afternoon, Ms. Clark.
Are you a professional photographer, sir?
Yes, I am.
And do you have a photo lab of your own?
I work with a custom photo lab, Western Hills Photo in Cincinnati.
Now, directing your attention to the date of January 6, 1991, can you tell us where you were on that date, sir?
I was at Riverfront Stadium covering a playoff game between the Cincinnati Bengals and the Houston Oilers.
And when you say you were covering the game, where was that?
That was at Riverfront Stadium.
In Cincinnati?
In Cincinnati, yes. Mm-hmm.
And were you covering it for the purpose of taking photographs in your professional capacity?
That's correct.
Can you tell us where you were when you took those photographs?
The series, I was on the sidelines.
And what sidelines were you on, sir?
I was on the Bengals side.
Did you take photographs of the defendant during that game, sir?
Yes, I did.
And how far away from him were you took those photographs?
I'd say approximately roughly 10 to maybe 15 feet away.
And did you cause one of those photographs to be enlarged?
Yes.
People's next in order, Your Honor.
606.
Thank you.
Is that correct, Mr. Robertson? 606.
Showing you people 606, sir. Can I ask you to tell us if this is a photograph that you took on January 6, 1991 in Cincinnati?
Yes, it is.
And does this photograph accurately depict the shot that you took?
Yes, it does.
1386, can you see that? 165, can you see that, sir? Yes, sir. Thank you.
Now, with respect to that particular, did you take photographs throughout the day during that game?
Yes, I did.
And did you take some at halftime, sir?
Yes, I did.
Did you also take some at the end of the game?
Yes, I did.
Can you tell us what time this one was taken?
I'd say it was, obviously that one is post-game after interview. It could be 5:30, 6 o'clock, Cincinnati time.
Can you tell us, sir, whether there was any artificial lighting when you took this photograph?
No, there wasn't.
Did you use a flash?
Not on this picture.
I'll show you another photograph, actually, that'd be marked People's 606A.
All right, people 606A, have you shown that to Mr. Blazier?
Mm-hmm.
All right, 606A appears to be a 8 by 11.
Yes, thank you, Your Honor. I'm sorry. 606A is an 8 by 11 showing the defendant holding a microphone turned towards his left. It's in a slightly different posture than the one that is 606. And showing you this photograph, sir, can you tell us if this is another photograph that you took of the defendant at the Bengals game on January 6, 1991?
Yes, it is.
And is this a halftime or post-game photograph, if you can tell us?
This is the post-game.
I was leaving the court. I'm going to ask to tape this one to the board as well. Is this, when I say this one, 606A?
606A. Mr. Troutlow.
All right. Now, you say you took photographs, sir, of the defendant during halftime as well?
Yes, I did.
I'm going to show you a photograph that is approximately 8.5 by 11 of appears to be the defendant holding an umbrella. This one is a vertical photograph, people 606B,
606B
and a horizontal photograph of the defendant holding an umbrella, people 606C.
and C.
Mrs. Robinson.
Showing you people 606B and C, sir. Can you tell us whether these are photographs that you took?
Yes, they are.
And are those accurate depictions of the photographs that you took on that date, January 6, 1991?
Yes, they are.
What color are these gloves, sir?
These have a brown.
May I ask that one of them be put on the Elmo for further questioning, Your Honor?
Which one?
And it'd be 606C?
606C.
Can you tell us, first of all, with respect to this photograph, when it was taken during the game?
This was taken at halftime,
And how far away from him were you when you took this photograph?
roughly 10, 15 feet.
Can you describe the weather?
Very kind of rainy, obviously. Damp.
Throughout the game?
Yes.
Now, for this photograph, sir, did you use a flash?
Yes, I did.
And was there any artificial lighting?
The artificial lighting was from the TV cameras. I mean, TV lights.
I mean the lights that are on the
Lights.
video cameras?
On the video cameras, or I'm pretty sure they might have had some lights that were on the field.
Can you tell us what kind of camera you used?
I use a Nikon. I have two Nikons, 8008 and FA.
And was there any special processing that you gave to this photograph?
Nope.
Or any of these photographs, sir?
Nope.
I'd like to mark one further photograph.
D as in David.
Yes.
606D.
D as in David. Do you see what appear to be raindrops or any moisture on those gloves, sir, on this photograph 606C?
Yes.
I'm going to show you 606D. Can you identify this photograph, sir?
Yes, it was a picture also taken after the game that was used without a flash.
And this is another photograph of the defendant wearing those gloves at that game?
Yes.
Was this a post-game or halftime photograph, sir?
Post-game.
So there was no artificial lighting for this photograph?
Right.
May I ask that the photographs 606C, B, C, and D be passed around to the jury, Your Honor?
All right, if you'll hand them to juror number 7. Thank you. Could you just hand them down as soon as you finish looking? Thank you. Lowe, would you retrieve those photographs, please, and may I see them, please? I'm sorry, Ms. Clark. Yeah. Thank you.
Your Honor, I have here photographs 606E through J that I've marked and shown to counsel. I'm going to show them to the witness and ask if he recognizes them. Can you tell us, sir, if you recognize those photographs I've just marked as 606E through J?
Yes, I do.
And what are those photographs of, sir?
Pictures of defendant
And
doing an interview, post-game interview.
can you tell us, as you review them, sir, if these are all post-game interview photographs that you took?
Yes.
Of the same game on January 6, 1991?
Yes, they are.
Your Honor, I'd like to place on the board at this time the photographs that I gave to the court, and we'll label them. For the record, that was 606A is on the board to the far right, Your Honor. I'm going to ask you to put up also 606B.
Mr. Rankin, would you hand this to Ms. Clark, please?
Thank you, Your Honor. Mr. Grable has double sleep. And 606 for you. Are these all true and accurate prints of the photographs that you took on January the 6th, 1991, sir?
Yes, they are.
If we may put the label indicating the date and the witness's name below those three photographs, 606 A through C.
You may.
Thank Your Honor, we have a we have a video clip that we'd like to show.
Mr. Reporter, please. Gentlemen, there's something I need to take a look at out of your presence. Let me ask you to just slip back into the jury room. We'll call you out probably in about 5 or 10 minutes. Run from the courtroom, and Mr. Bill Rankin is still on the witness stand. Ms. Clark, you indicated that you had a videotape
Yes, sir.
that you were going to play for Mr. Rankin to see if he can identify what's on the videotape.
Correct.
All right. And how long is this videotape?
How long is the video clip?
It's approximately about 7,800 frames, so
That tells me a lot.
about 4 minutes.
Okay. 2,000 a minute? Okay. All right, we'll mark the videotape then, prosecution next in order 607. All right, let's see the videotape. Mr. Fairlaw? Yep. All right. Clark.
Thank you. Mr. Rankin, do you recognize the videotape that is shown in this segment, sir?
Yes, I do.
And can you tell us if you were present when this film was being shot?
Yes, I was.
With relation to the photographs that you've testified to previously, 606 A through J, were these photographs taken during the game depicted in that videotape?
Yes, they were.
And do you recognize the videotape shown as being the game you were present at on January 6, 1991, when you took the photographs you've already testified to, sir?
Yes, I do.
Mr. Blazier? Any voir dire as to this issue?
Mr. Rankin, had you ever seen this video before today?
No, I haven't.
Had you ever been told you were going to be shown a video?
What's the relevance, John?
No, I haven't.
Now, was this video being taken while you were taking your pictures?
Mm-hmm. Yes, sir.
And how do you know that?
How do I know? Because
Yes.
I was there.
Well, but I mean, how did you know that this was the Kansas City Buffalo game that you were at?
Excuse
Okay.
me, that was the Bengals-Oilers game.
All right, Bengals Oilers.
Excuse me?
How did you know that that was the game that you were taking pictures at?
I was present.
How do you know that?
The video
Yes.
by the, well, for example, there were Bengal players running behind the defendant during the interview.
I'm asking you, how do you know it was the same game you were at versus some other Bengals versus Houston game?
Because it was a playoff game.
Okay.
And the weather conditions.
And what tells you about on this video that this is a playoff game?
Because of the nature of what the defendant's wearing, the total atmosphere of the video,
The atmosphere. What do you mean by the atmosphere?
people behind it, the weather conditionings.
That's all the questions I have.
All right. Counsel, I think there's a sufficient foundation at this point. It appears to be the same game. The post-game interviews with the coach and the quarterback appear to be the same individuals. They appear to be positioned in the same manner. It appears to be the same point in time as a post-game. It appears to be a video at the same time that these photographs were taken. So I think there's a sufficient foundation for the videotape. All right. Let's have the jurors again, please. And Ms. Clark will go to 3 o'clock. Make sure they're waiting in the wings. Okay, let me see counsel at the sidebar without the court reporter. Mr. Cochran, Ms. Clark. All right, thank you very much, counsel. Ms. Clark, you may continue.
Thank you, Your Honor. At this time, Your Honor, I'd like to mark the video clip as People's Next in Order 607. Before I do, hold on. First of all, Mr. Rankin, I'm going to ask you to look at this video and tell us if you recognize what is depicted in it.
It's defendant doing a commentary about, I imagine, probably the first half, scores, stats, overall commentary of the first half of the game.
And when you say the game, sir, what game are you referring to?
That was the playoff game with the Bengals versus Oilers
And where was that?
at Riverfront Stadium in Cincinnati.
And is this the same game from which you took, you previously identified still photographs that you took in 606A through J?
Yes, they are.
Okay, so this is a videotape of the game that we had the still photographs for from you.
Correct.
Can you tell us, noting the umbrella in the defendant's hand in this frame, sir, what time, at what point in the game this video is shot?
Well, again, it's at halftime, and it could be 2:45, around that area, 3 o'clock.
Thank you, sir. I'm going to play the rest of this video, sir, and ask you at the conclusion of the videotape to some further questions concerning what you see.
Sure.
Directing your attention to the defendant's left hand holding the microphone, sir, can you tell us if you see what appear to be raindrops on that glove?
Yes.
Thank you. Did you see rain or would it maybe rain or some kind of mild snow on the hat and jacket of, what's his last name? It's Isom, thank you. I was going to say boomer.
All right, this is at frame 5439.
Thank you, Your Honor. Do you see?
Yes, I do.
Thank you.
Bless you.
Stop. Back up one. Right there. Can you see the wrist area of the defendant's left hand in this frame 6775?
Yes, I can.
See an area of his flesh exposed underneath that wrist area, sir.
No, I don't.
That's on the defendant's right hand, sir.
No. It looks dark in nature.
Keep going. Recognize that? Do you recognize that video clip, sir?
Yes, I do.
And that's a clip of?
Bengals-Oilers playoff game, January 6, 1991, at Riverfront Stadium in Cincinnati.
Mm-hmm. Thank you, sir. I have nothing further. If I may ask that Mr. Fairglow hold up People 606 so the jury can see it. I think that it was just...
All right, thank you, Mr. Fairwell. Mr. Blazer?
Mr. Rankin, good afternoon.
Good afternoon, sir.
January 91 in Cincinnati, that's a pretty cold time of year there, isn't it?
Yes, it is.
And was it very cold?
It was cold, rainy, moist.
And it's not unusual, I take it there were a lot of other people in the stadium with gloves?
I imagine.
Brown gloves?
All different kinds of gloves.
They're not particularly unusual to have brown gloves in the cold and wet.
I assume.
In fact, did you notice in the video that everybody that was walking around in the background behind Mr. Simpson was also wearing gloves?
I didn't really pay that much of attention, but I assume in that climate of weather, individuals wear gloves of any nature.
Now, how cold was it that particular day?
Could have been in the 20s, early 30s.
Did you at any time get close enough to Mr. Simpson to determine whether or not he had a heat pack in the palm of his hand under the gloves?
No, I couldn't tell.
You know what I mean by a heat pack?
Yes, I'm familiar.
Have you seen those used at football games? Keep your hands warm?
Sort of.
Now, you notified the prosecution that you had pictures when, for the first time?
You need to answer that? It was June, around 26th.
And that was while they were still presenting their case in chief?
Sustained.
June 26th?
Around June 26th, Jack Webster, former employee of Europhoto, sent out the 20 by 30 poster print.
Okay. Now, I think you indicated that some of those pictures are at the beginning of the game and some are at the end of the game. Is that what you indicated?
Halftime and at the end of the game, right?
Do you have any from the beginning?
No, I don't.
All right, now the ones up here, which one is from halftime and which one is at the end of the game?
The ones from halftime, sir, are the horizontal, him holding the blue umbrella.
All right, the first one of your pictures on the left.
Yes.
I don't know what the letters are, Judge. And the one from after the game is the one on the right?
Yes,
Right. Now, was it raining during this whole game?
pretty much.
Did Mr. Simpson have an umbrella most of the time when he wasn't on camera?
There were times I remember seeing him without it in the runway area, but then when they did the interviews, except for the post game, there was no umbrella used, but the halftime there was.
Now, you notice in the picture that you've indicated is from the halftime, and you can come down here and look at it a little more carefully if you'd like to, that around the wrist area of the gloves, they appear to be bunched up like there's extra leather.
Oh,
You notice that?
Sure.
And that's consistent with what you saw that day?
well, I wasn't looking at his gloves.
Okay.
I wasn't looking at how they were bound up. I was just shooting the.
All right, Mr. Rankin, you need to speak so the jurors can hear you.
I was not so interested in shooting the gloves. I was shooting the individual at the time.
Now take a look at the one from the post game. You see also that it's bunched up around the wrist area? Here's the extra leather.
Seems that's not evidence, the photograph speaks for itself.
Oral.
Take a look at the after game. Would you agree that in all the pictures that you took, that you reviewed, it also shows that there's extra folds of leather in the wrist area?
Sustained.
Now, would you like to look at your other pictures and tell me if they appear to be consistent with the ones you just talked about on board?
Yes, they are, sir.
And those are all consistent with what you've told us about?
Yes.
Now, I think you indicated that the video was, the first part of the video was halftime,
Yes.
about 2:45, I think you said.
About that time.
Could we have the video started from the beginning, please? Stop, please. Back it up. Stop there, please.
0544.
See the time on the tape, Mr. Rankin?
Yes, sir.
That's not halftime, is it?
That's not halftime?
That's the beginning of the game, isn't it? Before the game.
Could be. It's. Oh, I see. Okay, that's the five. I'm sorry, I didn't understand what the 5:44. Okay. That's the actual time of the footage, right?
You're the one that identified the videotape. You tell me.
That's correct.
What?
That was quite a while.
It's 12:03, doesn't it?
Excuse me?
The video indicates 12:03, doesn't it?
Yes.
And that's the pregame, isn't it?
Oh, okay. Excuse me. That was the pregame interview.
And you see down on the right hand, by the wrist area, you see that same bunching up?
Objection, characterization, Your Honor.
Sustained.
Does the video here, the right-hand area, the wrist, look the same as your pictures?
Yes, they do.
Ms. Clark? Well, give my regards to all my friends in Cincinnati. Thanks a lot.
I will do, Judge.
Thank you.
You're welcome.
Thank you. Other people call Kevin Shoutout.
All right.
Maybe
Sure. Madam Reporter will finish this one. All right, thank you, counsel. Ms. Clark, you may call your next witness.
People call Kevin Shoutout.
All right, Mr. Schott, would you just stand right here by the court reporter, please? Face Mrs. Robertson, our clerk.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the cause now pending before this court should be the truth, the whole truth, and nothing but the truth, so help you God. Please have a seat at the witness stand and state your first and last name for the record.
Kevin J. Schott, Kevin J. or Schott.
All right, Ms. Clark, I'm sorry, do we have a correction? Thank you. Ms. Clark.
Mr. Shaw, can you tell us what you do for a living?
I'm a teacher.
And what do you teach, sir?
I teach photography.
And where is that you teach photography?
Orchard Park High School
And where is that?
in Orchard Park, New York.
New York?
Correct.
How do you spell that? Orchard?
Orchard Park,
I'm
correct.
sorry, I misunderstood you. Thank you.
Try and keep your voice up.
Okay.
All right, sir, directing your attention to the date of November 21st, 1993, can you tell us where you were on that date?
I was at Rich Stadium in Orchard Park, New York,
And for what purpose were you at that stadium?
to take photographs for my students.
Was there a game going on at that time?
Correct.
What game was that?
The Buffalo Bills against the Indianapolis Colts
And where did that take place?
at Rich Stadium,
In what state?
New York,
Is that upstate New York, sir?
Western New York.
Now, while you were there, sir, did you take photographs?
Yes, I did.
Going to show you, and did you send us some photographs, sir? By us, I mean the district attorney's office.
I didn't, my lawyer did.
I have a photograph here. I'd ask be marked People's Next in order 608. Show you people 608 and ask you, sir, if this is the photograph that you sent to the district attorney's office.
It is a photo that I sent to my lawyer.
And is that the photograph that you took at the game on November 21st, 1993 in New York?
Yes, it is.
Going to show, ask that I have 3 other enlargements, Your Honor, 608. If they could be marked 608 A, B, and C. First of all, A, full face of the defendant.
Actually appears to be from the waist up.
From the waist up, Your Honor, thank you. 608B, a close-up shot of his right hand holding the glove.
Actually appears it's a white gloved hand holding a microphone is what it appears to be.
A black gloved hand on the microphone. And a close-up of the defendant holding the microphone in his right hand. Let me see if I can distinguish it. That does not go as far down as his waist. People 608C.
All right, so marked.
Showing you these photographs, sir. That's 608A, B, and C. Can you tell us if you recognize these photographs?
Yes, I do.
How do you recognize them?
They're photographs that I took at the game.
Now, can you tell us, sir, where you were when you took these photographs?
I was on the sideline of the Buffalo Bills, and I was on the Bills side.
So you were actually on the field?
Correct.
Can you tell us how far away you were from the defendant when you took these pictures?
I would say approximately 10 to 14 feet.
Do you recall what kind of camera you used?
A Canon EOS 630.
Did you use a flash, sir?
No, I did not.
Can you tell us what time of day it was when you took these photographs?
Approximately 11:30.
And what was the lighting conditions? What was the weather like?
Relatively sunny. I believe it was a little cool towards the morning.
Now, did you send the negatives to us for these photographs for authentication?
I believe my lawyer did, yes.
May I ask that the photographs be taped onto the board, Your Honor, and labeled?
Yes.
As indicated?
All Mr. Fretlow?
May I ask that while Mr. Fairford doing that, we pass around one of these 608A?
All right, 608A, if you hand that to juror, just hand it to juror number 165. Let's make him first for a
Thank you,
change.
John.
The record's clear, that's 608C that you've handed to 165.
Thank you, Your Honor, yes.
All right.
On the board, Your Honor.
Yes.
Label indicates Kevin Schott, 11/21/1993, Colts versus Bills. The development of these photographs, sir. I'm sorry.
It's corrected. The photograph that's actually being passed around that 1386 has right now is actually 608A. All right, the record should reflect that each of the jurors has had the opportunity to view 608A. Ms. Clark?
Thank you, Your Honor. Did you send these photographs out for development at a lab?
The film to be developed?
I'm sorry, yes.
Yes, I sent the film out to be developed.
All right, was there any special processing that you requested on this film?
No.
Maybe.
Mr. Blacher?
Take care.
Good afternoon, Mr. Schott.
Good afternoon.
How are you doing?
Fine, thank you.
November of '93 is when these pictures were taken, correct?
Correct.
In Buffalo.
In Buffalo.
Do you live in Buffalo?
I live in Orchard Park.
Is that near Buffalo?
It's near Buffalo.
November in the Buffalo area generally isn't cool. It's generally very, very cold. Was this an unusually warm day or a cold day?
I'm not a weatherman, but in Buffalo, in November, we could have some days where they start out cool. For example, today I believe it's getting warmer, and the afternoons can warm up.
Okay, but in November, I mean, we're just in early
Correct.
September.
Right, but in November, you could have some nice days where it's cool in the morning, and then it will warm up.
Okay. How many people were in the stadium, roughly, if you know? Was it sold out?
My best guess is yes, it was, but I don't know that for a fact.
A lot of people wearing gloves?
I don't believe so. I wasn't looking for that.
Okay, so you don't know.
I really don't know.
Was there anything particularly unusual about wearing gloves on that day?
No.
Do you have men's gloves?
Yes, I do.
Now, are these the only pictures that you took?
No, they're not.
Okay, and where are the other pictures?
I take it you were referring to that afternoon.
Yeah, I meant that afternoon of Mr. Simpson.
Mr. Simpson?
Yes.
I believe the district attorney has what I printed up.
Okay. But these are the ones that you've identified here in court today, and that's actually only two different pictures, is it? Am I correct in that?
Correct.
Now, I think you indicated you have a lawyer
Yes, I do.
dealing with these pictures.
Yes, I do.
When did you send these pictures to the prosecution?
Objection made.
I,
Sustain. First question.
When did you send the pictures that you took of Mr. Simpson to the prosecution?
Objection made.
Overruled.
I talked to my friend who happens to be my lawyer, and I believe it was somewhere between June 23rd and June 26th
This year.
of this year, 1995.
Did you try and sell them to Inside Edition before you sent them to the prosecution?
I did not try to send him an Inside Edition.
Did your attorney on your behalf try to sell them?
I don't believe he did either. I'm not sure.
Was contact made with Inside Edition to try and negotiate the sale of these pictures?
It may have been, I don't know.
Did you authorize him to do that?
No, I did not.
He did it on his own?
Speculation.
Sustain.
Were you aware of your agent, your attorney, was attempting to sell these pictures?
Objection. Mischaracterized. Mistake. Objection.
Sustain. First question.
Do you have any knowledge of your agent, your attorney, trying to sell these pictures on your behalf?
Objection. Mistake. Testimony.
Overruled.
I don't know what he was doing. I just submitted the photos to him, and I asked him to look into it for me.
Look into what?
Look
How much
into-
you could get for them?
No, I asked him to look into sending to the prosecution to share the evidence.
When did he contact
Or-
Inside Edition, if you know?
I don't know if he did.
Objection. Your Honor, assumes Scott not evidence.
Sustain.
Who's your lawyer?
He's indicated he doesn't know if it happened.
Who's your lawyer?
Robert Lee.
Is he here with you?
Yes, he is.
Where is he? In the courtroom?
No, he isn't.
Upstairs?
Yes, he may be.
No. Will he be around after court today?
I believe so.
That's all I have this time.
All right. Any redirect, Ms. Clark?
Are you paying Mr. Lee, sir, for his services?
No, I'm not.
How long have you known him?
Long time. I can't put a time on it.
Is he your friend, sir?
Yes, he is.
Is he acting as your agent in any capacity?
He may be. I don't know. He's just a good friend helping me out.
Now, you said you took other photographs other than these that depict Mr. Simpson in the gloves?
Not in the gloves. No, I have other photos of Mr. Simpson.
Okay. In which he's not wearing gloves?
Correct.
And did that involve another event during this game?
Yes, it did.
Did you show those?
Let's wind it up.
Did you show those photographs to me yesterday, sir?
Yes, I did.
And was that the first time you shared those photographs with the prosecution?
I believe it was.
And where do you teach photography, sir?
At Orchard Park High School.
Thank you. I have nothing further.
Pleasure. All right. All right, Mr. Schott, thank you very much, sir. You're excused. Thank you for coming out. All right, ladies and gentlemen, we're going to take our recess, mid-afternoon recess. Remember, all my admonitions to you will be in recess for 15 minutes, all right? Thank you, sir. The Simpson matter, all parties are again present. Jury is not present. Mr. Blazer?
Yes, Your Honor, two things. I asked the prosecution right after we broke if I could talk to Mr. Lee, Mr. Schott's attorney, as I may want to ask him one or two more questions, and I'm waiting for that. Also, I asked LAPD to bring over item 94, which was a glove taken from Mr. Simpson's residence, that I'd like to have lodged with the court. I don't know if I'll use it, but Detective Van Hatter needs it to be lodged with the court so he can account for it.
Okay. We'll mark the glove then. Ms. Clark will mark it People's 609 for identification purposes. 609. Yes, please, Detective, thank you. And is it a glove or a pair of gloves?
A glove.
A glove. A glove. A glove and paper bag. Do you want to see that first?
Yeah, I bag it.
Ms. Clark, have you seen the contents?
Yeah, a long time ago. We all have.
Yeah, very quick schedule matter. About P&As on Dr. Dutton's testimony with the court. I think Mr. Bailey has some counsel. I just want to know when the court wants to address that matter. Is it with the other?
Haven't even seen it yet.
No, I understand. I understand. This afternoon?
I'll take a look at it at the conclusion of the court day, see what it is, and see when it is I want to do it.
That's right. So not this afternoon?
No, not this afternoon.
Okay.
We have RFLP set for this afternoon. All right, Ms. Clark, is Mr. Lee available to chat with Mr. Blazier before we move on?
Yes, Your Honor. I asked immediately at the break when Mr. Blazer informed me he insisted on speaking to him that I asked that he be called down, and it just took a while, but he's coming down and he will speak to Mr. Blazer.
All right, Mr. Blazier, you want to chat with him briefly before you move on?
Yes, also, if we could have the next witness, so I can take my cumulative objection.
Okay, Mr. Blazer saying that, Your Honor, because I already told him that I would, I voluntarily have eliminated three more witnesses to black gloves. And I would propose to conclude the glove presentation with Stuart West and Mike Romano and Deborah Gadara.
All right, are these all brown glove people?
No, two are black glove and the last one is brown glove.
All right, why are we doing black gloves?
Because those particular photographs show a fit that is very significant for the witness, Richard Rubin. These are very brief. Neither one of them involves video. And they're very late in time. One's December of 93, the other one's January 94. We've already, you know something, Your Honor, we have eliminated from our list now 7 witnesses that we had proposed to call because the court keeps indicating that it's going to rule these things cumulative. We have pared it back now to the very bare bones. This testimony is not, in fact, taking very long.
Be that as it may, it still doesn't mean it's not cumulative. One, we got brown gloves, not black gloves. I mean, wouldn't you have put on your most recent black glove person first?
No, I didn't, because I need to lay a foundation in the beginning and at the end, Your Honor. No, this is important. This is important, Your Honor, because Nicole Brown bought him these gloves in December of 90, that's right. She bought them on December 18th of 1990. It is important to show him wearing the gloves close to the date of purchase as well as close to the date of the murders. And that's what we are attempting to do, is to show a course of wearing these gloves from the time that they were purchased to the time of the murders. And that's obviously important, Your Honor.
They have an early one, and Mr. Schott is December of 93. That's a late one. We have 2 sets of black pictures.
That's November of 93, not December.
Okay.
What's your latest black glove?
May I show you the photographs we want to show, Your Honor?
What is your latest black glove, Counsel?
January 94.
And who is that?
That's Mr. Romano. And it's important, may I show you, Your Honor, the photographs that we have?
Well, why do we need, first of all, the gloves that are in evidence are the brown gloves, not the black gloves.
I understand that, Your Honor. But the nature of the fit is very important, obviously, in this case. And I would like to show you the photographs we're talking about so you will appreciate what I mean.
Thank you. All right. right, which one is which? One, Mr. Simpson appears to be wearing an NBC turtleneck.
The horizontal photograph in which he's wearing the turtleneck that's taken indoors is the January 94 photograph. And you can see the Eris label in it. You can also see the cashmere lining in that photograph.
I dispute, you can see the label, but they're black.
All right, now the vertical photographs where Mr. Simpson appears to be holding a lineup, and it appears he's putting the gloves on or taking the gloves off.
No, Your Honor, he has one hand against his chest and it shows the very short and tight fit of that glove. The other hand is in front of it holding papers. And that's December of 94.
You can see that one bunched around his wrist and he's pushing the fingers in. I mean, it's...
One hand is not touching the other.
black hole.
Also, you should note on the wrist of that particular photograph, Your Honor, you can see the kind of stitching which is important to the testimony of Richard Rubin, the expert on this matter. And the bunching that Mr. Blazer continually refers to is going to be explained by Mr. Rubin as well, as being reflective of the fact that it's very thin leather that rolls and puckers, which is consistent with the Eris-like glove. I would also point out to the court that those two photographs that are most close in time to the murders of the black gloves show features that none of the other ones do, both of them. They show the manner of the dip and the stitching of the wrist area, as well as the lining and on the other photograph, the lining and the Eris-like pad.
Sounds like they saved what they thought was the most probative for last to avoid cumulative objections.
No, Your
To me.
Honor, we're showing an evidence of wearing these gloves that is consistent over a period of time, both early on and late on. Obviously, there are a great deal more we could have shown, but we voluntarily excised them from our presentation. And if you look at the photographs that we've already presented, Your Honor, they show the hand in various positions, one with the palm out, one with the palm closed, which shows the fit when the fist is closed. And shows how short, in another set of photographs, shows how short it is on the wrist.
All right, the one that is the horizontal photograph that has the label coming out, the one that depicts the wrist area and what appears to be the lining, that is a different perspective than the others.
The other black photograph, Your Honor, is also a different perspective from the others. Showing the stitching on the wrist. I mean, it's very important because we had two sets of gloves purchased in December of 1990 of the same type. And his ability to identify both the black and the brown gloves in these photographs as the same type is of obvious probative value. To the extent that the court cuts photographs out, because the court is chipping away from the credibility of the witness.
What other witnesses do you have with brown gloves?
One more witness on brown gloves. Plus video.
I haven't seen that video. I think
What-
that's part of a ton of video. It's expected.
What video is this?
The Gadara, the same game that Ms. Gadara is going to testify about, I still don't have that. No, I don't think I have it.
All right, is Mr. Lee here?
I believe Mr. Lee is here.
All right.
May I indicate to the court, the videotape you're talking about was subpoenaed. It's
Well,
already.
let's not,
All right.
let me figure these things out first. All right, Ms. Clark, do you anticipate the direct examination will be the same 5 minutes?
That's right,
Did you
Your
take
Honor.
these photos, where and when?
Exactly. No.
5 questions?
That's right. There's no video with these, it's pictures.
All right, I'll overrule the objection. They do show different perspectives,
Thank you,
especially
Your
the
Honor.
label. All right, Mr. Blaze, you want to take a few moments to talk to Mr. Lee? And for the record, Ms. Clark, who are the witnesses that you've excised?
Yes, for the record. Karen Brown, James Chegia, Robert Sieg. That was most recently. Prior to that, Flash Jordan Zala, Richard Roman, Kristen. I forgot the first name. Last name is Kristen, Your Honor.
All right, is Mr. Schott available in the event Mr. Blazer wants to recall him?
I believe so. I believe he's upstairs.
How about in an abundance of caution, why don't we have him escorted down so we can save some time in the event Mr. Blazer wants to recall him for a question or two?
Sure.
Mr. Fairlow, why don't you accomplish that? Mrs. Robertson? Waiting, can I see 608 again, please?
Is that 608A?
Any of them. Anything that has to do with 608. That's shot. I can't see, it's turned away. All right, thank you. All right. All right, Mr. Blazier.
Yes, Your Honor, I'm prepared to go to the next witness. However, we may wish to call Mr. Lee out of order so that he doesn't have to fly back at some other time. But we're still considering that.
Okay.
They have a rebuttal if they think he's relevant. Let them make an offer.
All right, let's proceed.
Thank you.
Next witness.
People call Mr. Stewart West.
All right, let's have the jurors, please.
Let them do it on their dime.
Stuart West.
Yes, no. Oh, I guess we need to.
Minor detail. Gentlemen, please be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Ms. Clark, you may call your next witness.
Thank you, Your Honor. Call Mr. Stewart West.
All right, Mr. West, would you step over here next to the court reporter, please, and face the clerk?
Raise your right hand, please. You do solemnly swear that the testimony you may give in the trial not only before this court, be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I did.
Please have a seat. Would you stand and state and spell your first and last names for the record?
All right, Mr. West, would you please state and spell your name?
My name is Stuart West, S-T-E-W-A-R-T-W-E-S-T.
Thank you, sir. Ms. Clark.
Mr. West, can you tell us if you are a professional photographer, sir?
I am not right now, no.
Were you at some time?
Yes, I was.
When?
Started in 1989
Until
until about November of last year.
94?
Yes.
Directing your attention, sir, to the date of December 25th, 1993. Can you tell us if you were a professional photographer at that time?
Yes, I was.
Can you tell us where you were on that date?
I was at Candlestick Park in San Francisco.
And for what purpose, sir?
I was taking pictures of the San Francisco 49ers Houston Oilers game.
And where were you in terms of in the stadium?
I was on the sideline on the 49ers side.
So were you on the level on the field itself?
Yes, I was.
Did you see the defendant there when you were there?
Yes, I did.
About how far away from him were you?
I was approximately 30 feet away from him.
And he was on the field as well, I take it.
Yes, he was.
Was there any artificial lighting at that time?
Not that I remember, no.
And you took photographs of him at that game?
Yes, I did.
Your Honor, I have here a photograph that I'd like to be marked People 610.
All right, People 610.
A small photograph, sir, showing you People 610. Can you tell us if you recognize what I've shown you?
Yes, I do.
What is that?
That is my photograph.
Is that the photograph you took of the defendant on December 25th, 1993?
Yes, it is.
And did you send it into the district attorney's office, sir?
Yes, I did.
May I put it on the envelope, Your Honor?
You may.
I have here, Your Honor, two enlargements. I'd ask you to mark People 610A First one is 610A, shows the defendant. It's an enlargement of photo 610, Your Honor. Show you people 610A and ask you if you recognize what's shown there.
Yes, I do.
What is that?
That is a photograph that I have taken.
And is that an enlargement of the photograph that was shown to you just now that's up on the screen as people 610?
Yes, it is.
True and accurate copies, are they, sir?
Yes.
Showing you people 610B, does that appear to be a further enlargement, focusing in more on the gloves of the same photograph?
Yes, it is.
Also a true and accurate copy of your photograph, sir?
Yes, ma'am.
And did you send the negatives to the district attorney's office for authentication to make sure that these were accurate photographs?
Yes, I did.
All right, Your Honor, I just simply ask that these be affixed to the board, the photograph 610 and A and B with label.
All right, what's shown, Mr. Blazer first?
The label indicating, Your Honor, Stewart West, 12/25, 1993, 49ers versus the Oilers.
Yes.
Thank you, Your Honor. And this game, was it played in San Francisco, sir?
Yes.
Anything else? Nothing further.
Mr. Blazer?
Thank you, Your Honor. Good afternoon, Mr. West. How are you?
Fine, thank you.
Mr. West, could I ask you to take a look at the blow-up on the board here? And can you see in the picture where the right glove appears to be tucked under around the wrist area, or actually above the wrist area?
Yes, I can.
You have no way of knowing from this photograph how far that's tucked under, do you?
No, I don't.
Do you have any pictures showing the inside of the glove?
No, I don't.
Any showing any labels?
No.
Any lining?
No.
Now, you provided the prosecution with another picture in addition to this one, didn't you?
That's correct.
All right, I'd like to have this marked as defendant's neck.
I'm sorry? 1371.
We furnished Mr. Blazer with one that doesn't have holes in it.
Thank you.
Now, Mr. West, take a look at 1371. Is that a picture of the same glove?
Yes, it is.
Same day?
Yes.
Around the same time?
Yes.
Can I put this on the envelope, please, Your Honor?
You may.
Mr. West, you see how the gloves go all the way back on the wrist?
Yes, I do.
Yes, and that's all fluid in.
Overruled.
Powerful speculation, Your Honor.
Overruled.
Prosecution tell you they were only going to put in one of your pictures?
No.
No further questions. But, I'm sorry.
Didn't the court rule that some of these were cumulative?
Overruled.
Yeah, midterm. One final question. These are black gloves, aren't they?
As far as I can tell, yes.
Thank you.
Can you redirect? All right, Mr. West, thank you very much for coming in. Your excuse, sir. Ms. Clark.
Thank you. Your Honor, can Mr. Fairhill please put the small photograph up on the board as well? Let's keep it 6:10.
Yes.
Thank you. People call Mike Romano.
All right, Mr. Romano, would you come over here and stand by the court reporter, please? And face the clerk.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the class now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please have a seat. The witness stand and state before you first and last name to the record.
Michael Romano, Michaelromano.
All right, Mr. Romano, just sit back and why don't you pull the microphone closer, please? Thank you, sir. Ms. Clark.
All right, Mr. Romano, are you a freelance, are you a photographer, sir?
Yes, I am.
And what kind of photographer are you?
Freelance photographer.
And directing your attention, sir, to the date of January the 15th, 1994, what was your occupation at that time?
I was a photographer.
And on January 15th, 1994, sir, where were you?
I was in Buffalo, New York.
And why were you there?
I was photographing the Los Angeles Raiders football game against the Buffalo Bills.
Can you tell us, sir, if you took any photographs of the defendant on that date, in January of 1994?
Yes, I did.
And where did you take photographs of him?
I shot a photograph in the media room after the football game.
And where is the media room, sir?
The media room is adjacent to the locker room where they bring the players after the game.
And now the photograph that you took of the defendant, did you sell that photograph to someone, sir?
Yes, I did.
Who'd you sell it to?
The National Enquirer.
Are you here under subpoena, sir?
Yes, I am.
You did not ask to come here, is that right?
No, I did not.
I'm going to show you a photograph, Your Honor, people's 611 and 611A.
611, 611A.
Showing you people 611, sir. Can you tell us if you recognize the photograph that I'm showing you?
Yes, I do.
And what is that?
That is the photograph that I shot.
And you shot this photograph, you told us, in the media room, that's just a room just outside the locker room.
Right, where they hold post-game interviews.
Now, was that in New York?
Buffalo, New York.
And the photograph that's been marked people 611A, can you tell us if that is an enlargement of
Yeah.
the portion of the photograph in 611 that shows the defendant's left hand?
Yes, it is.
And is it an accurate enlargement, sir?
Yes, it is.
If I may show this on the Elmo, Your Honor?
You may. Which photograph was this?
611 first, Your Honor.
Mr. Romano, just look at your monitor and see if you recognize it. Ms. Clark.
Thank you. Now, this photograph, sir, is this the photograph you took of the defendant on January 15th, 1994 in the media room?
Yes, it is.
And how far away from him were you when you took this photograph, sir?
About a distance of 3 to 5 feet.
Showing you people 611A. From 3 to 5 feet away, sir, did you use a zoom lens then?
No, I didn't. I used a 50-millimeter lens.
Do you recall what time it was?
It was about 4:30 in the afternoon.
Did you use a flash, sir?
Yes, I did.
Do you recall what the film speed was?
200 ASA?
Now, did you send us negatives so that we could verify the accuracy of the print?
Yes, I did.
And when you sent your negatives to a lab for processing, did you ask for any special processing?
No, I don't.
Do you see? Strike that. I have nothing further.
Mr. Blazier?
Good afternoon.
Good afternoon, sir.
This was in Buffalo
Buffalo, New York, yes.
in January of '94, correct?
Yes, it was.
What was the temperature?
It was about 30, 35 below zero.
Very cold, wasn't it?
Very uncomfortable.
A lot of people wearing gloves?
Yes, sir.
A lot of people with hand warmers?
Yes, sir.
Kind of hand warmers that slip under a glove in the palm?
I wouldn't be able to see that, but I imagine.
So you have no way of knowing whether Mr. Simpson had one of those under his palm there, do you?
No, I don't.
Can we have that back on the Elmo, please? Now, those gloves are black, aren't they?
Yes.
The bulkiness around the fingers, is that consistent with your recollection of what they looked like at the time?
Objection to fact, not evidence.
Oral. Oral.
No foundation.
Oral.
Yes.
And the rolled up area, the extra leather at the wrist there?
Objection to characterization.
Sustain.
That's all.
Ms. Clark?
Sir, what, do you see that white oblong thing sticking out of the edge of the wrist area of that glove?
Yes, I do.
You see the arrow pointing to it, sir? Does
Yes, I do.
that appear to be the tag attached to the glove?
Objection. Speaks for itself.
Sustain.
What does that appear to be to you, sir?
Objection. Speculation.
Oral. You can answer the question.
It appears to be some sort of tag attached to the glove.
Can't read anything on that, can you?
Looking at the photograph, no, I can't read anything.
Is that it?
Yes, may I ask that these photographs also be attached to the board later, Your Honor?
Yes. All right. Do you have any further questions for Mr. Romano?
Nothing further.
Mr. Blazer, anything else for Mr. Romano?
No.
All right, Mr. Romano, thank you very much for coming out, sir.
Thank you, sir.
People call Mr. Deborah Gadara.
All right.
Miss. That's it, Mr.
You did. All right, Ms. Guidera. All right, would you step around here, please? Stand over by the court reporter and face the clerk.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the following before this court will be the truth and whole truth and nothing but the truth so help you God. I do. Please have a seat. The witness stand and state your spell your first and last names for the record.
Deborah Gadara, Debraguidera.
Ms. Clark.
Thank you, Your Honor. Ms. Gadara, can you tell us, are you a professional photographer, ma'am?
No.
Have you ever been one?
No.
Directing your attention, ma'am, to the date of December 12th, 1993. Can you tell us where you were on that date?
I was at Giant Stadium in East Rutherford, New Jersey.
And why were you there?
I was helping out a friend as a photo messenger that day.
Can you tell us what the weather was like that day?
It was very cold.
Now, while you were there, the friend that you were helping, what did he do there?
He works for the Associated Press.
Was he a photographer?
Yes.
And can you tell us where you were in the stadium?
I was on the football field.
Were you at the sidelines?
Yes.
On whose side?
On both sides. Oh, actually, on the Colts side. As when I took the picture.
Okay. Now, when you say the picture, did you have a camera with you that day?
I did, but it wasn't mine.
Whose was it?
It was my friend's.
Now, I have here a photograph, Your Honor, asked that it be marked people 612.
Right, 612.
And then there'll be two enlargements.
612A and B.
Yes, thank you, Your Honor. The farther away enlargement, 612A, close up on the hand area, 612B.
So marked.
Thank you. Ms. Gadara, I'm going to show you a photograph that's been marked as People's 612 and ask if you recognize this photograph.
Yes, I do.
Is that a photograph that you took, ma'am?
Yes.
And is it a photograph that you took on December 12th, 1993 in New Jersey in the Giant Stadium?
Yes.
And do you recognize the person depicted in that photograph?
Yes.
Who is it?
OJ Simpson.
And how far away from him were you when you took that picture, if you recall?
I'd say about 10, 12 feet.
Can you tell us what colored gloves are depicted in this photograph?
They look dark brown.
All right, you place 612 on the elbow.
They look dark brown or black.
I'm going to show you what's been marked now as people 612A and 612B. Do these appear to be enlargements of the photograph that you see here in 612?
Yes.
And are they accurate enlargements of the photographs you sent us?
Yes.
Now, you indicate that you were approximately 12 feet away when you took this photograph?
Yes.
Certainly.
Your Honor, may I ask that the photograph marked people 612 be passed around?
All right, small photograph.
It is.
All right, hand that to juror number one, please. Juror number one.
May I ask that Mr. Fairtlow be permitted to put up the A and B?
Yes.
Thank you.
Would you collect the photograph 612 from Deputy Smith, please? Thank you.
May we also fix that to the board, Your Honor?
You may.
Now, let me ask you a further question, Ms. Gadara, about the date. Do you independently recall what day it was?
A Sunday.
It was a Sunday? Is that yes? You have to say it out loud for the record.
Yes.
Okay. And what month was it?
December.
Of 1993?
Yes.
And do you know if it was before or after Christmas?
Before Christmas.
And what date was it? What Sunday was it? Do you know?
The 12th.
Okay. Your Honor, the label that I have here indicates only 12 of 1993. May I ask that we be allowed to make a new label indicating 12/12/93 for the purpose, before we put it on the board?
Yes. Do you have any further questions for Ms. Gadara?
Very briefly. Ma'am, was there any artificial lighting when the photograph that you took of the defendant in those gloves on December 12th, 1993 was taken?
No.
Did you use a flash?
No.
And did you send the negatives to us for the purpose of verifying the accuracy of the photograph?
Yes, I did.
Mr. Blazier? Yes, you may. All right, let's have it quiet, please. All right, Mr. Blazier, you ready to cross-examine?
Yeah, sure. Yeah, Ms. Gadara.
Hi.
How are you?
Okay.
This was a December in 1993 in San Francisco, correct?
No.
I'm sorry, in New York.
No, New Jersey.
New Jersey. How cold was it?
Very cold.
Very cold. A lot of people wearing gloves there?
I guess so.
Not particularly unusual to see people wearing gloves at a football game?
Overruled.
No, it's not unusual.
Okay. Now, I want to take, I'd like to remove one of these if I might. And could I put this on the envelope for you?
And which one is this, Mr. Blazier?
This is 612. I don't know. A. we back out on that, please? Now, Ms. Gadara, do you have an independent recollection of being there and seeing Mr. Simpson
Yes,
and looking at him when you took the picture?
yes.
When you look at that glove in person, was it as loose as it appears to be in the picture?
Overall.
I can't recall.
Okay. The picture is the best record of what you saw. Now,
Yes. You're shaking your head. Is that?
Repeat the question?
this picture is your best depiction of what you saw that day.
Yes.
Okay. Now, could we have the back up just a little more? And could you zoom in on in the lower right corner? Mark. And could we have a circle around that glove, please? Ms. Gadara, do you recall seeing the person standing behind Mr. Simpson wearing gloves?
Right now I do, yes.
Okay, appear to be the same kind of gloves that he was wearing?
I don't think so.
May we have that printed out, please?
Yes. We'll mark that as, let's make that 612 C.
I'd like to show the witness people six.
Dane. Record to reflect that the reference was made to 609. 609. Ms. Clark, any redirect for Ms. Gadara? All right, Ms. Gadara, thank you very much for coming in. You're excused. Next witness.
Richard Rubin, the glove man.
All right, let me see counsel at the sidebar without the court reporter. Gentlemen, there's something I need to take a look at before we hit the next witness. Let me ask you to step back into the jury room. All right, the record should reflect all the jurors are withdrawn from the courtroom. Ms. Clark, you indicated you have a compact disc-based video. May I see that, please?
Yes.
All right, let's clear the telestrator, please. All right, Mr. Orman, I don't have anything on my monitor. Mr. Blazer, do you have this on your monitor?
I do now.
Ah. Please. Appears to be a different clip.
Yes, Your Honor, that was the end of the sentence.
Ms. Clark.
Your Honor, the shot of the defendant in the brown coat, or the brown glove, is the one that we do not have, I believe, in the still photographer report.
It's pretty good digital quality.
The detail that's shown in this video drawing was important to Mr. Rubin for the purpose of determining whether the stitching was consistent with the stitching of the crime scene.
Your Honor, may we have Mr. Rubin leave, please?
Yes, Mr. Rubin, why don't you wait outside?
Mr. Rubin would like to be here when we discuss the issue of scheduling, however.
Scheduling? Sure. Yeah, why don't you just wait outside, Mr. Rubin? Thank you. All right, Ms. Clark, as to record to reflect that Mr. Rubin's withdrawn from the courtroom. With regards to this 15-minute clip that's on the compact, is it a laser disc or compact disc?
It's on a laser disc, Your Honor.
All right. Objection?
Yeah, well, Jack, first of all, it's cumulative. It's another brown glove. I don't think it shows anything more than what they've already put pictures on. I don't know, object to a foundation. They haven't established the foundation. So I object on both of those grounds.
Don't know when it is.
Let me get that for you, Ron. But let me simply, but let me indicate this to the court. I understand the objections to cumulative nature in the black glove, and we pared that down considerably, but all shots of the brown gloves that are deemed to be, by our expert, consistent with those purchased by Nicole Brown and those found at the crime scene and at Rockingham are clearly not cumulative, because it shows the defendant not only having them at a point in time shortly after they were purchased, but also at a point in time, also shows his habit and custom of wearing them, which means they're out in the weather. The more he wears them, the more important that is to their stretchability, and as close as possible in time to the murders. This clip that is shown in the brown gloves is of the Kansas City versus the Bills on January 5th, 1992. It's an important video for the expert because, as the court can tell, it's very clear in its depiction of the nature of the stitching on the fingers, the Brosser stitching on the back of the hand, and these are distinctive features to be able to identify these gloves as the type and class purchased by Nicole, and coincidentally, the type and classification of gloves found at Rockingham and Bundy. I don't know what other justification needs to be made.
Well, I understand the justification. How are you going to lay the foundation for it? I recognize the person depicted. Question is when.
Right. And for that purpose, Your Honor, we subpoenaed the representative from NBC. NBC responded by sending an affidavit to the court. I believe the court is in possession of that?
Yes,
And then-
received it this morning.
Yes. If I may ask leave of the court to ask Mr. Yokelson to come down to indicate to the court, because he's had all the interaction with them. They've been very uncooperative. I would ask that the court inquire of Mr. Yokelson, because it's my understanding that the attorney, Ms. Edgerton, has indicated that her position on behalf of NBC is that the court can force the parties to stipulate to the admissibility of the clip without the necessity of a custodian appearing. And we have indicated to her the contrary repeatedly.
Well, federal courts can in civil cases.
Pardon?
Never mind.
Anyway, may I ask leave of the court to have Mr. Yokelson address the issue, since he has been in contact with them?
Because I think foundation is going to be necessary, at least place and time.
And I don't disagree. I totally agree with the court. We're being hamstrung by witnesses that are simply refusing to come in and testify. And we need the court's assistance.
How about if I turn off the video, and let's see how long it takes NBC to cooperate.
I bet it'll work.
All right. Well, let's do it.
Okay.
Okay.
Deal.
All right,
In the meantime,
Where's Mr. Yokelson?
let me get him down.
All right.
He's on his way.
All right.
I'm going to call and make sure that it's on its way, but I specifically asked that he address you.
All right. Mrs. Robertson? Mrs. Robertson, have we heard from Miss Edgerton lately? Mrs. Robertson. Particular affidavit from Mark Laplace concerning the particular outtake that you're discussing here?
The brown blood photograph,
Yes. Yes, the one that you just showed me.
I'm waiting for Mr. Yochelson for his job. He's in possession of all of that.
All right, do you know what game this is? I'm sorry. Which football game is this?
It is Kansas City. Kansas City? Yeah. Kansas City Chiefs versus the Bills
On what date?
on January 5th, 1992.
Now, the fact that this is all right, what's the source of this? All right, records reflect we've now been rejoined by Mr. Yochelson. Good afternoon. Mr. Yochelson, there is some controversy about the foundation for the video clip, which is alleged to depict the January 5th, 1992 football game, American Football Conference playoff game between the Chiefs and the Bills.
Yes, Your Honor. As Ms. Clark indicated, we did subpoena that footage from NBC. NBC provided that videotape in a fairly expeditious manner, and at the same time provided a custodian, or offered to provide a custodian of record affidavit. They did not, and their position has been throughout this that they are not obligated to provide an actual live witness. Their position is that the witness who would testify to this is located in New York and beyond this court's jurisdiction without further process of the court. Ms. Edgerton filed a letter with the court today, and I just got off the phone with her, and she's indicated that she attempted to contact the court within the last hour, leaving voicemail. But she is attempting to, or strike that. She has contacted the court with this. It is our position, Your Honor, that the affidavit under 1560 of the Evidence Code should suffice to lay the foundation for this videotape.
Mr. Blazer, what's the defendant's position?
Our position is that we don't think that that does. It doesn't comply with the law. This is not a governmental agency. That they have subpoena power. They can bring somebody from New York, just like we brought Miss McKinney from Georgia or from North Carolina.
All right, the problem I have, Mr. Yokelson, is that the affidavit, I agree with you that there is a manner, the subpoena ducis tecum and the process and the declaration of the custodian of records, that's ordinarily a way to avoid having to call live witnesses if there are business records that are maintained in the normal course of business in an appropriate manner. The difficulty I have is that the declaration that is attached to Ms. Edgerton's letter to the court bearing today's date, the affidavit indicates, quote, NBC has made a diligent search for that footage and has not been able to locate it, and it refers to the videotapes of the Kansas City Chiefs Buffalo Bills game played on January 5, 1992. So the affidavit itself does not provide a foundation. So where does that leave us?
Well, that leaves us with attempting to find another affidavit, obtain a second affidavit remedying this defect, or having NBC here to explain this issue to the court. We are not going to rest until we can lay the foundation for a very simple piece of tape that should by rights be stipulated to, but the defense, we've not been able to arrive at a stipulation. It seems that this matter should be handled very expeditiously. Ms. Edgerton informs me that she can be here tomorrow, and I would ask that we have her in first thing tomorrow, and we attempt to hammer this out with all the parties and NBC.
Because we handle business records all the time in this manner, but the affidavit doesn't support what you're asking for.
Well, in that case, I'm sure that we can address that issue with NBC, and we will take it up. I suggest that we hold this matter in abeyance until tomorrow morning, have Ms. Edgerton in, and we will settle this matter.
Well, I would suggest that you have somebody up at 5 o'clock tomorrow morning at the opening of business on the East Coast and see if you can't expedite this matter, because the matter of an appropriate declaration, that's all that's missing here.
It should be a simple thing, and we will accomplish that. Of course, as Ms. Clark points out, the fact is that NBC gave us this videotape, so clearly they knew what it was in response to our request, so clearly they knew what it was and were able to locate it.
Well, my problem is, Mr. Yokelson, as much as I understand and appreciate what it is you're saying, there's an objection, and the affidavit doesn't support what you're asking for.
All right.
Yeah, we have copies of what's been submitted. We haven't seen anything.
Mrs. Robertson, would you have Mr. Byrne? I think you
I believe that was already provided
previously, Your Honor.
Okay. All right, as far as scheduling, then, I take it then unless and until we have this video, this is also videotape you want to use with Mr. Rubin, correct?
Correct.
All right, scheduling then. Mr. Blazer indicated he needed additional time to prepare for the cross-examination of Mr. Rubin, and Mr. Darden, you indicated that there was a desire to have Mr. Rubin present just so we can consult with his calendar. All right, why don't you ask him to step in, Mr. Fairlow?
About to ask him to come in. I don't know that the court is aware of this, but Mr. Rubin is the only so-called expert in this entire case who has testified without any fee for free. He has appeared here on many occasions on his own time. He has taken calls from the defense on the East Coast on his own time. He runs a business, and he needs to get back to that business. I don't understand why we need to delay until Wednesday.
Well, there's a request for additional time, and part of the difficulty, though, is some of the information that Mr. Rubin produced and gave to the prosecution was not turned over to Mr. Blazier until today. I mean, that's not a situation that the court created.
Everything that we have put on today was turned over. All the photos we put on today were turned over, I believe, prior to September 1, Judge.
Well, we had a discussion, we started off this morning's discussion with the fact that Mr. Rubin's letter of July the 6th had not been disclosed to the defense. That's how we started off this morning's discussion.
And I think we ended that discussion by the court noting that it was a preliminary, at most, conclusion on his part. He was asking for more photographs or better photographs, and was.
The point being, though, is that he actually does refer to specific photographs and make certain findings. That's the point. All right, Mr. Blazier, why do you need until Wednesday?
Well, I think it was a total of 47 pictures on Friday afternoon at 5:30. I spent the weekend working on this. We may be producing some exhibits. I have to coordinate some other people that I may have here in court for when Mr. Rubin testifies. We simply just need some more time. I'm looking at Thursday. I may be able to be ready by Wednesday. I'll have a better idea tonight.
Well, specifically, what is it you need to do?
I need to consult with experts that we've been in contact with. I need to see if they're available to be here Wednesday. We may be making some photographic exhibits. I obviously been here all day, so I haven't been able to do that today. That takes time.
We gave them color copies of just about all the photographs early on, Your Honor. There's nothing that has been presented here today that should have been a surprise to the defense. This is rebuttal. We all knew it was coming. We all knew we were going into the glove issue. It's really a simple issue, that is the identity of these gloves being an Aris leather light, an Aris light or not. How much more time can be necessary to prepare to cross-examine Rubin on these issues? Beyond that, we've already litigated the issue of brochure stitching and the V palm and all these other things.
And what? I'm sorry.
We've already litigated these issues regarding the stitching and the V palm and everything else as it relates to the uniqueness of that glove. So why the extra time?
Well, the main problem I have is that this report wasn't turned over.
A detailed, in fact, a transcript of our conversations with Mr. Rubin as they related to each of the photographs shown to him was provided to the defense on August 31st or September the 1st. On September the 1st, which is much more detailed than any report, and in particular, much more detailed than any preliminary report or letter sent to him by us. They have a transcript of all of his opinions as they relate to each of the photographs, and they've had it for 12 days now.
My recollection of that transcript is the only photograph he said looks like the Aris glove to me is one Rankin picture, maybe a second. That's it. None of these other ones are referred to in the transcript, and then there's one video, I think, that he said is a good video. None of what we've heard except for the Rankin pictures is part of that transcript. Now, I'm assuming this is part of some later opinion, but I have nothing about that in writing. I just have to assume he's going to get up there and say something about it.
Mr. Jordan, do you have a copy of of Mr. Rubin's last report or letter to you? His final report or letter?
I don't believe we handed over a final report. We handed over the transcript of Mr. Rubin's opinions and comments as they related to each of the photographs. Mr. Rubin points out to me that it was Mrs. Blazier, Mr. Blazier's wife, who called him up and let him know he was coming back to testify in the first place, and that it was Mrs. Blazier who interviewed him on the telephone several days ago on September 1st. So none of this is a secret, Judge.
Yeah, we had obviously we've been trying to prepare for this since they started making noises about doing this. We had no pictures when we talked to him before. It was a telephone conference. That's it. That was not terribly helpful.
Mr. Rubin would like to testify tomorrow morning and get back east to his business and family.
It does not give me adequate time to represent my client.
And I think that's probably why we have the objections, so that he'll be forced to go back east before he is allowed to testify in this case. This is a no-brainer, Judge. As far as Croft goes, yeah. It had adequate notice.
You people.
And I'm willing to surrender people's witness, Mr. Rubin, to Mr. Blazier. He may take him anywhere he may like and do with him whatever he want.
All right, well, the photos are here. Mr. Rubin's here. Mr. Rubin's well known to both sides. He's been cooperative with both sides to an exceptional degree. He's provided raw materials for both sides. I think we've had the photographs now for a sufficient period of time. I am still concerned, however, about that letter of July the 6th. Mr. Blazier, be ready to go tomorrow.
May I say one further thing, Your Honor?
Certainly.
One of the things that we've been doing is trying to accumulate gloves that have some of these characteristics, and we were going to produce some photographs.
Mhm.
We're going to attempt to. We can't do that, and I can just inform the court, I can't do that now. If I have to go forward tomorrow morning, I can't do that. We still have gloves coming too, by the way. So we may have to have him come back.
Well, that's something that can be independently put on by somebody else, by an investigator, that they found these gloves with similar characteristics. That's something you don't need to do with Mr. Rubin.
Well, we need to test
But this is also not an issue that's been a mystery or is unexpected.
Which photographs he's going to identify has been until today, except for the Rankin picture.
All right. Anything else
Yes, Your Honor.
before we launch into our Sims hearing?
It's a discovery question concerning upcoming witnesses.
Yes. Who's coming up after Mr. Rubin?
Well, first of all, Your Honor, of the list of 60 names that we were given on Friday, my office has attempted to identify those witnesses for whom we have no report, statements, or any idea of what they are going to testify about.
All right, and they are?
David Atkins, I believe, works with SID, but I'm not sure the nature of his testimony.
Who is David Atkins?
The OIC in the photo section at SID, I believe he testified once before on the issue of the Willie Ford video.
Yes. Press people say yes. They know who he is.
If they will look at, did he testify? Look at the logs from Rockingham, you see that he arrived at Rockingham around noon that day. He testified that he saw the socks.
Are there any reports regarding him?
I will.
I'm sorry, I didn't hear you.
I don't think so, no.
Next.
Brent Clayton, Clayton.
Who is Mr. Clayton?
No.
Ms. Clark, do you want to look at my list?
Mr. Clark, but Sharon.
All right, and before we break, Mr. Rubin, would you make yourself available to discuss these matters with Mr. Blazier this afternoon, this evening?
No problem.
All right, thank you, sir.
Sorry, I'm drawing a blank at the moment.
All right, next name.
Jim Henson.
Paperwork, Your Honor. I have everything written down with who testifies to what and why, and I don't have it in front of me.
Let me get the name just so that we're clear. Steve
Okay.
Jensen. Dennis Kilcoyne, I know, is an investigator, a police officer. I'm not sure what he's testifying about. I have a name that says Laufman, Laufman, no first name. I don't know who that person is.
Mr. Hoffman, I believe, was a witness to Kathy Randa and Skip Taft removing a large sum of cash from Mr. Simpson's safe deposit box on June 17th. And Mr. Jensen is from Cognitive. they enhanced the photographs of the young.
Lamar Lyle.
We did not do those enhancements.
I'm sorry, is that another club witness?
No.
Okay.
Don't worry about it.
Lamar Lyle.
But these are witnesses to the establishment.
All right, do me a huge favor, that's my list, so how about if you don't mark on it?
Shouldn't have brought that note about you.
Another one. Okay, how about, listen, what I'm going to do is, I would like to take a brief recess, because we're now going to launch into an hour-long hearing on Sims and RFLP. Let me order Mr. Douglas, Mr. Darden, and Ms. Clark to meet and confer during the recess. Get your list, find out who's who, turn the names over to Mr. Douglas as to who you're going to call and who they are. All right, we'll take a,
And the next 3 days, Your Honor?
and that's what that includes.
When Mr. Fairlawn meeting with Mr. Douglas, all the paperwork.
I believe I stated all the witnesses in the next 3 days on Friday, Your Honor.
All right.
I've already done that.
Oh, well, Mr. Fairlawn, Mr. Douglas, get together, compare the names, the schedules.
Like that, it's 3 days, yeah, there's 3 days here.
No, we don't need to do it, we don't need to do it again, counsel. I've got my notes. You should have yours.
All right, one other thing, Your Honor. I wasn't here on Friday, Your Honor.
Okay.
One other thing, there's a motion, the people filed a motion to introduce expert testimony regarding domestic violence. I thought we went through before. Dean Allman is here. He will not be able to respond to this motion until Friday, and we'd like to argue it next Monday. No.
Mr. Gordon is going to be arguing that issue for us, and we intend to rest by next Monday.
Sir, well, they can rest without this witness too, then, Your Honor, because this week's got this convoluted, complex motion, which was already litigated, I thought, and Dean Allman is here, and it may require Kelly Fry, et cetera, and we're indicating we can't respond to it. His work is back up north, he's going back home. We'll respond to it by Friday. I want to alert the court to that.
You know, earlier today, Mr. Bailey told us he was ready to argue. He wanted to argue this motion this afternoon.
I don't think Mr. Bailey's seen this motion, Mr. Dart, at that point. This motion requires our points and authorities, and we will be doing that.
In fact, I think Mr. Bailey was ready to concede the issue.
Well, I
have not seen any points and authorities that were handed to me after I said I'd be prepared to go on my papers by then.
All right. Get your P's and A's as soon as you can. I think Friday's optimistic. All right. Let's take a 15-minute recess, and let's get the Sims witnesses down here, and we'll start into that. And Mr. Blazier, why don't you take advantage and chat with Mr. Rubin? Yes. All right. Which is the motion regarding RFLP testing of evidence taken from the Bronco automobile, and also some continuing issues regarding the scope of the prosecution rebuttal case. Mr. Cochran?
Yes, we would ask, we want to just make sure the court would allow us to argue the issues regarding the scope of the prosecution's case, because the case will be over. We may not have argued that motion. So I wanted to make sure we did that at least,
well, then
not this afternoon.
Wouldn't that indicate there's a very limited scope?
Well, not left to them, Your Honor. I think you'd have to interject yourself to make sure that happens. So we'd like to do it sooner rather than later. So whether this afternoon or first thing in the morning, I just give Your Honor your choice on that. We're prepared to do that. I think counsel are prepared to do that as soon as you're ready. Bob Blazer has a portion of that, and I suppose he's out talking to Mr. Rubin. But I think Peter Neufeld is ready on a portion of it.
It would make sense, Your Honor, if we can schedule it this way. May I be heard?
Sure. Certainly.
Yes, thank you.
Good afternoon, sir.
Oh, good afternoon, Your Honor. Mr. Scheck, of course, is going to be addressing the RFLP issue on the console this afternoon. And we just got, as you know, points and authorities this afternoon on the Dutton matter. But, for instance, you asked the prosecution yesterday, are there any Kelly Fry cases at all involving this kind of testimony, anywhere that would give the court guidance? And at that point, Ms. Clark said, yes, I believe there are, but I'm not certain. We just spoke to, Mr. Dutton this afternoon, and Mr. Dutton informs us, for instance, that as to these four matters, he's never participated in any Kelly Fry hearing anywhere in America or Canada on these issues before, that he wants to raise for the first time in this particular case. That's the kind of facts we need to know before we can adequately brief it and argue it before Your Honor. They said this case is going to last 3 to 5 days, 5 days. It's going to be the most extraordinary 5 days since the earth was created. All we're saying is that we need to know before we start running off in 16 different directions what evidence we're really going to have to refute, both in cross-examination and conceivably sir rebuttal. Yesterday, I also asked that they put in points and authorities, Your Honor, on June 17th testimony. I don't know if you recall that. Remember, they felt that June 17th was now relevant. Yet we haven't heard anything about June 17th.
Well, they offered, they indicated they wanted to call Skip Taft, Kathy Randa, and
Michael Baden and other people who were present at the house that day. But they didn't, there's no points and authorities as to why, what doors have been opened for that kind of testimony at this time. All I'm saying is this: I think we're entitled, as this train moves down the track, to get some understanding right away as to what the court is going to permit and what the court is not going to permit, so time is not expended on unnecessary issues.
All right, I agree with you wholeheartedly, Mr. Dufeld. So you're raising obviously the Dunton issue, which we just got a points and authorities on.
Yeah, Mr.
You're
Bailey.
concerned about the scope of the defendant's activities on 6/17, correct?
Yes.
All right, what else, what other concerns do
The
you
Bronco Fiber report, which they feel that the door has been opened up because of a witness's suggestion
Kathleen
that,
Bell.
right.
Yes.
I think Mr. Bailey will be ready to argue both those issues tomorrow morning, Your Honor. And I would ask that time be set aside tomorrow morning as to both the Bronco Fiber issue and also as to the Dutton matter tomorrow morning. All right. Your Honor, also...
Dutton issue tomorrow is fine.
Okay.
No, just kidding.
Sorry,
Just kidding.
Your Honor, also, although we received a proffer yesterday with respect to, or I guess Friday, whatever it is, as with respect to the scientific witnesses, most of the witnesses included on that list of 60 people are not expert witnesses, and they too have to fall within the criteria of proper rebuttal testimony. And so we can
Are there any
argue that...
particular areas that you can isolate for me that are apparent to you just from who they are?
Well, no, that's the problem, is that we have looked at that list, and there are many people on the list we've been unable to identify at this time. I can't tell you right now who they are. I can give you that tomorrow morning, and I would ask that first thing tomorrow morning when we give you that list, that the people then come forward with a brief proffer as to who those people are and what they'd be testifying to, so we can argue either in a 402 or 352 or whatever that it's inappropriate.
Makes sense.
So that can happen first thing tomorrow morning, too?
I don't know that it'll happen first thing tomorrow morning, but I at least want to frame the issues and get us scheduled to discuss these matters.
Also, you had mentioned that you were going to review the DeForest matter with Mr. Hodgman.
Had not heard back from Mr. Hodgman today, but in case you haven't noticed, I've been on the bench all day.
Okay.
All right.
One moment, Your Honor.
In fact, Mr. Kelberg, would you, in fact, Mrs. Robertson, would you instruct Mr. Hodgman to be here tomorrow morning, 8:30, so we can conclude the DeForest matter?
Your Honor, and also, we also want to be able to litigate this Paratus tape, which they've come forward with now.
All right.
Would you like, can we do that tomorrow morning also, so we'll know?
We'll schedule it tomorrow morning.
Okay. Thank you.
All right, before we begin with Mr. Sims, there's the matter of, it appears now to be Agent Diedrich and maybe Mr. Bodziak are the people's intended witnesses. The first matter I should raise, we just received this afternoon a document from the, documents from the FBI. It had previously been described to me by Mr. Goldberg as preliminary reports. I don't know if it's a preliminary or a final report. But basically, what has been done is they took some chemically treated paper and something that's called an identicator, and they took the genes.
I know we've had this discussion already.
Right. Now, I asked Mr. Goldberg again whether he would concede that the picture that I wanted to show to the court demonstrates that the genes are altered. Looking at the picture, it's clear that the genes are altered. He said he hasn't looked at it yet. and he maintains that the procedures that are being used to create these test impressions are not in any way a destructive test. And therefore, he takes the position that no notice need be given to the defense as to any of these testing procedures. That apparently was the position that they took, because I thought that this order...
Counsel, why are we discussing this now?
For one simple reason. I asked if they were going to be conducting any further tests with the genes. Mr. Goldberg indicated to me that that could happen. I asked if they would give us notice of that. He said, I'll give you notice, but it's not necessarily going to be timely notice because I don't think you're entitled to that. And I said, well, if we want to have an expert present or document or even litigate any further alteration of these genes as to whether or not it's reasonably necessary for that to be done, particularly since we think that it shouldn't have been done in the first place. We want this court to order the prosecution to give us notice so that we can, A, litigate whether this should be done in the first place, whether there's reasonable necessity to do it under Griffin, and B, adequate opportunity to have experts there to do it. And I want to put the court on notice that we don't have full discovery from them. The test impressions that were actually taken
All right, why
from
don't
the
you
various objects we don't
and
have.
Mr. Goldberg be here at 8:30? We'll discuss the matter. All right, Mrs. Robertson, would you summon Mr. Goldberg tomorrow morning also at 8:30? All right, Mr. Harmon, are you going to conduct the hearing as to Mr. Sims?
Your Honor, actually, I believe I'm going to have some participation with the court's leave because we feel it is a hearing that is most appropriately bifurcated. Our position is that this evidence is clear rebuttal evidence. I was intending, with the court's permission, to tell the court, argue to the court why, in our judgment, this is clear rebuttal evidence, such that the timeliness of the RFLP testing becomes irrelevant. I did hear this morning, I know the court in a similar motion regarding scope of rebuttal was concerned about the timeliness of the photographs being collected and so forth, and I'm mindful that the court has expressed concern regarding the RFLP testing, but I would like to be heard as to why I believe, given Dr. Gerde's testimony, the evidence concerning the 303, 304, and 305 RFLP stains is true rebuttal evidence such that the timeliness issue with respect to case in chief falls by the wayside. We are certainly prepared with Mr. Harmon and Mr. Sims if the court wishes to hear the circumstances of the scheduling of the tests, the chronology of events. Mr. Harmon is obviously intimately familiar with those and is in a better position to conduct the inquiry if the court feels that that is necessary. But I truly do believe that if the court hears what I believe to be the reasons why this is rebuttal, the court may be convinced that that hearing is unnecessary. Your Honor, as the court will recall from Dr. Gerde's testimony, he contested the reliability and validity of Mr. Sims's interpretation of the 1.3 allele in stain 31 from the broncho console. As the court will recall, the testing on the PCR of that stain 31 was, in the opinion of Mr. Sims, consistent with a mixed stain of Mr. Simpson and Mr. Goldman. I believe 1.1, 1.2, 1.3, and a 4. The 1.3 and the 4 would be Mr. Goldman. Dr. Gerde's position was that the 1.3 allele was too faint to be legitimately called as an allele which was present. And in fact, it could be the result of cross-contamination due to sample mishandling.
Do you want to direct my attention to the particular passage in the transcript where Dr. Gerde's...
I think we can get that for the court. This is a summary. I had the issue framed in my mind in discussing rebuttal evidence with Ms. Clark, Mr. Hodgman, and so forth, and then I confirmed with Mr. Clark as to the substance of, and with Mr. Harmon as well, the substance of Dr. Gerde's testimony. But what I am saying is a representation made to me in my consultations with Mr. Clark, Mr. Harmon, as to Dr. Gerde's assertions as part of his testimony as a defense witness. And in essence, what he said with respect to that stain, in comparison, for example, with item 52, which was one of the blood drops on the Bundy walkway, which Mr. Sims did also see a 1.3 showing in the PCR testing, but which in that circumstance, Mr. Sims felt could not be called as a true finding of an allele from a contributor, and in fact attributed it to an artifact. So Dr. Gerdes, one of his positions was Mr. Sims had to be consistent. He couldn't call the 1.3 in stain 52 an artifact and not call the 1.3 in item 31, the console stain, an artifact as well. The point is that stains 303, 304, and 305, combined under order of this court for the purposes of RFLP testing, come from an area nearby to where item 31 was found in the console. The RFLP tests, we have done now all 4 probes, but there is a report only of the 3 probe findings. The 3 probe findings are, again, consistent with a mixed stain of OJ Simpson and Ronald Goldman. And further, they are consistent by intensity levels with the intensity levels found in item 31. The intensity level of Mr. Simpson's contribution being significantly more than the intensity level of the 1.34 allele called by Mr. Sims as consistent with Ronald Goldman as a contributor. So the essence of this RFLP test results from the 303, 304, and 305 stains is to undermine Dr. Gerdes' contention that Mr. Sims was wrong to call the 1.3 and 4 a contribution by Mr. Goldman, but rather he should have called it an artifact, or to be consistent, it was an artifact through sample mishandling. We are corroborating with 303, 304, and 305's RFLP results, corroborating the accuracy of Mr. Sims's call on 31, accuracy which was called into question by Dr. Gerdes, a defense witness. And that's why this is true rebuttal, because we are now going to reinforce the accuracy of Mr. Sims after that accuracy has been attacked by Dr. Gerdes. Furthermore, Your Honor, I would submit to the court, as I know the court has had a concern and a requirement, that any time DNA test results have been given, there be population statistics given to the jury in order to understand the rarity or commonality of a particular finding. I submit to the court that on this RFLP series of tests on 303, 304, and 305, the statistics are already heard by the jury. The statistics are the PCR statistics of stain 31, because we are not independently offering 303, 304, and 305 for themselves, but to prove the accuracy of 31's finding and the call by Gary Sims, as a result of which no further independent statistics should be required. And in fact, the statistics which have been received by the jury on the PCR, Mr. Clark was kind enough to give me the testimony, are much more favorable to the defense than any statistics offered by someone such as Dr. Weir would be for RFLP tests on 303, 304, and 305. For example, on stain 31, assuming 2 contributors, the statistics run from 1 in 4,700 to 1 in 19,000. And for the 303, 304, and 305 PCR stains, there's also been testimony as to these statistics. They run from 1 in 570 to 1 in 10,000. But if one gets into the RFLP statistics, and there was a recent report produced by Dr. Weir, which has been given, as I understand it, to the defense, for assuming 2 contributors, you are looking at a range of 1 in 58,133,000 to 1 in 114,237,000. Now, I don't hold myself out as the brightest guy in the practice of law, but it would seem to me pretty logical that if I were the defense, I kind of like the PCR numbers as to the commonality a lot more than I would like the RFLP numbers. And that's the point of this evidence of 303, 304, and 305. It is not offered for independent value, which may have resulted in it being in our case in chief, but it is being offered to corroborate findings that we did offer in our case in chief, which are basically similar findings. It's a mixed stain. It's a mixed stain consistent with OJ Simpson and with Ronald Goldman, but it's now being offered to directly attack a defense expert testifying in the defendant's case in chief. That, as I understand the law, Your Honor, is true rebuttal. And for that reason, this evidence should be received, irrespective of when the test should have been or could have been performed. And I offer no opinion on the timeliness. I leave that to Mr. Harmon and Mr. Sims if the court still feels the need to hear it. But I suggest to the court, if this is true rebuttal, then we cannot offer this evidence until we reach rebuttal. We have reached rebuttal today. The tests are available today, and that makes them timely on rebuttal. As I also indicated, we submit to the court that no new independent evidence of statistics is required for the interpretation of these RFLP findings on 303, 304, and 305, where they are offered to corroborate the findings of PCR results on stain 31. Thank you, Your Honor.
All right, Mr. Harmon.
Oh, do I get?
They get to go first.
Oh, so in other words, you do want to hear from them?
Yes, I do.
Okay.
Thank you. I'd like to just give you a little outline of the chronology, and then we can go through it with Mr. Sims if that's what the court would like to do. As the court recalls, on or about March 9th, you approved, over the strong resistance of the defense, our desire to combine these tests to take whatever results came out of them, let the chips fall where they may. Other, I think, significant events, and Mr. Sims will go through the chronology in detail to demonstrate to the court that these things were processed in an orderly fashion. Mr. Sims made trips to Los Angeles. Mr. Sims attended study groups during this time period. Mr. Sims consulted with me in anticipation of his testimony. He also prepared reports, personally prepared the extensive discovery that's required. All of these things occurred at the same time he was trying to satisfy the desire to have these results produced as expeditiously as possible. As the court knows, during his testimony, there was a death in his family which disrupted his life. He took proficiency tests. His testimony was disrupted by that personal event. It's my opinion that the court, if the court is interested in any chronology, the most important part is the beginning. So I invite the court to stop me when you think we've covered the area that you're interested in. At some point, once the RFLP process has begun, and by beginning, I mean the hybridization. That's a misconception that the process begins when you begin the hybridization. Dr. Gerdes lauded the Department of Justice for their meticulousness. In fact, everybody played off LAPD against DOJ, and now you'll see as this hearing unfolds, they will be criticized for being as meticulous and fastidious as they were in making sure that even in spite of your approval of the combination, there were subsequent evaluations which, had they not produced favorable results, Mr. Sims would not have proceeded with the combination because it would have been against his scientific judgment to do so. But once the hybridization begins, and we'll give you some numbers on how long each probe was allowed to hybridize, essentially you're stuck with however long it takes to develop the results. Some of the key dates that I think to keep in mind in trying to identify, and I've asked every time we've addressed this issue, precisely what is the legal issue that we're addressing here? Mr. Scheck has consistently complained that we've denied them access to that evidence, and every time he's done that, I've said, no, the balance is still there. It's been there since March if you really wanted to test it. So that never was an issue. I think if they wanted to fashion a legal issue that somehow they were forced to proceed with their case without knowing what the results were, you will see that the chronology does not support that. The outline actually lists the date that the people rested, which is July 6th. The defense case began on July 10th, and if they complained that they were sandbagged, they didn't have to call Dr. Gerdes when they called him. They chose the date that they called him, and I think the court will see when you combine when they called Dr. Gerdes with what was known by the defense in order to fashion and very carefully craft or carve a way around the overwhelming biological evidence in this case, you'll see that Dr. Blake was, once again, a regular visitor there, was a regular reporter on the development of these probes, and as of the date of Dr. Gerdes' testimony, the defense was aware that there were, in fact, 3 RFLP probes which produced the results that were produced in this case.
Mr. Harmon, maybe I can help you cut to the chase.
Sure, I'd like to do that, Your Honor.
What interests me most is the time period between March the 9th, when this court granted you permission to combine those samples for the purposes of attempting a single RFLP test, and the time that the test was actually undertaken.
Well, I think you'll see it was undertaken right away, but, you know, we're going to differ in what undertaking the test means. But I'd be happy to, because that'll bring us all the way up to August, depending on how you define undertaken. So we'll just start with March 9th, and you tell us when you've had enough, Your Honor. We've got the whole period of time covered. It'll take a while, but maybe we'll have our 5th probe before the hearing's over, so. Would you like me to have Mr. Sims testify?
Counsel, it's your record.
Thank you, Your Honor.
Madam Reporter, what's your time pressure? All right, proceed.
I do. Please have a seat. Witness stand and state. So your first and last names for the record.
My name is Gary Sims, Garys,
Your Honor, I've put my own chronology together, and I know Mr. Sims has reviewed it. These are my notes, but I don't have any problem sharing them with everybody. Would you like me to have a copy marked as well?
Yes, for the purpose of this hearing.
Would you like a copy?
I would. Thank you very much. 613.
And Mr. Sims, have you had a chance to review people 613 for identification?
Yes, I have. That's the chronology of 303, 304, and 305.
Okay, and why don't we use the actual exhibit that's been marked? Is it your recollection that on or about March 19th, after some discussion and you filing an affidavit with the court, you received approval from the court over the defense's objection to combine what remained of 303, 304, and 305 for the purposes of doing RFLP testing?
Yes, that was about March 9th.
Okay, and did you actually conserve some of the samples? Are there still samples remaining to the best of your knowledge?
Well, yes, as I put in my declaration to the court that I would preserve sample on all of those, and in fact, I did preserve sample on all 3 of those samples.
And what did you actually do on March 9th?
On March 9th, one of the samples, 305, was brought back to the laboratory, and we spent a lot of time just documenting what was present in that sample, and then sampling it, and then repackaging for return.
Okay, how much time do you think you spent on that enterprise that day, March 9th?
It was probably the better part of the day. I don't know the exact number of hours.
Okay, March 10th, what did you do that day?
I had a meeting with you.
All day?
I believe that covered a lot of the day, yes.
Do you take Saturday and Sunday off?
I believe I did at that time, yes.
Okay, what did you next do with respect to this case, any aspect of this case, or specifically samples 303, 304, 305?
Okay. At that point, we did, on March 14th, there was DQ alpha typing on that original sample of 303 and 304. In other words, prior to the time that they were combined. So at this point, we wanted to know that independently they shared a consistent DQ alpha type so that we could then proceed with the further analysis. And that DQ alpha typing was completed on March 14th.
Okay, did you I think you misspoke. What were 303 and 304 previously typed with any marker?
Yes, they had previously been typed in D1S80, as I recall.
Okay, and why did you pursue the DQ alpha testing with 303 and 304?
Well, the DQ alpha testing was to, again, look for consistency of the results to see whether or not it was consistent with the mixture of Mr. Goldman and Mr. Simpson.
Did you obtain consistent results on 303 and 304 consistent with what you had seen in 305?
Yes.
Okay. Had you not obtained consistent results on 303 and 304 with the DQ alpha marker, would you have gone ahead with combining those three samples for the purposes of RFLP testing?
I would think not.
And why is that?
Well, because then there wouldn't probably be enough DNA of the people that may be involved in that mixture to get an RFLP result. In other words, they may be other people, and we've got an exclusion, perhaps.
Okay. So as of March 14th, then, you had decided that even though you had the court's permission, that scientifically it was appropriate in your mind to go ahead with combining those three samples?
That I wanted to do that testing even though I had the permission. I still wanted to look at those DQ alpha types before I did the actual combination.
And how much time do you think you spent on these tests on March 14th?
That's probably about a half a day's work, something like that.
Okay, do you recall if you did anything else with respect to this case on March 14th?
That's all my notes indicate.
Okay, March 15th, what activities did you perform with respect to this case?
On March 15th, I laid out in my notes what samples I still plan to extract in this case. I included these, the combination samples as well as some other samples in this case.
So were there actually other samples being evaluated and tested in this case during the same time period?
Yes.
And are they listed in your notes?
Yes, they are.
Okay. March 16th, do you recall if you did any work on this case or specifically the console stains?
I have nothing in my notes on that particular time. I should point out, too, that sometimes what I'm looking at here are my laboratory notes, and there are instances where I may be working on the case but not making entries in my laboratory notes. For example, I may be reviewing some of the other results or photographs or something like that, or consulting that's not always showing up in these particular in these notes.
Now, just to jump ahead a little bit, did you have a report that you knew you were going to have to start putting together towards the end of the month?
Yes, there was the second big report we put out was in early April, and so we started getting ready for that also at this time.
Now, do you actually write in your notes getting ready to file report?
No, that's an example of the kind of time that would not show up on my lab notes.
And the notes you're referring to, they actually reflect scientific or technical activities that you engage in?
Yes.
Okay. March 17th, what did you do on that date?
That was a time when we started some extractions on some of these various samples that we listed. This is when we actually, I want to make sure I've got the right set here. This is when we're actually doing the extraction of the combined set.
So when you say you're doing extraction, you can't use the DNA, or you're not using the DNA that you use for PCR typing. Is that true?
That's correct. At this point now, we're starting with the additional swatches, to do the combination. In other words, we took those additional swatches that were from 303, 304, and 305, and we're extracting them now as a group.
As if you're starting the process from the very beginning.
That's right.
Okay. So you began the extraction on Friday, March 17th?
Yes, that was a Friday, I believe.
Okay. How much time do you think the activity that are reflected in your notes took?
I'm working on that at night, it looks like. The time I've got is, there's two different sets going. One that goes in at 21:20 hours, another one goes in at 22:18 hours.
How many samples in each of those two sets?
There's about, I think, 7 or 8 in each one, something like that. 4, I'm sorry. 8 in one. I think 6 in the other.
And I assume you're taking your time?
Yes.
You didn't want to rush and be criticized the way Colin Yamuchi was?
Yes.
Wanted to be careful?
Yes.
Not have one tube open more than one tube open at a time?
I agree. Let's pick it up.
You meet with me that day as well?
Yes, on March 17th, that Friday.
How much time did we spend together?
I think we spent the better part of the day.
And so you spent the day with me and then did the extractions at night?
Yes.
Okay. Did you work Saturday on this case?
Yes, I did.
What did you do Saturday, March 18th?
On March 18th, I completed the extraction on some of these sets. No, I'm sorry, I did not complete it. I continued the extraction on some of these sets. And then it was on March 19th, Sunday, when the extraction was actually completed.
So you worked Saturday?
Yes.
How long?
Well, I have some additional notes that I may be able to...
Can you give us a ballpark?
I think it was a few hours on Saturday.
And how about Sunday?
That's probably some more time there. That's maybe at least half a day, something like that. It could be longer, I'm not sure.
Okay, and on Monday, March 20th, were you advised that the defense had filed a new motion challenging the DNA evidence?
Yes, I think I was aware the very day that it was filed, and I think that was on March 20th.
And soon thereafter, did we send you a copy?
Yes.
Ask you to read it?
Yes, we decided that obviously that should be reviewed and discussed.
Okay, and did that ultimately take some time towards the latter part of March for you to review that motion and counsel us?
Yes, that was all part of the time.
March 21st, what sort of work did you do in this case?
Dr. Blake came over, reviewed some of the RFLP and PCR results in this case.
How much time did you spend with Dr. Blake that day?
I logged about 3 hours that day.
Do you recall if you did any, do your notes reflect specifically any other work you did on this case on that date?
No, my notes do not.
Okay, March 22nd, did you again perform some specific hands-on work on the console mix in this case?
Yes, on March 22nd, I ran the yield gel on these particular samples, the Bronco console samples, as well as some of the other extracted samples in this case.
Okay, was there more than one set of samples upon or which you ran on the yield gel?
Yes, there were the 2 sets that I mentioned earlier.
So these are actually 2 separate yield gels?
It's what we call a double origin, where you take one gel, but you have 2 places where you enter samples, 2 parallel lines of slots.
And the purpose of the yield gel is to see how much DNA you extracted?
Yes, it tells you how much total DNA. It doesn't tell you whether or not it's all human.
How long do you think that this work on both of these sets of samples in this case took on March 22nd?
Given the number of samples involved and all that, it was probably the better part of the day was spent on that.
Okay. And then March 23rd, what sort of activities did you participate in with respect to the samples you'd process on the 22nd?
The main thing that I did on the 23rd was to go through and actually evaluate the results of the yield gel. And at that point, I decided that I would want to do a what we call a blotting of the yield gel to see whether or not the DNA that was present was human.
Now, why was that important to you?
Well, it was important because, as we've talked about at length in this case, there were other samples where there appeared to be a lot of high molecular weight DNA, but it was not of human origin. Some of it turned out to be not of human origin, and so I figured it was worthwhile to evaluate whether or not the DNA that we saw at the high molecular weight end, which is the RFLP-able type DNA, was in fact human.
But just to go back to the beginning, why was it your judgment, real briefly, to have to combine these three samples, 303, 304, and 305, for RFLP purposes?
Because individually, I didn't feel that there was enough there to get a good RFLP result, and I wanted to optimize the chances of getting a clear RFLP banding pattern, and to do that, I had to have more DNA to work with than any single one of those stains offered.
How much time do you think you spent on this case on March 23rd?
That looks like the better part of the day also, because there was the evaluation and then there was also the starting of the blotting process. My notes indicate I'm working on that latter part around 4 o'clock in the afternoon, and then I went overnight at 5:30.
Okay, Friday, March 24th, you met with me again?
Yes.
Better part of the day?
Yes, the better part of the day, as I recall, was spent meeting with you. There was a relatively minor part of the time spent in the actual laboratory analysis.
What did you do in that relatively minor part of the time?
That's after the southern blot of the yield gel went overnight, then I processed it and it was now ready to be hived and tested with a human probe.
What did you actually do that day, and how long did it take with respect to the consult mix?
Well, what I'm doing is evaluating the yield gel to see whether or not the DNA on there was human on those samples. And so this is the part now where the southern blot has gone overnight and it's taken apart and then processed in a way that it's now ready to be probed to see whether or not there's human DNA there.
Okay, now this is not the RFLP probing, this is just to determine if it's human DNA.
That's correct.
How long did dismantling the southern blot take that day?
Well, I'm starting on that according to my notes, at 6:30 in the evening. So I believe I had spent most of the daytime talking to you, consulting, and then it's the latter part of the day then that I actually did this part in the laboratory, and that's probably about an hour's worth of work, something like that.
And when
Maybe
we talked,
less.
I'm sorry, and when we talked about this case all day.
Absolutely.
Okay. You took Saturday and Sunday off, the 25th and 26th?
Yes, I believe I did.
And did you perform any work on this case on Monday, the 27th?
No, I don't believe I did.
Okay, and March 28th, did you give a training session somewhere?
Yes, I was asked to participate in a PCR roundtable discussion in a training class at what's called ABI.
What's that?
Applied Biosystems. They are a part of the company that actually produces these kits, the PCR kits, and they put on training classes for how to do this kind of PCR testing. And as part of their training course, they usually have an afternoon devoted to a roundtable type discussion of some of the issues that come up in courtroom interpretation, that sort of thing.
Okay, March 29th, you got back to the blot of the yield gel.
Yes.
What did you do?
At that point, I actually probed it with a human probe and produced what's called a LumiRad, which is like one of these autorads, but we're using a probe now that produces luminescence, and so you can actually read the intensity of these bands now to get an idea of how much human DNA is present in a sample on this particular gel.
And how long did that work actually take that day?
That would have been the better part of the day. I have my final film coming off around, looks like around 5:30 in the afternoon, something like that.
And so, I'll strike that. Did you perform any other work other than just getting that final film off, and was that it for that day?
Well, there's the whole hybridization process. I mean, that's done by the analyst, in this case me, during that whole course of the day, and you finally produce a film at the end of the day.
Okay, what I'm saying is when you ended up with the film, did you call it quits for the day?
Yes, I believe that's correct for March 29th.
Okay, March 30th, what did you do?
I attended the main thing I did that day was to attend a California Association of Criminalists DNA study group meeting.
Further education?
Yes.
And March 31st, you traveled to Los Angeles?
Yes, I came down here on that Friday. I spent all day down here.
That was an all day. And in my summary, is it true you worked about 115 hours on this case in March?
Yes.
And you were working on 5 other cases as well that are not reflected in this chronology?
That's correct.
You were back in Berkeley on April 1st on Saturday?
All right, before we move on any further, Mr. Sheikh, you want to consult with your client for a moment?
Your Honor, I'd ask, Mr. Simpson won't be able to eat if he doesn't leave now, so he's agreed to waive his presence for the remainder of the
All right, Mr. Simpson, is it agreeable to you that the court with the witnesses and the lawyers continue the hearing and you agree to waive your presence for the remainder of the hearing? All right. You're excused.
And how much time do you think you spent that Saturday on this case?
I think it was on the order of about a half a day.
And Sunday, April 2nd, did you also work on this case?
Yes, I was involved in preparing the written report.
How long do you think you spent on Sunday, April 2nd?
I don't recall the exact amount of time spent.
Okay, Monday, April 3rd, did you actually do any hands-on lab work in this case?
The hands-on work was to actually now look at those LumiRads that I had produced from this human probing and to make an assessment of the results.
You did that? You did that on that date?
Yes, on April 3rd.
How much time do you think you spent on that aspect of this case on April 3rd?
That would probably be a couple hours at the most, something like that. That's not a lot of time.
Okay, and then April 4th, what sort of decisions or evaluations did you make in light of everything you've described to the court to date?
Well, that was the point at which in my notes I commented that, now I felt I had established that there was high molecular weight human DNA in all those, in the combined samples. I'd evaluated some other samples also. And in my notes on April 4th, I say, regarding 303, 304, and 305, proceed to RFLP.
Okay, and did you also perform other work on this case?
Yes, Dr. Blake came over again on that day. And I also did some additional work towards getting the report out. And there was also some work on the discovery package at that time, too. So that was a pretty busy day.
Okay, April 5th, what kind of work did you perform on this case?
Report preparation also.
And then April 6th, did you and Renee Montgomery come down to Los Angeles?
Yes, I came down on April 6th with Renee Montgomery. I consulted with you, and I believe that was when the report was, and the discovery package was delivered.
You actually hand carried the material down here?
Yes, that's my recollection for April 6th.
Okay. April 9th, a Sunday, what did you do on that date with respect to this case?
On April 9th, there was some consultation with you on that Sunday, and there was, that was the main thing that day.
April 10th?
Yeah, yes, on April 10th, I think I may have misstated on April 6th. I'm not sure I delivered the discovery package on April 6th. I think it was just the report that actually came down on April 6th, because I noted that there's more discovery going on as we get into like April 10th and April 11th.
And so you continued to work on the discovery after you filed the report?
Yes, I think that's correct. I think I misstated that the discovery was delivered on April 6th. We could check that.
Okay, and the outline that we've prepared lists discovery prep on April 10th and April 11th?
Yes.
And no actual laboratory work on the console mix in this case, is that true?
That's correct.
And then April 13th and 14th, you've listed preparation for testimony?
Yes, at this point, I began in earnest to prepare for the upcoming testimony, which I anticipated could be at some time in either the end of April or in early May, something in there.
And why'd you decide to do that instead of continuing with the RFLP testing at that point?
Yes, well, there are two reasons. One is that there was a large volume of material that I felt I needed to be responsible for. In other words, that I had to be prepared to be cross-examined and also to present direct testimony on a large number of items, a large number of typing results. And also, I wasn't sure what sorts of issues might be raised by the defense based on that motion of March 20th. So I prepared in earnest to get all the literature articles in order, that sort of thing, review as many of them as I could, and then also to have plenty of time to study my own notes, just the actual notes in this case, and not just the other issues involved.
You take Easter Sunday off?
Yes, I did.
Okay, the next week, April 17th and 18th, did you continue your preparation for trial testimony?
Yes.
The 19th and 20th as well?
Yes, I believe on the 19th there was some additional analysis as far as just reviewing results.
But
But nothing in the lab.
No lab work?
That's
Okay.
correct.
You took April 21st, Friday off?
Yes, that was when my kids had a school holiday that week, and so I took that Friday off.
Okay, then the following week on April 25th, did you actually get back to discussing specifics on the console combinations in this case?
Yes, I decided at this point that I would try to get that RFLP work going, and that was April 25th.
What did you actually do on the 25th?
On the 25th, there was I outlined in my notes what sort of results we had on the, this goes down not just the 304, 305, that combination sample, but also the other samples that were being extracted and evaluated at that time. But there were decisions made as to whether or not some of those other samples should go through what we call the slot blot process, because in other words, there was not enough human DNA in some of those to detect it on a blot of the yield gel, so we had to do an additional test for human DNA on some of those samples. So I made some notes there. I provided some some extracts to Renee Montgomery for her to proceed with that. And then also on that 25th, I actually began to outline how I would do the RFLP, to plan the RFLP on the Bronco console.
What sort of planning do you think was entailed in that?
It was a fairly involved process because of the limited amount of sample that was available. It involved looking at those reference samples as well as the combined console samples now, because that I basically knew what I had to work with. At that point, I knew I had about 72 nanograms total available from that console, something like that. I knew that given that low level, and I also knew that it was a mixture of samples, so that told me that I had a very low level of DNA to work with. And in trying to balance an RFLP gel, one wants the samples to be in fairly good balance so that the bands are not blown out on some samples and then very weak on others. And so as part of that balancing act, I had to go through what I had of the reference samples from the defendant, from Nicole Brown's, and from Ronald Goldman, and to evaluate how much of those extracts I would use to do this restriction analysis.
Did you also continue to prepare for your testimony on that day?
Yes, I believe there was also some time spent on that day doing that too.
How about the 26th? What sort of activities did you do with respect to this case on that date?
On the 26th, I actually got the tubes out. After having planned it the day before on the 25th, I got the tubes out on the 26th and checked them to see if there was enough sample on these. Because on some of these now I was running out of sample. For example, on the defendant's extract, I was getting low on the sample that we had from one of his swatches that had been extracted. And so I had a note here that I needed to check this previous reference extraction sample and see if there was enough of his extracted DNA to get a sufficient quantity to put on this RFLP gel.
How much actual hands-on time was involved in this on April 26th with respect to these samples? The ones he's talking about on the 26th.
We're not talking about console samples. He hasn't been for a while. So.
Are you're talking about as far as the reference samples and that?
The 26, all the samples.
Yes, that's the thrust of what I'm doing at that point. It's difficult to say just looking at these notes, but it's probably about a half a day, something like that.
Now, you're going to run these reference samples with the console mix, right?
That's right. In other words, they're going to be restricted at the same time, and they go through the whole process at that point together.
Okay. How about the 27th? What did you do that day?
There was preparation for testimony on the 27th, and also I attended a study group meeting for the California Association of Criminalists.
Further education?
Yes.
Okay, Friday, the 28th of April?
Yes, on the 28th of April, as I'm looking at my notes. In the interim, Renee Montgomery had run a slot blot analysis of some of these other samples, and this doesn't relate now to the center console. This relates to some of these other samples that were extracted at that time. And I went through with her the analysis and the quantitations on those samples. Dr. Blake came over that afternoon. We spent about 2 hours reviewing some autorads as well as the quantitations.
Okay, and then you met with me as well?
Yes, I met with you on April 28th, Friday also.
Now, these other samples, these are not the console samples, right?
That's correct.
But there are other samples in this case?
Yes.
There are other samples that could have tended to incriminate or exonerate Mr. Simpson?
Yes.
The summary notes for April reflect that you were working on one other case during that month. Does that sound right?
Yes.
And you worked about 108 hours on this case?
Yes.
Okay. In May, Monday, May 1st, what sort of work was done by you or Renee Montgomery with respect to this case?
On Monday, May 1st, Renee Montgomery reran some D1S80 samples.
Okay. Did you actually do any lab work on this case on May 1st?
No, I don't believe so.
Okay, May 2nd, what sort of work did you do on this case on May 2nd?
The one interjection I wanted to make when you asked me if I did any other lab results, keep in mind also that during this whole process, we are developing autorans, for example, and that is some time that's involved as far as developing and looking at them and deciding what kind of exposures we're going to use, and that's not reflected in any of these lab notes.
And there's no way to reconstruct that, is there?
Not simply, no, but it could be done, but it's not simple. But that's part of the process that I haven't addressed any of that's going on as we're doing all of this.
Okay, May 2nd, what kind of work did you do?
Again, at this point, I'm very much in the preparation mode. I put together, I worked on the what we call the photo log of keeping track of all the photographs that were taken.
May 3rd?
I have 6.5 hours of preparation for testimony.
May 4th?
I have 8 hours of preparation for testimony.
May 5th?
May 5th, in my notes, I indicate that I'm working with Renee Montgomery again on some of these additional samples.
In this case?
In this case, right.
May 6th, Saturday?
Yes, May 6th, Saturday, May 6th, which was Saturday, I again spent some time in preparing.
And May 7th, you came down to LA?
Yes, that was on Sunday. I came down to Los Angeles.
With Renee Montgomery?
Yes.
And how long did you stay in Los Angeles during that segment?
I was there from Sunday to Friday.
And what was going on that week?
That was the time at which Dr. Cotton was testifying, and I was monitoring her testimony.
Now, in your laboratory, you don't have underlings that actually do bench work for you, is that correct?
Well, that's correct. The only thing that we have as far as having other people working with us, I wouldn't use the term underlings, but they are people that are, for example, involved in the batch probing process.
Okay, so when did you return to Los Angeles?
It was on Sunday, May 14th.
And then what were you doing those weekdays that you were down here?
Well, on the following weekdays, 15th was a Monday, I was standing by for testimony. And my testimony actually began on Tuesday, May 16th and went through Friday, May 19th.
Okay, and there was a death in the family?
That was on May 19th in the evening.
And did that interrupt your testimony?
Yes, it did.
And when did you return to the Bay Area?
Well, I returned to the Bay Area on...
Well, Counsel, this part's all part of the court's recollection as to these events, these personal events of Mr. Simpson. Let's move on.
Sure. We're up to the end of May, the summary.
Yes.
You've listed 172.5 hours on this case, and you worked on no other cases during the month of May. Is that correct?
That's correct.
You completed your testimony on June 1st?
Well, that's not strictly true because I did testify later in June also, as I recall.
Or that's
But that segment, yes.
that segment of your testimony. And June 6th, you again returned to working the actual bench work on this case. Is that right?
Yes.
Okay. Now, would you describe what the next steps of the process entailed and why you had to wait so long to begin them, if you did? You've described everything up to this point and everything else that you did. What would the next steps in the process be, and why didn't you do them before?
Okay. The main steps in the process would be the restriction analysis, where you actually restrict the DNA, and that goes overnight. Then the next step is to purify and reconcentrate that DNA and then set it up on the actual electrophoresis, the analytical gel, and that goes over another night. Then the next day, one would do the southern blot, and then that would go overnight. And so there's a series of events that take place. Specifically, once the analytical gel is put into motion, and that would be like towards the end of one day, then there's a time period where you basically have to follow up at certain precise times. So for example, you could do the restriction and then put those samples aside and then do the electrophoresis at a later date. But once you start that electrophoresis, then you're tied into a 3-day period.
Well, is that just the way you do it, or is that the accepted protocol?
That, I believe that's pretty much standard protocol in most RFLP laboratories.
And having that need to, once you get started in the process, to do it continuously, did that affect your ability to do it during the month of May?
Well, certainly May was very much disrupted by the testimony and being in Los Angeles.
Okay, so on June 6th, then what did you do?
June 6th was back in the laboratory. I think there's some review going on at that point and discussion perhaps, and then it's actually June 7th when I set up the actual restriction.
And did that continue over to the 8th?
Yes, the restriction went overnight from June 7th to June 8th.
And then June 9th, you took the day off?
Yes, this was at a time when my children were out of school, and I took that day off.
And the weekend? You didn't work Saturday and Sunday?
Yes, I was ordered not to work that weekend, as I recall.
June 12th, you came back to work, and you've listed 2 hours of analysis. What did that entail?
That may have been some actual evaluation of autorads at that time. I don't have anything in my working notes about June 12th, so I believe that's probably some evaluation of autorads that were coming off.
All right, Mr. Harmon, 10 minutes.
Okay, we're just getting to the good part, Your Honor. Good. June 13th, you set up the analytical gel, which actually produced the autorads in this case. Is that right?
That's correct. In other words, that electrophoresis went overnight, June 13th.
Set up the southern blot on the 14th?
Yes, and that went overnight.
On the 15th, the membrane was ready for hybridization?
That's correct.
And when did you actually begin the hybridization process for that first probe?
That would have been June 15th.
And how long did that probe hybridize, or how long did you allow it to hybridize to produce a result?
That first probe was for locus D2S44, and that went 19 days until it was completed.
Why did it take so long?
The results were weak.
Okay, and then did you soon thereafter begin probing with a different probe?
Yes, the next probing was for locus D4S139.
And how long did that probe, was that allowed to hybridize for?
That went 12 days.
To the 19th?
Yes, I believe that's correct.
And then what probe did you begin with after that?
Then the next locus was D5S110, and that went 9 days to the 5th of August.
July 27th to August 5th?
Yes.
And then the fourth probe, which is, what's the designation of the fourth locus?
The locus is D10S28, and that went from, that was a 10-day exposure from August 26th to 9/5, September 5th.
And you actually have a fifth probe hybridizing as we speak, or hopefully?
We have a film sitting on a hybridized membrane as we speak.
Okay. I think I've covered. Thank you, Your Honor.
What's your guess as to when that one might be ready, this last one?
I was planning on looking at that tomorrow, is when I have it designated for the first film to be looked at. And then at that point, I make an evaluation as to how much longer the other film I don't know if this is new material, but the way we do it is we have a sandwich with the membrane in between two films. We look at the top film, which is called the non-DNA film, first, and that gives an idea of how it's developing. And then we make a decision at that point as to how long the final film will stay on there.
I just have one other question. Was Dr. Blake alerted every time you had a new autorad to give him an opportunity to come over and take pictures of it?
Yes, I kept Dr. Blake informed of that. The only one I don't think he's aware of is this this fourth one, but I provided that in discovery last week when I was down here on Thursday.
Mr. Scheck?
How long?
I'm sorry?
I'll try to be brief, but I'm mindful that
Yeah, we're going to
way
quit
over the limit.
We're going to quit at 6:30. Sorry. But we'll start at 8:30.
Well, I'll see if I can get right to the point.
Okay.
Mr. Sims, you knew going into this process that the longest part of it would be the period of time that the probes were hybridizing.
Yes.
You knew that that part of the process would take something on the order of 15 days, 16 days per probe, given the small amount of high molecular weight human DNA you had.
Well, I think it was in mid-May that I informed the court that I would need about 2 months.
Please answer my question.
Well, I'm trying to use that because
No.
you're giving me a
All right,
specific...
I'm giving you a very, I'll do it, make it easier for you. All right? By March 22nd, you had done the quantitations on the combination and knew that you had 72 nanograms of high molecular weight human DNA from 303, 304, and 305, right?
No, that's incorrect. I
All right.
didn't know as of March 22nd that that was human DNA.
All right. You're saying you knew you had 72 nanograms as of March 22nd, right?
Yes.
And then by April 4th, certainly, you knew that that was 72 nanograms of high molecular weight human DNA.
Yes.
But it would be a fair statement that certainly by March 22nd, you knew if you only had 72 nanograms of, at best, human DNA, that the RFLP tests here would be longest in terms of elapsed time from the moment that that probe began to hybridize, right?
Yes.
So you knew that would be the long part of the process that would drag it out.
Yes.
And if you wanted to get this done in a timely fashion before the end of the prosecution's case, you had to get the probe started right away, correct?
Objection, it's argument.
Go roll.
Well, I don't think I had any idea of how long the prosecution's case would be at that point in time.
Were you aware that when the court ordered that this combination could take place, that it was the understanding stated in open court that this process of RFLP testing should be done immediately, if not sooner, quote unquote?
I don't recall that exact language, no.
Nobody communicated to you that this court said that it was its understanding that the RFLP process for the combined stains should begin immediately, if not sooner?
Well, I know that the prosecution, which would be through Mr. Harmon, encouraged me to get this done as soon as I could, yes. But I don't recall the court ordering that.
In your discussions to get this done as soon as it could be, did you inform Mr. Harmon, as of March 22nd, when you knew you only had 72 nanograms of DNA, that the long part of this process would be the time that the probes began to hybridize?
Well, we've asked that question already, haven't we?
I just want to establish that Mr. Harmon knew.
I think we can assume Mr. Harmon knows how the process works.
I think he does, but I guess it's just for the purposes of the record. We all know he knows.
All right.
Now, in terms of this process, and I call your attention now to the questions that Mr. Harmon was asking you about the process that you prefer to do over 3 consecutive days involving the restriction analytical gel, and southern blot. Now, the restriction, all we're talking about is putting that DNA into a test tube with the restriction enzyme and cutting it up, right?
Yes.
And that, in terms of hands-on work, that takes, what, an hour?
Something like that, something along that
And then you
line.
just let it sit overnight?
Yes.
And he was asking you questions about how you prefer to do this over 3 consecutive days, but you didn't even do this over 3 consecutive days.
No, I think that misstates my testimony. What I said was that when you can do the restrictions separately and then set it aside. The 3 consecutive days are, you do one day where you do the analytical gel overnight, the next day which is the electrophoresis, then the next day is the southern blot overnight, and then there's a third day where you have to dismantle the southern blot. So that's the 3 days that you need in a row that I spoke of.
All right, so in terms of the restriction, it's 1 hour of hands-on work, and then you leave it overnight.
Well, I would object to that characterization of 1 hour of hands-on work because it's not just hands-on work. It's evaluating how much sample you have to put into this situation. In this particular case, it's making sure we have enough sample, that sort of thing.
Wait a second. I'm just you just told us a second ago to do the restriction, it took an hour of hands-on work. Just a second ago you said that.
Well, no, I agree with that being an hour of hands-on work, but I'm saying there's a lot more than hands-on work is my point.
Thank you. And then you let it sit overnight. The analytical gel, agreed, that's 2 hours of hands-on work, and then you let that go overnight.
No, I disagree.
All right. How many hours of hands-on work does it take you to put the DNA into the analytical gel? Because that's what's at issue here.
Well, no, I don't mean to be argumentative, but I think you have to remember that after you've restricted the DNA, you have to do an evaluation. You run a digest gel. You have to then...
Just give me an estimate of hours.
Well, that's about a day's work. About a day's work after you do the restriction to get it now going overnight on an analytical gel.
So you're saying it takes you a day to prepare the analytical gel? Come on.
Yes.
All right, 1 day for the analytical gel.
Counsel.
That's not very courteous.
No, it's not.
No. Very fond of Mr. Sims. Mean no disrespect to him. I'm only trying to get at the truth here. Mr. Sims, the southern blot. How long does it take you to prepare the southern blot? An hour and a half to 2 hours?
After the overnight electrophoresis, it's about 2 hours of work then to set up the southern blot.
All right, so you can do the restriction, the analytical gel, and the southern blot in what, 3 days?
We're now through that process, yes. There would be about 3 days, something like that.
Right. So it would take you, and part of that, it's not just 3 days of consecutive work. Part of that is you just have to let things go overnight.
That's correct.
All right. So before you get to the phase where there's this long elapsed time of letting the probe sit, you needed to do essentially work that would take 3 days to complete, right?
Something like that, yes. I'm sorry, 3 or 4. I'd like to say 3 or 4.
Let's try 3 or 4 days to complete.
Yes.
But in those 3 or 4 days, for example, if you had done the restriction, which you told us takes about an hour, and you let it sit overnight, could have done the restriction in an hour and had a conversation with Mr. Harmon about discovery or preparation or other things, right?
Well, that's not really true because a lot of these things are done at the end of the day. For example, the restriction is usually set up as the last thing that goes overnight. So it's not the sort of thing where I would do that the first thing in the morning and then later in the day talk to Mr. Harmon. That's not clear.
Let's
All right,
get,
Counsel,
I have
we're
one last question, Your Honor, that you may want to think about overnight, and this will be it.
All right.
From March 22nd, when you knew that you had 72 nanograms of DNA, and there would be a very extensive time period in the development of each probe, to the time that you went through what you described as the 3 or 4 day process that would be necessary to get those probes in motion, right? That's the time period, okay?
Okay.
So it's March 22nd, and you began that process of getting those probes, that 3 or 4 day preparation time to get the probes in motion. You began that on June 7th.
Yes, I believe that's the right day, is June.
And it's
June
your,
7th.
and it's your testimony that between March 22nd and June 7th, you couldn't find 3 days to get that in motion so that the RFLP test on the combined samples could be ready before the end of the prosecution's case. Is that right?
Well, it's the point that I did not find that. I came very close to doing this at the end of April, but I was not, I did not complete it at that time.
And you're not the only person that was doing that, just so the judge understands. In terms of these batch technicians, they're the ones that actually deal with the RFLP pros, technicians in your lab.
Yes.
And Renee Montgomery, she was working on this case too.
Yes.
And she was doing PCR tests.
Yes.
And she was helping with the RFLP tests.
That's not true.
She can't do any of these. Didn't she do slot blots and yield gels on some of these samples?
She did on some of the samples, but I don't believe she did any with regards to these particular samples, no.
All right,
She's
we'll
capable of it.
All right, we'll stand in
Yes.
recess until 8:30.
Your Honor, could I just give the court, it might be helpful for the court, you wanted references to Dr. Purdy's testimony on the stains.
Yes.
Mr. Clark has been kind enough to write them down. He's not sure of the volume numbers, but he has the dates of the testimony.
All right.
Your Honor, there were two witnesses that the defense, without telling me about it or asking anyone, they went directly to the witnesses, Kevin Schott and Robert Lee, and told them that they had to stay until tomorrow at noon. Their flight is scheduled for 8 o'clock in the morning. They have had a full opportunity to interview those witnesses. Their testimony is complete in the people's rebuttal case. If the defense seeks to have them subpoenaed, they may do so, and I don't see any cause for them to be required to stay longer than their flight would indicate, and I'm asking leave of the court.
Mr. Sims, tomorrow morning, 8:30. Thank you.
I'm asking leave of the court to let the witnesses go.
Mr. Scheck?
Your Honor, I feel like the court now. I've been here with you. I don't know what they're talking about.
Those witnesses were released from further testimony. There was no request to keep them.
Thank you.
All right, we'll be in recess 8:30.
Be very